All right. Mr. President, the witness is ready in the waiting room. I'll just wait to hear from you to bring him back in, and I'll go off camera.
Yes, let's see if there are any matters of housekeeping.
There's one matter from my side, Mr. President.
Yes, Mr. Hill.
There was a request yesterday from Mr. Cowley for metadata in relation to 3 documents. That was, if you like, put reciprocally because we had asked for metadata in relation to 1 document.
Yes.
We have provided the metadata in relation to 3 documents. Sorry, I should say we provided the metadata that we have in relation to 2 documents. The other one is only in hard copy, so there is no metadata. And we've provided that a little while ago to both ICSID, so it should get to the tribunal, and also to Mr. Cowley. So that's just the housekeeping. So we obviously await his version as soon as possible. One point that emerges.
Excuse me, just before we get into that, I'm very ignorant. I'm not quite sure what metadata is. I imagine it's the data that tells you the genesis of the electronic document.
Exactly. It tells you the information, in particular, when it was created or worked.
Yes, thanks. Yes.
And one point just arises out of that, which is that one of the we've asked for the documents to be uploaded in native form onto the system so that in cross-examination or submission, anyone who wants to can ask FTI to actually pull up the native form and demonstrate the metadata. We assume that would be uncontentious, but Mr. Cowley has put in an objection. Now, it may well be, and I completely understand, he simply hasn't had time to digest or think, but I would like to put, or perhaps put, one of the documents in its native form to Mr. Marshall while he's in the witness stand. So if Mr. Cowley could confirm his consent in the course of today, that would be helpful.
Hi, Mr. Cowley.
Yes.
Have you any comments to make about that?
At 6:46, we received an email with a letter, and the letter apparently refers, I won't challenge what Mr. Hill says it says, or what it contains. We haven't even opened it. We have no idea what it really contains, and I can't possibly comment on it. But I can say this. In 2020, but at the time, what was the date of our request?
Late 2019, maybe?
At the latest, or early last year, and perhaps before, there were a number of discovery disputes put to the tribunal. We requested metadata for these documents. We made the request directly of the respondent. They refused. We had to put the dispute to the tribunal, and the tribunal made no ruling. They stood by their dispute. They said absolutely not. It wasn't appropriate, wasn't relevant, wasn't reasonable to request them to get it, and they weren't going to provide it. The tribunal specifically made the decision that it was not going to make a decision, and instead it was going to leave to cross-examination our exploration of that fact. So having come to the hearings, expressly refusing to give us any notice of metadata, refusing to let us look at it, test it, analyze it, Mr. Marshall has tried to get access to this and prepare for the hearings, and they refused. And then now to say that they believe it's uncontested, that they can just throw it at us without him reviewing it and then question him on it, I think is highly inappropriate. It was a request we made for them to send it to us. They say they did. We'll look at it. We'll talk to them. If they want to make a request to submit it at some time to the tribunal, we'll talk to them about that because we may have a similar request for our own metadata on documents that they challenge. But this should be a subject of discussion between the parties and not ambush for Mr. Marshall at these hearings.
My understanding of the request that's been made to you is it's a request in relation to the form in which one document is put in cross-examination to your witness. What I suggest is we're going to have a half-an-hour break after an hour and 3/4. In that break, that'll give you a chance to open the envelope, see what's in it, and decide on your response to it. Is that fair enough?
But Mr. Marshall will not, as I understand it. And the only reason they don't have our metadata yet is because we're not permitted to speak with Mr. Marshall about our evidence. Our evidence includes the document that they want in metadata form. So no one from our firm has sat down and worked with Mr. Marshall to obtain it in native format yet. We were expressly told not to talk to him about such records. We're waiting for the opportunity to do so, and we'll provide it to them.
Yes.
But he'll
Just
never have
pause
a
it-
chance to
Just
review.
pausing there, I think if we have a word with Mr. Hill, he certainly will make no objection to your discussing that matter with
Yes.
Mr. Marshall.
Yes, 2 points. If it were a real point, we certainly wouldn't object to that limited discussion. But we don't actually understand that point because he has the document on email, which means he has the document in its native form. There's nothing to discuss with Mr. Marshall.
Yes, I think, Mr. Cowley, I think there may be some cross wires at the moment. What is being requested is, as I understand it, a very simple request in relation to one document. There'll be no objection to your discussing that request with Mr. Marshall in the 30-minute break that we'll be having in just under an hour and 3/4 now. So let's leave it till then. If you have further problems, we'll look at them after the break.
No other housekeeping from me, Mr. President.
Right? Anything else you wish to raise, Mr. Cowley?
No, Your Honor.
No? In that case, let us invite Mr. Marshall to return.
Okay, bringing in the witness right now.
Mr. Marshall, good morning. We were looking yesterday at R040. Can we call that back up? You'll recall that that was Mr. Eminer's evaluation in May 2012. And you recall that yesterday you made an allegation that this was a fabricated document, fabricated for this arbitration. Yes, you recall that?
I don't believe it was written on May 8th, 2012. Definitely not.
Well, in light of what you were saying in your evidence, we have been back to that document and provided your lawyers and indeed the tribunal with electronic information about document establishing that it was in existence in May 2012. Do you have any basis for your allegation that this was a document not in existence in May 2012?
Mr. President, unfortunately, I have to lodge an objection to a representation on the record that we just explored in our housekeeping discussion. No one has seen this document. That representation cannot possibly be contested. And to spring it at Mr. Marshall as if it's truth established with us is simply inappropriate.
Well, I'm in the tribunal's hands. I see this question as an appropriate one. I'm asking if he has any basis for his allegation that this is a fabricated document.
I don't believe Evode was in that position at that time. He had been a tag manager. He had come over, I don't know, sometime after being a tag manager to work in the GMD office. He never contacted us. It's not the procedure in Rwanda for anybody to be preparing documents based on somebody else's evaluation. It's always very much hands-on. They always come and talk to you. So I don't believe it.
During the course of yesterday's cross-examination, you also gave evidence that the Nyatabindi mine had been closed since the Stark time, and you said maybe before Stark. Now, I'm just going to ask you to go to bundle C035.
Well, can we go back to point 4 on this document, or are you moving away from this document now?
We're happy to go back to point. Yes, if you want to make a point about point 4, I'm happy to, because that is the assessment of Dr. Michael Biriabarema, which is referred to in the May 2012 document. Is there something you wanted to say about it?
No, that's section 0.4. I'm talking about section 4. The management is in section 5.
Yes, that's the point you made yesterday, and I asked you, you'll recall, whether you were aware of any letter that actually did have the correct date from a chairman of NRD of 14th of October 2012. You recall that?
Do you recall my answer was that I don't know because I don't have the documents in front of me. I would have to look to see what that was.
But you are not aware of any document.
I'm aware of lots of documents, but
No doubt if you're
one which is dated October 14th, 2012, I can't say which one it would have been, and whether it's the chairman's letter to Reina, I can't be sure without looking at the documents. My point was different. My point was that's a date after he claims to have written this report.
And that's why I asked you if you were aware of any document with the correct date of 14th of October 2012. No doubt if there is one, your attorney can put it to you on redirect. Now, I was asking you about the Nyota-Bindi mine. And during the course of yesterday's cross-examination, as I said, you gave evidence that this mine had been closed since before Stark's time, or maybe even before Stark, you said. And I'm going to ask FTI to call up bundle C035 and go to page 11. This was the November 2010 application, which we've already looked at before. And page 11 says that near the top, at Nyota-Bindi, 3 massive dam walls were raised in sequence along the Nyota-Bindi River to retain suspended material that is introduced through mining activities. And perhaps just to be clear on what we're talking about, if FTI could go one page back. So it's environmental mitigation, 2011 to 2015. So back on the page we were on. At Nyota-Bindi, 3 massive dam walls were raised in sequence along the Nyota-Bindi River to retain suspended material that is introduced through mining activities. Further upstream, Nyota-Bindi 1 to 4. So just pausing there, it's quite clear, isn't it? That in the period being dealt with, there are continuing mining activities, as a result of which environmental action is proposed. Yes?
No. But my understanding at that time, and certainly during the period we were there, we were doing a lot of environmental work. This is what I referred to yesterday as where the Belgians had done a lot of what they call ground sluice mining, which means they literally turn on fire hoses and wash down the hillside. And there was no mining going on there, specifically because it was too complicated to try and dam up the silt that would have come down if we were continuing that approach. It's a large site, 3 kilometers wide. To my knowledge, there may be some illegals. I mean, this is not a small area, which were stirring up the area and thereby creating silt. Our work there was remedial. We were at this time before 2010 and during our time, this is why we brought over the team of environmental management from Olomouc University. And that team was specifically focused on environmental works. There was no mining going on.
Just to be clear, this document is an NRD document. It's talking about dam walls being raised to retain suspended material that is introduced through mining activities. So it's dealing with continuing mining activities, isn't it?
You need to go visit. It's illegal mining activities, which is increasing the suspension of silt, not legal mining activities.
Can you go to page 83 of this document?
And it would be irresponsible to do it.
Page 83 of this document, we have production on the Nemba site there. And if you go on to page 85, still in production, we have production aggregated for Rutsiro, Sabaya, Kabaya, Nyota-Bindi, and Mara. So Nyota-Bindi figures are included in the aggregate production figures from January 2010, aren't they?
Yeah, but you're confusing terms. Nyota-Bindi is reference to an area. The whole area is maybe, I don't know, 15 kilometers by 10 kilometers. There's some particularly sensitive areas where the ground sluicing is going on, was something going on in some other part of it, which was not going into the Sabea River catchment, possibly. Not during my time, but possibly before. But certainly not contributing. This is the most, for NRD, this was the most sensitive area because everybody knew that the Belgians had left a mess, not just the Belgians, the Belgian and the national mining industry, when it was owned by the state, continued it. Everybody knows it's a very sensitive issue and very sensitive place.
Well, I'd suggest to you that it's quite clear that there was continuing mining on Nyota-Bindi, and that Minister Kamanzi's letter, to which you gave an intemperate response, was a fair one, and that's reflected by your subsequent, more moderate response to the mayor that we looked at yesterday.
No, I think you're mistaken. The mayor went immediately in front of a crowd of 300 people, riled them up, caused us a great deal of worry whether we were going to be harmed or killed. It was a political rally. He was not talking about Nyota-Bindi. He was not talking about Route Zero, which is where he claimed he was. It was Nyota-Bindi, which is an entirely different place. And he went so far as to threaten to take away all of our concessions if we didn't clean up the Belgian works within, I forget what he said, a month or 2 months.
Well, we've looked at exactly what he said in his letter, and we can look at a fair characterization in his letter. Now I'm going to move on. We were dealing yesterday evening with the Benzingi story in August 2012. Can we go to bundle R231? And this is your letter complaining on the 3rd of August to the RDB. And can you can FTI go on in this letter, please? A bit more, keep going. Sorry, but my apologies, one back, FTI, please. Thank you. So you're complaining about RDB being taken in by Mr. Benzingi, and you say, fourth paragraph, I'm sorry to tell you this, but when Ben Benzingi has, what Ben Benzingi has argued to you and your staff is breathtaking in its absurdity. It's astounding that your staff believes them, or indeed they should think it's their job to make determinations on issues where the Rwanda courts have already made their decision, the facts of these and so on. So you're going in quite hard on this letter, but not suggesting for a moment that there's been physical threats to the RDB staff, which was a suggestion you made in your testimony yesterday.
No, not to the staff, to the registrar herself. That was what she told us was the reason she made the change. I'm not sure you understand how—
but you're dealing, just to interrupt, I'm sorry to interrupt, but just to be clear, you're dealing— I'm going to take you a stage at a time. You can give your answer in a minute. You are dealing with in this letter, with your complaint at the RDB staff for making this change. So if you had a complaint that it was the registrar who was responsible because she was threatened, you would have said so in this letter, wouldn't you?
We didn't know how it was decided at this time. What we knew was we were owners of a company, we were management of a company, we have a group of foreign investors, and now it's all gone, all of it.
That's now a different version of events from your version of events yesterday.
I'm sorry, can I finish, please?
Yes, please finish.
Please don't keep interrupting me. It's very—
well, but please try and keep your answers concise then.
Thank you. The reason that this was such an emotional moment for us was we had done, as far as we knew, everything right. We had checked with the US Embassy on everything. We had done every step according to Rwandan law. And all of a sudden we were informed, not by the ministry, not by the registry, but by Ben Benzingi, who shows up in our office and says, I own your company. This was a very frightening moment for us.
Now, I let you run on, but that was not in fact an answer to my question. My question was, this is a different version of events from your version yesterday. Your version yesterday was that you did know on your case that some member of staff had been threatened, but you were choosing not to mention it in your letter to the RDB. And your version of events today is that you didn't know. Which is true?
No, you're intentionally mixing up the timeline and for purposes of not getting the facts out. This letter was written before we knew how Ben Benzingi had persuaded them, or threatened them in this case, to remove us from the commercial registrar certificate. The only identification, so far as I know, as to who owns property, a company property, is that registrar. At the time that I wrote this letter, we didn't know how that had come about. Ben Benzingi had showed up in our office and said, "You guys go home. I now own everything."
Well, Mr. Marshall,
this was a very frightening prospect for us.
Mr. Marshall,
We had a series of meetings, and in those series of meetings, we came to find out that the registrar had been threatened by Ben Benzingi.
Mr. Marshall, I suggest that is a different version of events from yesterday's, and we can all go and look at yesterday's transcript to confirm that. Now, I'm going to move on. Only 3 days after this letter, on the 3rd of August, the RDB responded to you with a letter that we have at bundle C146. And this is a letter from the Rwanda Development Board. And they say references made to our previous discussions regarding the status of natural resources development. Following our recent meeting with you and your lawyer, we've received documentation. So I should say this is addressed to Mr. Benzingi, not to you, from the majority shareholder, Natural Resources Holdings. This documentation shows the legal representative and sole managing director of the holding company to be Mr. Roderick Marshall. In this capacity, he is mandated to secure the interests of the holding company in the Rwandan subsidiary. He then explains about forwarded a written complaint, here we have attached, that you've transferred a significant amount of company assets. Please note, as managing director, you have fiduciary duties towards the company and therefore may not embark on any actions that are either to the detriment of the company or against the express interests or consent of the shareholders. Failure to respect these duties may result in civil liabilities. Due to these complaints from the authorized representative of the holding company, protesting that the interests of the majority shareholder are being jeopardized, we hereby inform you that the position of managing director has been suspended and no person shall hold this position in the company until we have investigated these complaints to ensure that the interests of all the shareholders in NRD Rwanda are secure. So just pausing there, the NRDB have been faced with, at this stage, competing positions. And in the light of that, they are warning Mr. Benzingi about his fiduciary duties and suspending the position of managing director until further investigation is taken. Do you recall that?
I recall the letter, and I still don't understand what it really means.
Well, it's a fair and reasonable position for them to take, isn't it?
Well, I understand, but maybe you can explain to me what it means.
Well, I'll go on. Now go to bundle R114.
But what does this letter mean? You know, you can't, somebody has to be running the company.
Now go to bundle R114.
What we understood the letter to mean was that they were saying, we're embarrassed by what has happened, so we're going to suspend Mr. Benzingi.
Yes, they were suspending him and suspending the position of managing director altogether for what you'll see as a short time while they investigate. Then you go to bundle R114. So the last letter we looked at was the 6th of August. And here we have a letter the next day, 7th of August, from the RDB, so 24 hours later. We refer to your letter to the Rwanda Development Board, in which you question the Registrar General's decision to rectify the registration of Managing Director from Roderick Marshall to Ben Benzingi. You make representations about RDB's role and or intention in this matter, and I would like to emphasize that RDB is a facilitator of shareholders' wishes and cannot appoint or remove a managing director, as that is within the remit of shareholders. I have nonetheless raised the issue in your letter to the Registrar General, who is empowered by law to oversee company registration matters. I take note that she has written to you and Mr. Benzingi, copies of which are attached here too, and decided to suspend any holder of that title until you furnish her with information currently absent in your file. I'm therefore confident that the existing issues will be resolved. Please do cooperate with the Registrar General until it is resolved. And that is, again, a fair position for the RDB to take, isn't it? Given the absence of material in your file and given that there are competing claims from people purporting to be shareholders?
Well, that's exactly the point. There was no absence of material. In fact, they had a stack of materials, which at the time they claimed were missing. They subsequently found those materials and then reappointed me. But what was interesting, and I don't think you're recognizing here, the first letter from the RDB, the registrar's office is under the auspices of the RDB, and that's why you saw in the other letter, RDB Office of the Registrar as the heading. There was some confusion at this time whether being Ben Benzingi seemed to believe that being the managing director meant being the owner of the company, not that the owners of the company appoint a managing director. And so this was part of the ongoing confusion. It's not that there was Ben Benzingi, who was considered a majority shareholder. He interpreted it as being ownership. And that's why it went back and forth and became very heated, because we had been dispossessed without explanation, without notice.
I'm asking you to focus on the position of the RDB faced with these competing claims and the position they've taken so far, which is they're suspending the position of managing director pending investigation, is a fair one to take, isn't it?
And what I'm trying to explain to you is what the meaning of those words are. There was no lack of documentation. There was no competing claim by Ben Benzingi. Ben Benzingi did not have ownership, in our opinion. He claimed to have 15% ownership. In either case, it didn't give him the right to appoint himself as managing director.
Well, now let's go to bundle C70, C070.
Not only managing director, he claimed to own 100% of the company.
Now we go to C070. Same day, so they've obviously continuing investigations, and on the same day, the RDB write to the Mayor of Bugesera, and they say, we have recently received legal and authenticated documentation showing the holding company NRD Limited is wholly owned by Spalena, an American company incorporated in Delaware. In his capacity as therefore a sole shareholder of the holding company, he submitted copies of a notarized resolution appointing an acting managing director for the company. The appointed managing director is Roderick Marshall. Please find attached all the relevant documentation. In this regard, we therefore request you facilitate the transfer of the company property, including keys to the premises of the company, to Mr. Roderick Marshall. So within 5 days of your initial complaint, RDB had responded to your representations, and based on the information you provided, they had taken steps to ensure company and property and access was returned to you, correct?
Partly correct. The documentation says that we were not, the assets and our bank accounts were not returned so quickly, but they had made a written decision within 5 days, yes.
You have a complaint about actions that you suggest Mr. Benzingi took in the few days after the registration information was changed and before the position was restored, but you accept, don't you, that those were the actions of Mr. Benzingi and not of the RDB or of any state body, correct?
Without the enablement of the body, he could not have done those things.
Can we go to bundle C048? This is a letter you wrote after these events, copied to a number of people. Can we just look at the last page of the letter? This is on the 10th of August. You say, it is clear to me and our investors that the RDB staff was completely misled by the threats and illegal actions of this man, Ben Benzingi. It appears he has taken advantage of RDB's goodwill and exploited a gap in Rwanda's laws. This is not a civil matter, it's a criminal matter. So your view at the time, on the 10th of August, was that the RDB had been misled by Mr. Benzingi, yes?
I couldn't perform my own investigation. It was some combination. Was I giving them an out? I was certainly trying to.
You weren't suggesting at the time the proposition you advanced in your testimony yesterday that there'd been some registrar or member of staff who had been physically threatened, correct?
Well, you just ask her, call her up. She's not going to deny it. This was a terrible time.
Nor are you suggesting that RDB were in any way collusive in Mr. Benzingi's actions or behaving corruptly or anything like that.
Whatever actions Ben Benzingi took to get them to pretend that they had lost all our files, which were subsequently all rediscovered. Yes, somebody or some people were participating in this scam, and they were.
Sorry, I interrupted. You finish.
They were certainly surprised that we objected to losing all of our property.
Could you go to the claimant's counter memorial on preliminary objections at paragraph 35? So paragraph 35, sorry not to give you a page number. Thank you. And you deal here with this episode, and you say there in your memorial that Ben Benzingi's second sentence was inexplicably and falsely credited by RDB as the managing director of NRD when you explain about your complaints about what Mr. Benzingi did. And you say, in essence, respondent by and through the RDB used Benzingi as a pawn to make clear to claimants that they could be stripped of their entire investment on a whim. Now, that is not at all what you thought at the time was happening.
That's absolutely what I thought at the time.
Because we've seen your letters where you accepted at the time that RDB had been misled by Mr. Benzingi.
Oh,
and we've
yeah.
also seen that RDB, as soon as you made the complaint, investigated and corrected matters. Yes?
Oh, Mr. Benzingi, in collusion with some people at the RDB, did these things. Who they were, I don't know. All our files, as I say, went missing as a way of enabling the registrar to have some kind of face saving. I used the phrase that somebody had been misled. That was a courtesy, an indulgence on my part. These were criminal acts. We had been dispossessed. We were not sure that we were going to get it back. I had a very difficult and very unpleasant conversation with the head of the RDB, Claire Akamanzi, who was explaining to me why I was no longer the owner of the company. That's not unintentional. That's very intentional. We wouldn't have had that ongoing dispute if that hadn't been the case.
Now, again, you're introducing allegations that have never been said before in any witness statement of yours or even in your memorial, and you are making it up as you go along, aren't you, Mr. Marshall?
No. If it was 1,000 pages, maybe you would get more of this kind of information. But for you to dismiss it is very unfair.
No, it's right to say, isn't it, that Mr. Benzingi subsequently lodged an appeal against the RDB decision to suspend him. You recall that?
No, I didn't know that.
And he subsequently, well, don't worry, because I'm going to try and press on. He subsequently launched arbitration proceedings in October of that year, so that's 2012, to vindicate what he saw as his rights. You recall that? Yes?
Yes.
Now, I'm going to come back to that arbitration. I'm first going to try to keep it broadly chronological so we can all follow. I'm first going to come to something else that happened in the second half of 2012. And you have a complaint in this period about what you say are military arrests and seizures of minerals in Sabea. Now, can you go to Mr. Neon Sarber's second witness statement, and where he has an annex? And can I ask you to be showing the annex to his second witness statement?
Can you say that name one more time?
Yes, Neon Sarber,
Yes.
N-I-Y-O-N, and his second witness statement. Mr. Neon Sarber, of course, is the man who was working in the Pact ITRI program. And I just want to look at the annex to this as an annexure 1 at the end of the statement. It's on the 7th page. So this is dealing with a complaint, the complaint by you, that you see in the summary in the second row. NRD had informed ITSCI the Rwandan military had allegedly come to the site, seized minerals and arrested 5 employees. Subsequent ITSCI investigations reveal that NRD had been suspended by the government for environmental reasons. Reports of the seizure of minerals by the military could not be confirmed. And then the ITSCI report has action to be taken. GMD was informed, joint field visit to be done next month. The site was visited on 13th March 2013. The site manager, Mr. Gaspard, said that the police commander came on site and seized around 750 kilos of wolfram at Bukyan Gender's house in Buaza Center, Marundi sector. The police was alerted by a neighbor of Bukyan Gender, contacted the police commander in Rutsiro district, said that the minerals were seized, but no people arrested. The report was done and it's ready to be sent to Gihango court. In the meantime, the mineral is still kept at Rutsiro police station. During the visit, it was observed that lots of illegal miners are on the site. The company manager tries to resolve this. I'm just going over the page. Resolve the situation, but face difficulty. During the day of the visit, the ITSCI technician attended a meeting organised by the district environmental officer, Mr. Olivier Kabanda Vanzi, the NRD representative, during which it was agreed that illegal miners form a cooperative. However, ITSCI reminded the site was still suspended. And then during August 16, NRD suspended by GMD and no tags and logbooks, no further action possible. So that gives a different complexion, doesn't it, to your story of military arrests and seizures?
No, those are unrelated. This is a different description of a different series of events.
Now, staying in the second half of 2012, I'm going to come back to the license.
Can I explain where your error is, or you want to move on?
I may be coming back to that, so you may get another chance. Or if not, it can be picked up and redirect. But I really need to try and move on because I want to try and.
But you can't throw out. I'm sorry, but I thought
I'm asking you.
The truth.
Happy to take your evidence.
The truth is being able to respond to concrete allegations. You say, if you go back one page, I can explain to you why the military arrest was in a completely different location than the area described here.
Well, you've just said that. I am going to move on. Could we now go to bundle C045? I'm going to come back to the license issue. And here we have, we're now at, so we're in the second half of 2012. So yes, they're in September, sorry, of 2012.
Sorry, what's the date? September what?
13th of September 2012.
Okay.
And it's a letter from Mr. Kamanzi, and he says, reference is made to my letter dated 20th of February 2012, extending the previous license of Natural Resources Development NRD for 3 months, which expired in May 2012, in view of the ongoing work on reorganizing the mining sector, which will have a bearing on the new contracts that will be negotiated, as has been communicated to all the existing concession holders. I have the pleasure to extend your license up to October 2012 to allow for the ongoing work to be completed.
This struck us as particularly odd because, as you point out, the letter is dated September 13th, and it's a license up to October 2012. So for roughly 2 weeks extension, and we couldn't understand why he would send that when there was no communications between us at that point. I mean, it's very nice, very pleasant of him to send 2-week extension, but it was meaningless to us.
But you say meaningless. By this stage, your previous extension had expired.
No,
You're
something
operating without a
something
license.
political. All other concession holders were in process negotiating long-term concession licenses. We were the only one at this point who was not actively in negotiations because they wouldn't, and we don't know why to this day. And we got this letter in the middle of that saying, okay, you're extended for 2 weeks.
Now, I'd like you just to focus, rather than making speeches, Mr. Marshall, I want you to answer my
Same
questions.
information, I hope.
Just please focus on my questions and answer them. The reason you needed to have a letter of this kind is that your last license extension had expired, and for you not to be an unlicensed operator, you needed to be given a license extension, correct?
Our license was an ongoing, for all concession holders. We were all treated the same in this respect, that all of them were deemed to be continuing licenses.
No, it's not a question of deemed to be continuing. We've seen
there are specific
the
rights.
correspondence.
There are specific rights and responsibilities of a concession holder. At all times, we were treated to have those rights and responsibilities of concession holder. It never changed.
We've seen the correspondence where there was a previous license extension. You needed to be a licensed operator, and this license was granted. Here we have another license extension granted until October 2012, yes?
Yes, so a 2-week extension.
And it's making sure you are a licensed operator over until October 2012. Otherwise, you would not be a licensed operator.
Up to October 2012.
And there's nothing in here promising that a long-term license is going to result, is there?
No. All concession holders at this time in 2012 were in active negotiations for the terms and conditions of that long-term license. We never had that opportunity.
And so I think you're agreeing with me. There's nothing in this letter indicating that a long-term license is going to result, is there?
There's nothing which contradicts it. And there are lots of other forms of communication which you've decided to take from our office, your client has decided to take from our offices.
Well, you keep saying that, and just I should make clear that's not accepted that Rwanda has removed anything from your offices, and it's also not accepted that you do not have access to vast amounts of material. Just want to make that clear. Now, by this stage, you had not made any application for a long-term license, had you?
Yes, we had.
Subject to your point about your argument that the November 2010 application counted.
That was deemed an application for a long-term license, according to the staff at the Licensing and Supervision Division.
Now let's keep that page on the screen if we can and look at paragraph 34 of your witness statement. You say at paragraph 34, on September 13th, 2012, Minister Kamanzi wrote to NRD granting another extension to the NRD mining licenses, stating that the long-term contracts will be negotiated. Could you just show me where in the letter from Mr. Kamanzi he says that the long-term contracts will be negotiated?
It says new contracts, referring to long-term contracts that will be negotiated.
Why do you say that's referring to long-term contracts?
Because everybody was being treated the same.
You had no basis for thinking long-term contracts were being negotiated because all you had applied for was a 5-year contract by this time.
It's not true. No.
Now, that license extension has expired, as we see here, in October 2012. And it's right to say that at no point after that did you have any actual extensions to your license granted by the minister or anyone, correct?
I don't recall.
Now, we're still in September 2012. Mr. Sindagaya left in September 2012, didn't he?
He was fired after a criminal investigation in August or September.
Well, the accurate position is that he left in circumstances where he had not been paid for some time and had had enough, correct?
That is entirely inaccurate.
And at that point, you made a number of serious but unfounded allegations against Mr. Sindagaya, didn't you?
No, we had a detailed criminal investigation. The police came, they interviewed him, they interviewed others. They agreed with what had happened, and money was missing. In fact,
It's bundle C182. This is a purported letter from you to the police in September 2012. Now, you never actually sent this letter, did you?
I don't know. Are you claiming that it was not received?
Yes, it was not received because it was not sent.
I would have to go back and check whatever logs we have. Can you show me the signature page?
Yes, it's the last page of the letter. You'll see it's signed, although there's no company stamp.
Yeah, no, it would be very unusual if I hadn't. You would have to check with Susanna. I would guess that I had. There's no reason for us not to. They came. We had several meetings with them explaining what had happened. So I can't imagine. I don't know what the content of the letter was. It may have been, if you believe that it had not been sent, there may be a different version, which was sent. But would it be very unusual for me to sign a document and not have sent it?
Can we go to Mr. Sindagaya's second witness statement, paragraph 15?
I believe the statement in the document to be true, by the way.
Mr. Sindagaya's second witness statement, paragraph 15. That deals, Mr. Sindagaya gives evidence on this document. He says in paragraph 15, I've never seen this document before. All the allegations made in it against me are false. I also do not believe this letter was ever sent to the police for the following reasons. The letter is addressed Kigali Chief Police Supervisor at the letter, and then he goes on at 15.1, if FDI could pull that up. The letter is addressed Kigali Chief Police Supervisor at Kigali Police. I do not believe such a position exists, or that there is such a thing as Kigali Police. Each district has its own police station, and that is where complaints are made. Whenever we had complaints to make to the police, we would submit them to either the Remera or Kimihura police station in Kigali, which were the nearest to the NRD offices. When complaint documents are presented at the police station, they are stamped, stating the date of reception and the name of the receiving officer, and a copy provided to the person making the complaint. The September 2012 letter is not stamped and therefore does not appear to have been presented to any police station at all. I believe Mr. Marshall was familiar with this process of submitting complaints to the police, as I understood that he had filed complaints against former employees of NRD, including William Kwam, Julius Cabrera, and Valerie Mpongo. If this September 2012 letter had been submitted to the police, I would have been summoned to a police station and interviewed about the allegations, which on the face of the letter are very serious. This never happened, nor did Mr. Marshall ever raise his allegations of me in person. Instead, I had only attended the Remera police station the previous month to give a witness testimony concerning the wrongful actions of Mr. Mpongo, which I discuss in further detail below. In fact, during my employment of NRD, my only involvement with the police was as a whistleblower in 2 cases that led to the firing of employees and police investigations. And contrary to what you just said in an earlier answer, Mr. Sindagaya wasn't interviewed by the police, was he?
I'm sure he was interviewed by the police. I can't imagine that we would have presented the letter to him prior to our filing it with the police, and whether we had addressed it to the right location. We delivered everything by hand. There is no mail service. So you go there, ordinarily there would have been a stamp, and there is not a stamp on the front of this. So that would not be, sorry, let me back up. when you're delivering a letter to any government ministry, you deliver it a copy and you get them to stamp your copy as evidence that you've delivered that letter. The version, the copy of the letter you've provided to me doesn't have any of those stamps on it. So my guess is that it's a different version that would have had the record of it being distributed. It certainly never would have been shown to Amy before it was placed there. The police had an ongoing investigation because they came more than once to see what Amy had been doing, both in the books and with regard to self-dealing by renting company bulldozers and other equipment for his own personal gain.
Now, you can see what you're doing here, which is conflating different stories. Firstly, you did not send this letter and Mr. Sindagaya was not interviewed by the police. That's right, isn't it?
I can't imagine, I wasn't involved with an interview between him and the police, so I can't say for sure. 100% this was delivered. It's the basis on which we fired him. We did an investigation. We found out that he had been cooking the books. We found out that he'd been self-dealing, and with certainty he was fired.
Secondly,
found the police filing, whether it's this copy or a different copy, I can't say.
Secondly, you're conflating two different stories in that you did have complaints about a bulldozer and money were to be made from the hire of it, but Mr. Sindagaya had actually been the whistleblower on that complaint, and you and Mr. Sindagaya had made a complaint to the police about the actions of the other employee, and that's correct.
Valerie Mapongo was doing it with Amy.
Well, Mr. Sindagaya had been the whistleblower and assisting you in the complaint to the police about Mr. Mpongo. That's correct, isn't it?
Not that I know of. Certainly never shared to me that he was, in effect, fingering his partner.
And you and he had jointly made a complaint to the police about the hire of the bulldozer, correct?
He was the one who was leasing it. I personally went to find where the bulldozer was because it was missing, and it was at a woman's house, and it had been leased to her by Amy, the bookkeeper.
What you have done in this complaint is use Mr. Sindagaya's assistance in explaining the story about the other employee and reworked it into a false complaint against Mr. Sindagaya, haven't you?
No, it's not true.
And you've also in this document made a number of other serious false allegations. And I don't have time to pick them all up. I'm just going to pick up some. Can we go to the penultimate page?
If I can suggest, you should speak to our CFO, who was handling the matter, including the internal investigation at that time.
I'm going to pick up some of these complaints in this document. Can we go to the second to last page of the letter?
Which document number?
It's still in the letter. Sorry, I'm still in C182.
Thank you.
And I go to the second to last page. It's not numbered, or at least my version isn't. Thank you. So these are other complaints you make to the police. In item 12, you say his role in the situation regarding illegal Actros sale and his relationship to Mr. Kayumba, which resulted in 150 million Rwandan franc loss. Can we keep that up and also have Mr. Sindagaya's second witness statement up at paragraph 23.12? Now, Mr. Sindagaya deals with all your allegations. I'm only picking out some of them. 23.12. Mr. Marshall states he wants an explanation as to my role in the situation regarding illegal Actros sale in the relationship to Mr. Kayumba, which resulted in 150 million Rwandan franc loss. The sale of the Actros truck was arranged by Mr. Julius Cabrera, NRD's CFO, who sold the truck at a substantial undervalue. He sold it at its book, i.e. depreciation value, rather than at market value, which was substantially higher. I was not involved in the transaction. In fact, I reported, FTI, could you go over? I reported this irregularity to Mr. Marshall, and I'm now shocked to see him trying to blame me for this. And that's correct, isn't it?
No.
Can we go on to...
I would refer you to Zuzana Marushkevich, who was handling these transactions and the internal investigation. I don't have direct the moment direct memory of this.
Can we go on in to item 15? Your next complaint is his role in the motorcycles business, resulting in 15 million loss to NRD. And then we see Mr. Sindagaya's response. Mr. Marshall asked for an explanation as to my role in the motorcycles business, resulting in 15 million loss to NRD. I assume this is a reference to the fact that each site supervisor had a motorcycle purchased them so they could travel to remote areas. These transactions were executed before I joined NRD, and that's correct, isn't it?
Just one moment, please. Yeah, I don't recollect this issue, so you have to refer you to Zuzana Marushkevichova.
And then item 18, his role in the situation regarding accident of workers. Let's look at what Mr. Sindagaya says about that. Mr. Marshall states he seeks an explanation as to my role in the situation regarding accident of workers. There were some accidents in the mines during my time at NRD, and each site manager will be responsible for responding in the appropriate way to these. As an accountant, I had no involvement in this. It was not my area of responsibility. And that's correct, isn't it?
I don't have a recollection of this. I will refer you to Zuzana Marushkevichova, the CFO, who was handling the internal investigation.
But if you had sent this letter to the police, which I don't accept, you wouldn't have any basis, would you, for making a complaint to the police, for example, about Mr. Sindagaya's role in the situation regarding accidents of workers?
I don't recall what the issue is or what it was referring to when it says regarding accident of workers. So I can't help you on that.
It's just an example, isn't it, Mr. Marshall, of how you make unfounded allegations against anyone who you disagree with, correct?
I think that's slanderous and outrageous and really not helpful in trying to elicit truth in this process.
Let's move on.
Mr. Hill,
Yes.
it's not clear to me, and I doubt if it's clear to Mr. Marshall, whether you are suggesting that this letter was not typed on the 20th of September 2012, but has been produced much more recently for the purpose of this arbitration.
Mr. Marshall, would you like to give, you heard the President's question, would you like to say your understanding of whether this letter has been typed more recently or not?
You mean, is it a fraudulent document?
Is it a late document?
It's certainly not a fraudulent document. No, we don't do that.
Well, you've presented to something that was sent to the Kigali police, and that's not true, is it?
As far as I know, it would have been sent to the police, but I refer you to Zuzana Marushkevichova, who was handling that. This would be unlikely to be a copy that would have been confirmed by the police. As I say, when we delivered letters to the police or any ministry, we would take a copy, a signed copy, but photocopy, and take it to wherever we were delivering it and have them put the stamp on it to indicate that it had been received. So this is not that copy. I don't know what this copy is.
Mr. Marshall, is it your signature on that letter?
Yes.
And was that letter typed on the day of the date it bears? Or has it been typed more recently?
It certainly was not in preparation, if you mean in preparation for these hearings, 100% not true. Whether it was typed, I'm sorry, I don't know what the date on it is. I can't see it.
Well, the date is the 20th of September.
Yeah, if this was a draft and we decided not to send it, we sent a different version, I don't know. 20th of September. But I would refer you to Zuzana Marushkevichova, because this would have been, her investigation, her preparation of these materials. So this was certainly a draft. Whether it was actually delivered in this form or a different form, I couldn't be sure unless I had the copy which had the stamp on it.
Well,
I understand your answer is that this was a contemporaneous document produced with the date that it bears.
Yes, certainly contemporaneous.
Thank you, Mr. Hill.
I'm going to move on now to a different topic. It's September 2012, Minister Kamanzi suspended all mining activities in the Sabaya catchment in the Western provinces, correct?
Am I looking
You recall
at?
that?
Am I,
It's not, I hope isn't contentious. I'm just trying to help everyone on the timeline. So September 2012 was when Minister Kamanzi suspended mining activities in the Sabaya catchment.
I don't know what month it was. He did suspend them in 2012. Yes.
Yes, and that was as a result of concerns about environmental damage as well as illegal mining. Yes.
That's what his letter said, as I recall.
Now, by the end of 2012, where one gets to is that by that stage your licenses had expired, hadn't they? Because the October extension had now expired. Correct.
They're all being treated the same, and they're all being deemed to be still large-scale mining concession holders.
And by that stage, end of October, your November 2010 application had not been accepted, correct?
Yes, it had been accepted. We had not been told that it had been refused.
Well, it was clear I would suggest from your August 2011 letter you received from Mr. Kamanzi what the position was, correct?
No, because we at that point were negotiating the language of the long-term concession with the licensing and regulation department.
And by this stage, end of 2012, subject to your argument about the November 2010 application, you hadn't otherwise applied for any long-term licenses, had you?
We were, as no one had said, we were not in compliance. We had the same kind of application as every other concession holder, and every other concession holder at that time was in active negotiations for a long-term license. We were the only ones who were not at that point.
And we know
because we had already been through that process in 2011.
But we know, for instance, from Mr. Kamanzi's letter we looked at yesterday, from the beginning of 2012, that you'd been asked to focus on 2 concessions, and there was no possibility of you just getting a long-term license for all your concessions.
So that's not how that was resolved. We went back to Mr. Kamanzi's office and explained that he had been misled by Dr. Michael in saying that Dr. Michael had offered 2 concessions instead of 5. That conversation had not happened. So his letter was mistaken in its premise because he'd been misled by Dr. Michael, and we would like to have a meeting to talk about going forward, negotiating a long-term concession agreement. We were waiting for an invitation.
Well, let's look at C-160. This is a letter from the Minister of Natural Resources, Mr. Kamanzi, to the acting CEO, Ms. Akamanzi of the RDB. And it says, this is to request you to initiate negotiations with the above company.
I'm sorry, can you go back to the top for a second?
Yes. So it's January 2013. So we're now at the beginning of 2013.
So this is a letter to the RDB.
Yes, from Mr. Kamanzi, as I said.
Okay, sorry.
So this is to request you to initiate negotiations with the above company. Its initial license for 4 years expired some time back. The company has been operating on short-term extensions as we wait for the conclusion of the new type of agreement with them, if any. Their existing license incorporated 5 former government concessions of Nemba, Rutsiro, Kikea, Sabaya, and Mara, which were too many for 1 license. The way forward should be to negotiate a license for each concession, so that each of them should be evaluated separately. The key activities of the company have been temporarily stopped in the concessions of Rutsiro and Sabaya because of serious environmental degradation. However, negotiations could begin with concessions that currently have no serious issues. I will appreciate your prompt response to conclude these negotiations as soon as possible. So he is still of the view that he expressed to you in the correspondence we saw yesterday that you should press ahead with those concessions that you could make a viable application for, correct?
I've never seen this letter. I never had that discussion. I don't even know how this came up or what they mean by serious environmental degradation. The only area where the government had asked us to make environmental repairs is in Gachia, not in Route 0 or Sabea, and it's at the Nyatabindi site where the ground sluicing had occurred for 50 years. And we were not mining. There were no other allegations of environmental degradation against us at that time.
You just suggested that somehow Mr. Kamanzi had been corrected in discussion with you after his position he articulated in 2012. And it's quite clear that the reality is that he remains of the same view, which is that if any new licenses were to be obtained, they should be negotiated for on a concession by concession basis, correct?
This is all new information for me. I've never seen this document.
Same information as he had already given you in 2012, correct?
No,
And by that point, you hadn't put in an application on a concession by concession basis as he'd asked, had you?
but in the same kind of application as everybody else did, and everybody else was in negotiation.
Can we go to bundle C054? Now, this is an application that you put in January 2013, and this is an application for a long-term license. You recall that?
I recall we got called by the ministry to say, yes, we have your application from 2010. Here's what we want you to do. And we sat down with them and they said, please make this a high level, if you will, sort of a summary of a number of items and send it to us now.
Now, that again is something you've just made up and is not in any of your witness statements, is it?
It is not what I've made up, and that's exactly what happened.
And let's look at the covering letter. You start off by saying this letter is to provide you an update of the amended application of NRD for a long-term mining concession license. The original NRD request for the long-term mining license was submitted to your office on or about 11/29/2010.
Right.
Copies enclosed for your convenience. Now, that was trying to give the false impression, wasn't it, that the previous application had been for a long-term license? Yes?
No,
And let's go on.
this was at their request. This was not our initiative.
If it had been at their request, you would no doubt have said further to your request, here is an application. Correct?
No,
And if it had been at their request, you would have mentioned that at some point previously in these proceedings, either in one of your memorials or in one of your witness statements. Correct?
there's lots and lots of communication which are not reflected in this narrow thread of sentences that you're trying to hook together to come up with your own narrative.
Now, if you look at the next paragraph, you refer to an investment of approximately euro 15 million. Can we go to page 4 of the document? You describe their achievements in research, production, and processing versus targets. And then you talk about the original business plan being submitted by NRD in 2006. You refer to the 39 million figure. And you say in the last sentence of that paragraph, the targets outlined in the original business plan and the operating practices that have since been discovered were seriously flawed and inappropriate. And that's a rehash of something that was said in the November 2010 application, correct?
Yeah, that was addressing Zarnak's proposal to build a tantalum processing refinery, which cost many hundreds of millions of dollars.
But just in answer to my question, that is a rehash of what something that was said in the 2010 application, correct?
I don't know that it's a rehash. It's a reference to Mr. Zarnak's original business plan proposal.
It's virtually the same words, isn't it?
I don't know.
Then look at the next paragraph. When the management of NRD was changed in the end of 2010, The focus of activities and investments changed to support realistic projects to support and significantly increase semi-industrial mining in a way that will also greatly small scale artisanal mining in multiple places, with an emphasis on increasing the standards of safety in the workplace and protecting the environment. During the period 2008 through 2012, total capital investment and other expenditures of more than euro 15 million were made and are evident of a commitment to a development of a sustainable mining industry of Rwanda and its people. So you're claiming an increase of 6 million euros on the 9 million euros said to have been invested in the 2010 application. Yes?
Yeah, I don't recall what the numbers were, but that's what this says.
And then if you go to the next page, you can see the figures, and these are the figures I took you to on the first day of your cross-examination, or
Yes.
I think it was the first day, earlier anyway. And it's the 6 million euros that you refer to is wholly represented by your estimate for foreign consulting and engineering costs, correct?
That's what that line reads, yes.
And for the reasons we discussed earlier, that was a fictitious number, wasn't it?
For the reasons we discussed earlier, it is a wholly accurate, but an estimate.
It's right to say, isn't it, that this update was essentially a short 9-page rehash of the November 2010 application, correct?
All I recall is that we were doing what they sat down and asked us to do to prepare this document.
You didn't identify any new...
There's no misrepresentation here, Mr. Richard, and I object to your insinuation.
You didn't identify any new material investment or exploration in this document, did you?
I'm not prepared to answer that question because we didn't go through this in anticipation that this would be an issue to be dealt with in the calculation of damages.
Let's look at page 3 of this document. This deals with exploration highlights, and you don't, in your exploration highlights, identify any material new exploration since the 2010 application. That's correct, isn't it?
This is what we were told to put here, yes.
And then the exploration that you had identified had previously been considered deficient, hadn't it?
No.
On the previous occasion.
No.
Okay, let's go to page 5 of the document.
We had an ongoing sampling program. We were the only mining company that had our own laboratory. So every day that we were mining, we were sampling the minerals. So we had a much better idea than virtually any other mining company in the country because we had the laboratory and we were unique in that regard.
If you had any material information derived from sampling that was new from the 2010 application, you would certainly have included it in this application or one of your other applications, wouldn't you?
No, we got called to the ministry, as I recall. We got called and said, here's what we need you to do. You don't need to rewrite it. Here's what we need to be able to submit it. And so we did what we were told.
Now let's look at page 5 and 6 of the document.
This is not an open-ended, please tell us the history of your company. This was very narrowly targeted by the advisor to the minister.
If you look at, so page 5 and 6, you set out your proposed activity plan for the period 2013 to 2018. If we look at page 6, we can see that the reserve that for your plans for 2013 to 2018 involve a number of projects and deposits prioritized and earmarked for follow-up investigation. And then you have a list there: Rutsiro, detailed calculation of reserves of Rutsiro primary wolframite deposits; Nemba, detailed calculation of Nyakabindi laterite deposit; Nemba, reserve calculation of all other secondary cassiterite deposits; Nyakabindi, detailed reserve calculations. Now, 2 points here. Firstly, these are the same proposals, aren't they, as was proposed in the 2010 application, correct?
Yeah, I don't know. We were under instruction, as far as I know, these tables were provided to us by the ministry for inclusion. But I can
I'm
ask.
not on, but just to be clear, I'm not on with looking at the table. I'm looking at the bullet points underneath reserve calculation.
The same formulation. These information, these sources, this both technical information and the expectations for production were provided to us by the ministry. This was not our document in that sense. This is
simply not the case.
They wanted from us for this to be proposed.
Mr. Marshall, that's simply not the case. This is just a rehash.
100%.
It's just a rehash, isn't it, of your proposals or the company's proposals in the 2010 application. That's correct.
It's not the way Rwanda works, and it's not the way until the 2014 application or 2015 application process, when they started sending us one-line requests without giving us any detailed background or information or their idea of their expectation. It's all done on a cooperative basis. All of these are with all concession holders.
And that's, again, simply a made-up story, Mr. Marshall, that if it were true, would have featured before in this arbitration.
No, I think your client hasn't informed you about how the process works.
Well, if you had really thought that the content of your applications had been dictated to you by the government, you would have said so loud and clear when you said it was unfair that the applications hadn't been accepted.
No, there are two issues. The applications that weren't accepted were those where we didn't have the technical information because our offices had been seized. This document and the original 2010 application, in fact, going back to the 2007 application for mining license, all that technical information is provided by the ministry. That's what they expect. It's their way of saying what they expect from the mining companies. And if the mining companies can't fulfill that expectation, then there would be some negotiation. You could even lose your license. But the process is very cooperative throughout until the 2014-15 one-liners.
Mr. Marshall, the reality here, and we can see it from the other document, is that all you've done is rehashed material that's in the 2010 application. And that shows a number of things, Mr. Marshall.
I'm sorry, I'm explaining it's all a interactive process. This is what the ministry says. This is what they identify the deposit area, and they say, well, this is what we think you should be able to get out of it, and that's what we expect to be able to hold you to.
And this shows a number of things, Mr. Marshall.
Negotiation in that respect.
One of the things this shows is that no further material exploratory research or calculating of reserves have been done since you acquired the company at the end of 2010, even though we're now in 2013, correct?
No.
Because all you're doing is giving the same program.
You're asking me why other material wasn't included, and that would have been a question for them. Do you want this other information included? We had a whole series of teams of geologists, consulting geologists coming from Europe who were performing a number of tasks and opening up additional deposit areas for exploitation.
The other thing that
nobody
shows,
ever asked us for that. This is at their instruction.
Mr. Marshall, the other thing this shows is that you must have known that this was not a viable application for a long-term license, because this is showing exactly the kind of thing that should have been done in the 4-year period and hadn't been done, correct?
No, and I have to refer you back to this whole principle. You know, they asked us to come, please take a risk, please invest money. We know that this is nothing like what the ordinary arrangement is in the mining industry. Do this as an indulgence to us. You will be given a commercially reasonable long-term license agreement. Everybody else was in negotiation for what that commercially reasonable long-term license agreement would say. We were not.
This was work that needed to be done under Article 2 of the contract, and you were told in August that the hadn't been done. August 2011 hadn't been done.
We're making stuff up now. We were told to put this document together in this format. They did not ask for the other geological research, which was ongoing by our European, Czech, and Slovak geologists and their team.
Can we go to the bottom of page
We had
3?
more geologists, expat geologists working in Rwanda than any other company.
Can we go to the bottom of page 3? You have production highlights. And you give production figures for 2007 to 2011. And it's right to say, isn't it, that the reason you don't give production figures for 2012 is that they were so low under your watch, correct?
I don't know that that would have been the reason. I don't know why it's not here.
Can we go to Dr. Biriaba's witness statement at paragraph 15? He says, on 30th of January 2013, NRD made what it called an updated application for a 30-year concession, although this was in fact the first application it had made for a 30-year concession at all, because the application made in November 2010 was for new 5-year licenses. The January 2013 application was entirely inadequate. It contained none of the detail that would have been required even for short-term licenses, let alone the 30-year licenses now being requested. And that's a fair and reasonable view and summary, isn't it?
Absolutely outrageous and completely inconsistent with everybody else we spoke to at the ministry.
Well, Dr. Biriaba, as you know, was one of the people who had been evaluating this.
He was also under criminal investigation for much of the period we were there.
Mr. Marshall, this is yet another extravagant claim from you, isn't it?
We spent many meetings discussing Dr. Michael's corruption with internal intelligence, even external intelligence.
Until you got into the witness box, you've never suggested that Dr. Michael Biriaba was corrupt in any way, have you?
Yes, I did. In fact, I think I told you that he was being bribed by Anthony Ellers, or Anthony Ellers had disclosed to us that he was being bribed.
Until you got into the witness stand, you've never made any allegation of this kind, have you?
To the Rwandan authorities, yes, you should talk to them.
This arbitration, you've never made any allegation of this kind, have you?
I don't know whether it's included in any of our other documents, but
it's not. It's not, and the reason it isn't is because you've just made it up in this when it's getting into the witness stand.
No, that's not true. You talk to internal intelligence, talk to external intelligence. I suspected that he was going to be gone before we were.
Let's look at Mr. Eminer's witness statement at paragraph 23.
The military people that we were working for just asked us to be patient, do nothing precipitous, that he was being investigated for corruption. We fully expected him to be removed from his position. He's known throughout the community for corruption.
Let's look at paragraph 23. This is Mr. Eminer's reaction to your application. That draft agreement had been sent with what's described as an investment plan report summary related to a 30-year concession. The letter itself referred to it as an update of the amended application of a long-term mining concession license and mischaracterized the November 2010 application for 5-year licenses as the original NRD request for the long-term mining license. Investment plan report summary is only 9 pages long, contained very little detail, and much of it appeared to have been copied and pasted from a November 2010 report. There was no proper analysis or supporting documentation of it at all. If Mr. Marshall really considered this to be a serious application for a 30-year license, the first made by NRD at all, then it demonstrated his fundamental lack of understanding of what was required. And that is entirely fair, isn't it?
It's entirely outrageous. Nothing like that was ever communicated to us. The people who said, who were responsible on the licensing and supervision board always told us that of all the applications, and we read many of them from many of the other concession holders, ours was far superior to any other application. So I think this was just prepared for the arbitration and nothing else.
Well, these people who you say said it was far superior, who are they? Mr. Bodega's gone by then.
You'd have to ask Mr. Bodega who the staff were at that time and others who were there at that time.
That doesn't work. He had left by then. He was with you. He had joined your organization shortly after the correspondence that we were looking at.
You're really talking about several things, right? You're talking about the 2010 application. That was reviewed by the application Licensing and Supervision Board as being the best of all the applications.
Mr. Marshall, I'm looking at this application.
If you're saying that it was later deemed to be insufficient for some reason, that was never communicated to us.
Well, we've already seen in this testimony over the last days, various examples of you being told it was insufficient. So it was communicated to you.
Yes, and I think I've told you in response, most of those are due to bias because of allegations of corruption and other matters.
Well, let's go back to Mr. Eminer's
As far
witness
as we
statement.
do, our application had not been surpassed by anybody else, and nobody else had done more research than we had.
Mr. Marshall, I don't want to argue with you, but you could not possibly have thought that, given the correspondence you were in fact receiving.
I absolutely knew it because I'd been to all the other sites.
And the only things you rely on to support your suggestion you took a different view is conversations or some parallel stream of communication that are not supported by the material that we have, correct?
No, it's those conversations occurred. We were having regular, several times a week meeting with senior grade officers from the military who repeatedly assured us just to be patient. We visited every other concession. We knew every other concession application. You know, if you, the only application I think which was superior in some respects was Rutongo, and for the very simple reason that they had access to all of the Belgian resources and research for their 40 years of working at Rutongo. So additional process that they were doing, not a greenfield site like we were doing.
Now, let's look, staying in Mr. Eminer's witness statement. Can you just go back to paragraph 22? He's dealing there with the draft contract that you attached to this application. He says at paragraph 36 of his witness statement, Mr. Marshall suggests that the draft long-term license agreement that was enclosed with his 30th January 2013 letter to Mr. Kamanzi had been agreed with us. That is not correct. In fact, we never actually reached the point of discussing contractual terms of NRD because we never got to the point in the application process at which it was necessary to do so. I do not know the origin of a draft agreement enclosed in Mr. Marshall's 30th January 2013 letter. I do not believe it's prepared or produced by the government. Although Mr. Marshall states it is in conformity with the template which your ministry provided to us, it is not in a style or format we would use and includes information, for example, investment and profitability estimates that I do not believe we ever include in the body of our agreements. And that is entirely correct, isn't it?
No, I would say that's entirely made up for purposes of this arbitration. We negotiated in good faith with Dominic Bodega and his staff. They gave us the template, as I think I explained to you yesterday, the day before. It was the Gafur way, you can check it, Gafur way mining concession template that they gave us to make changes to. And so we did, and we reached the end of that negotiation. He explained to us that it had been referred up to Dr. Michael and the then Minister Kamanzi, and it had been approved and sent to the cabinet with a positive recommendation.
I don't want to go back round on that, but it's quite obvious if that had been remotely true, you'd have been saying so in the letter to Mr. Kamanzi, saying this has already been agreed, approved by Dr. Biriyama, approved by you, Mr. Kamanzi, and sent to cabinet. None of that happened because none of that is true, correct?
No, of course it happened, and they knew it perfectly.
So why didn't you say so in your letter?
I obviously didn't think it was necessary. There's nothing that they didn't know about this process.
Why didn't you mention in your letter that Mr. Kamanzi has already approved this, Minister McCrane has already approved this contract and it's sitting with cabinet?
I don't know that it was sitting at cabinet at that point. Obviously,
what's the purpose of the application on your case? What's the purpose of his letter at all if he's already agreed this contract and it's gone up to cabinet?
He's renegotiating. That's my point.
So this is volunteered by you.
He knows the language of the original agreement. He knows that it's been agreed. He knows it's gone to cabinet. It was not rejected by the cabinet, as I understand it. It was simply tabled and no action was ever taken.
Mr. Marshall, he's not negotiating. You volunteered. You volunteered.
May I ask Mr. Hill, just please let him finish before you start the next question.
Yes.
It was tabled. No action was taken I interpreted that to mean that, okay, this meant there was going to be another round of negotiations. So I expected that template, that agreed upon language, to be the basis on which we would continue and find terms that were acceptable, since obviously that was not acceptable, but I had not been told why or what provisions were unacceptable. So to me, this was already understood. We were working from this template. If they were going to bring in a new agreement, then we would have taken a look at it and started that negotiation. In fact, we did get a new draft agreement, which was substantially different from the one that had been submitted in the end of 2011.
So, Mr. Marshall, you don't have any answer, do you, to why on your case, if Minister Kamanzi had approved this a long-term license already and was prepared to submit it to Cabinet, you are making an application for a long-term license and trying to justify one and providing a draft agreement?
No, things are often less than regular in Rwanda. So the fact that they were asking us to negotiate from a new template was not particularly surprising to me. We had hoped that the original one was going to be accepted. They had approved it, sent it to the Parliament. Now they wanted to do a renegotiation. Okay, so let's see what you have to say.
Let's look at paragraph 35 of your witness statement. You say, following each of the extensions, I continue to expect that NRD would be awarded a long-term contract. Throughout all these extensions, the Rwandan government representatives we interacted with have always referred to long-term contracts for concessions as a guarantee or foregone conclusion. They never suggested to us that Rwanda may not honour the concessions of long-term contracts. I continue to invest in NRD with the understanding that long-term contracts are forthcoming. None of that is true, is it?
No, all of that is true.
Now, we were referring earlier to the fact you had been prevented from mining the Western concessions due to environmental concerns. Can you now please go to C056?
Not all of the Western concessions were closed, by the way, but just to alert you.
Can we just look at C056? This is from Dr. Biriabarema in February 2013. He says, reference is made to your letter dated 6th of February 2013 requesting for the resumption of mining activities in Rutsiro, Sabea and Gikea concessions of NRD, and also have the opportunity to remedy the harm being done in those concessions by illegal miners. Following our conversation with you on 6th of February 2013, we recognise and appreciate your suggestions to curb illegal mining practices by using demobilised soldiers to provide security for those concessions. As you informed us, this group has proved effective in Nemba, another NRD-controlled concession. We agree with your proposal and request you to proceed with discussions with demobilised soldiers and work out a security strategy. On the strength of this strategy, NRD will be permitted to resume activities in the short term as we proceed with negotiations on your request for new contracts for the concessions. For any other support, please do not hesitate to contact us. So you were allowed to resume activities in the short term while negotiations progressed, correct?
That's what it reads. The negotiations did not progress, but that's what it reads.
And this wasn't a letter from the minister, which would have been granting an actual license extension. This is from Dr. Biriabarema giving you, if you like, an ad hoc informal permission to remain on the concessions, correct?
No, we were always treated as mining concession holders as defined by law, except with respect, always treated as mining concession holders. In a few select instances, like this issue of the Sabea River catchment, there was a declaration that the catchment was closed, but we were always treated with respect as long-term concession holders.
But this didn't involve an extension of the license. That's why, just focus on my question. This didn't involve an extension of the license, did it?
Your question was whether we were had independent rights. And my point is, we are always treated like long-term concession holders. It's a course of dealing.
But you're not, right, you're relying on a course
Can
of
I finish,
dealing.
please? We never changed from when we got the licenses in 2007. We were always treated with those both rights and responsibilities, except that in certain cases, like Spalena River catchment, things were closed because of, in this case, environmental degradation.
And nothing on this letter gave you any assurance that any long-term license would be given, correct?
Proceed with the negotiation on your request for new contracts.
So exactly. And this permission was given on the strength of your assurance that you would curb illegal mining on the concessions through the hiring of demobilized soldiers, yes?
I would point out to you, you were accusing us earlier of mining in this area, and here this letter is talking about mining by illegal miners, not by NRD miners in this area.
This permission was given on the strength of your assurance that you would curb illegal mining on your concessions through the use of hire of demobilized soldiers, yes?
That's what they wanted us to do, yes.
And that reflected, didn't it, that it was NRD's responsibility to maintain order on its concessions and prevent damage on its concessions?
No, that's not true in Rwanda. You can make reasonable efforts. The country is so crowded that you cannot, it's not like in many countries where you can fence off a mining area. The areas in the concessions are large. They're in some cases hundreds of thousands of people. So people do come and mine selectively where they want, and you can't control it. Rutongo was able to get support from the military. We don't know why. We tried to get support from the military, and two entire brigades were posted at their concessions to stop the illegal mining.
Well, your concessions were particularly, Mr. Marshall, your concessions were particularly large, and that was one of the problems you faced, is that you couldn't control activity on your concessions, correct?
No, the concession areas are established by law. It's not something that anybody had an option to unless they were going to change the law before granting them to us. The concession areas, as a matter of practice, are always handled as a police matter. It's not like you can control somebody coming in or going out. These are widely scattered, very small deposits, and what you do is you provide those artisan miners with various kinds of support.
Well, plainly, Mr. Marshall, the government thought that you could curb illegal mining, and it was your responsibility, because the basis on which you're allowed back onto the concessions, as we can see, is your assurance you will hire demobilized soldiers to get in control of illegal mining. Yes?
That hadn't been tried before, so we proposed it to the government. Maybe what we can do, because this is a mutual problem, it's a police problem. It's a security problem. But these are not mines where long-term, large-scale mining concession holders ever had a responsibility for that. They have some security responsibilities for immediate dangers, like making sure people don't fall into holes and that kind of thing. But for policing of illegal mining, there's nowhere in the country is that solved by the concession holder.
Well, it's exactly what's happening here, and your undertaking to hire demobilized soldiers arose because you accepted it was your responsibility. Correct?
So, you know, you're attributing bad intentions by my not including some phrases in documents, and here you're interpreting a bad intention by saying, well, you had to because you had no other choice. We did this out of good faith. The police could not handle this problem. So we were unique among the mining concession holders that said, why don't we set up a program to hire these demobilized soldiers? It solves the government problem of what to do with demobilized soldiers who may be difficult to deal with, and we can give them work.
Mr. Marshall,
So
something that
was program from our point of view and innovative. Nobody else had done that.
Mr. Marshall, something that was happening as a matter of good faith was that the Rwandan government were granting you an indulgence by permitting you to remain on the concessions after your licenses had expired, correct?
No, we were deemed to be long-term mining concession holders, which is a defined term under Rwanda statute. That never varied.
You were not deemed, come on, Mr. Marshall, you were not deemed to be long-term concession holders, were you? You
Yes,
never had a long-term concession.
Everybody
you had a contract for 4 years, which by this stage was no longer extant. Licenses. Just listen to my question. You had a contract for 4 years, which was no longer extant, and you had licenses which were expired. You were never deemed to be long-term concession holders.
No, our contracts were executory. We had granted the indulgence that the Rwanda government had asked us. We had set up operations. We had invested considerable amounts with the expectation that we would be granted this long-term, commercially reasonable contract. And as a matter of law, we were deemed to be long-term concession holders, and specifically holders of those concessions by statute, not by right. We had fully performed on the contract. We had done what we had promised to do. They promised to give us a commercially reasonable long-term license agreement, and that was the negotiation and the agreement we were waiting for.
Mr. President, I wonder if that's a convenient moment for a break.
Yes, I think it's a very convenient moment, and we'll have an extra 5 minutes, I think, come back in 35 minutes at 1:15.
Okay, Mr. President, looks like everyone is back.
Thank you.
I'll go off camera and wait to hear from you to bring the witness in.
Yes, could I just ask Mr. Cowley?
Yes.
Did you have time to open the envelope and consider its contents?
We opened the original email. The representation to us was we were going to be asked to confer with our client about one document and
Yes.
admitting it today for questioning of Rod Marshall. I never received such a request. I took it as probably indicative of the fact that the questions they asked have already been asked, but if not, I still did two things. I looked into our IT staff has received the package. They have the metadata that was submitted to us by a letter this morning. I've got follow-up questions for them about what their comments. They don't know anything about the trial, the background. They don't know what to really be looking for. So I have follow-up questions with them, and I may answer all my questions, or those follow-up questions may have to be answered by respondents' counsel. I also have questions for them about what this new ability to produce metadata by the respondents covers beyond what we're holding. So I have additional questions. And in any event, I asked Mr. Marshall, as an academic matter, should anybody have an email in native format or another document in Word format, PDF format in native as opposed to electronic or PDF? Does he have any ability to talk about the differences between the two? Does he have any ability to talk about metadata in native compared to something else? And he says absolutely not. I confirmed with him that in order for him to even talk about what is in metadata or in a particular document in metadata, he has to confer with an IT professional. So there is no substantive testimony from the witness that could be obtained today in any event regarding metadata. So I suggest this change in position with regard to discovery and production of documents should be a subject of actual discussion between the parties' counsel. We've never had any, and we report back to the tribunal, probably not today, but we report back after we've had an actual conversation.
Right, thank you. Mr. Hill, that sounds sensible.
Well, we certainly can't deal with it now. So
Yeah.
let's park it now, I think.
Thank you. Then let us have Mr. Marshall back, please.
Okay, bringing the witness in right now.
Mr. Marshall, can you be given C57. C057. This is a letter from the RDB to NRD setting out its position in respect of the licenses. And the RDB note in the first paragraph of the contract, that the contract expired in 2011 and the company's been working on short-term extensions. Yes, you see that?
Yes.
And as they say there, as the government of Rwanda has taken a decision to negotiate license agreements separately for each mining site, we wish to initiate negotiations with the company for the issuance of a small mine exploitation right for the Nemba site. So at this stage, the government's making it clear, isn't it, that they want to negotiate license agreements separately for each concession. And at this stage, they're interested in negotiating a small mine license for Nemba, correct?
Possibly. It also may be that they were not articulating the situation well and that they were in error. For example, right at the top of the page is addressed to Mr. Zarnak, who hadn't been associated with the company for many years. I don't know. We were certainly, we took it as an invitation to come and negotiate a long-term concession license.
How could you have taken it as that, Mr. Marshall, given they're telling you they want to negotiate each one separately and they're inviting you to negotiate for a 5-year small mine license for one concession?
Well, I don't know that that's truly what they meant. All the other concession holders were in long-term license concession holder agreements.
But it is truly what they said, isn't it?
Sorry?
It's truly what they said in this letter.
You mean the sentence you're reading?
That's what they're saying.
You're contradicting me. Is that what you mean?
Yes.
No.
You say you don't know that's what they meant, but it's exactly what they said.
Yeah, so my point is that everybody is at this point going through a negotiation for long-term concession license. We had no reason to believe that we were going to be treated any differently, even though it's written inartfully here.
You say everybody at this point, but that's simply not the case, isn't it? Is it? They are explaining what they're prepared to negotiate, and it is not long-term concession licenses, correct?
Well, as far as I know, all large-scale mining concession holders were being brought in for negotiation of long-term license contracts, and all of them were negotiating what both parties would hopefully find to be a commercially reasonable agreement.
Should we look at your response to this?
For Ratongo, for example, it took them 3 years of negotiation. Well, I don't know why, but we hadn't even begun. So we were glad to find somebody willing to talk about what had happened to us and what the original long-term license agreement text had been.
You say you hadn't even begun, but I thought your evidence elsewhere was that you had begun, and indeed you had an agreed contract which had been agreed by the minister and gone to cabinet.
You're trying to twist my words, I think, sir. So excuse me. What I'm trying to say is I think you'll appreciate we had negotiated a long-term contract, had gone to the Parliament cabinet. As we were told, it was tabled, it had not gone ahead. We saw that this letter, we were optimistic that we were going to be able to be like everybody else, like every other large-scale concession holder, negotiating for a long-term concession agreement.
Let's look at your response to this, Mr. Marshall. C058.
Let me, by the way, let me give you just one important side to this. They had all the leverage in the world because they had our assets. I'm going
to stop you there, Mr. Marshall, because that is not a beginning to be an answer to any of my questions, and we must get on. And I'm not going to allow you to digress into matters which are not answers to my questions. So will you please go to C058? Now, this is your response to the letter from the RDB, and the pickup of in the beginning, first paragraph, a point about the addressee. I'm not going to bother you with that. I'm going to look at your second paragraph, next paragraph, I perhaps should add, as you note in CEO Akamanzi's invitation letter, the term of the original contract has passed without NRD receiving the agreed upon long-term license. And we would like to express our appreciation that we can now discuss that. And just pausing there, you knew that there was no agreed upon long-term license, and you knew that you were not being invited to discuss a long-term license, didn't you?
No, as you said before, this is the plain language. We expected to be negotiating for a long-term license, similarly to how we had been negotiating it with Dominic Bodega in 2011.
So this is a deliberate, I would suggest, misinterpretation of a letter, which you have copied, amongst other things, amongst other people, to the US ambassador. Yes?
That's the double question. Can I answer the first one first, please?
Yes, please.
What we understood was that we were being finally invited to negotiate a commercially reasonable long-term license. We hadn't had anybody to talk to about the terms of that license. From our perspective, we had fully performed. We had negotiated the agreement once, it had been sent to the cabinet, tabled, and it hadn't gone ahead. Now we're given a second opportunity to be able to negotiate what the language of that long-term license would be.
You wanted to give a full... Yes, carry on.
What was your second question?
Yes, you sent it to, and I suggested, and this is the same suggestion I'm making again now, you sent this letter to a number of other recipients in order to give a false impression that there was some agreement of a long-term license, didn't you?
This is a very small community. Everybody knew everything about what was going on. If the Rwanda government, if these people in the Rwanda government were jockeying to be able to say, okay, we did have an agreement. We're now going to breach that agreement by offering you something different than what we promised. Then everybody needs to know what that process is. We were trying to play with all the cards face up. That was the only reason.
Could I just intervene to ask a question which has been puzzling me from the outset? When we look at this letter, it has by the Ministry of Natural Resources, the Rwanda Development Board, and the American Embassy. How is it that one document bears these three stamps of receipt?
Well, ordinarily what we do is it's a administrative practice in Rwanda where you deliver the original to the named recipient, and when you're delivering copies, you go to their office and they give you a stamp on your copy so that you have a record of everywhere you delivered it.
So all these documents were delivered by hand in hard copy, is that right?
All documents in Rwanda are delivered by hand. There's really no meaningful mail service. So for example, the stamp there next to the addressee, I don't see others, but Rwanda Natural Resources Authority, that meant that we took it to them and the copy we were keeping, we got them to stamp it as evidence that they had received it.
Thank you, I understand. That was the same.
Thank you, Mr. President. I'm just seeing if I can skip the next thing just to try and move things along a bit. If you give me one moment.
Would add two additional, Mr. President, two additional administrative practices in Rwanda is one that all documents, all received letters are entered into a logbook. So when they stamp it, they also enter it into their logbook. And every letter that they send out, when the minister sends out a letter, for example, they also enter that into a logbook. So it's like the US Army where they keep a record of every communication. And then there's some dispute about whether it's 7 days or 7 business days, you have to respond to that letter on both sides.
Thank you. That's the practice.
That's the practice. Sorry.
Yes. Can you now go to C159? Sorry, C159. This is a meeting of the RDB that you attended, and you see at the beginning of the note of the meeting, it says, second sentence, Ms. Rusagara informed NRD had not received any comments from the company on the mining agreement and the due diligence questions it had submitted to NRD on the 4th of April 2013. Ms. Rusagara noted that in the absence of comments from NRD, the meeting could be used to focus on broader issues relating to the agreement and due diligence questions, or addressing clarifications in connection with that agreement. So the RDB went into this meeting wanting to negotiate or to discuss the agreement, which you had not yet commented on, and that was the 5-year NEMBA agreement, correct?
I don't know what the draft was. I don't recall.
And what happened at this meeting is you weren't ready to discuss that draft. And I don't want to go to the detail of the minute, but it's clear from the minute that you raised a number of complaints, and it was agreed that there would be a meeting with Mr Eminer, which took place subsequently. Do you recall that?
I recall that there was no meeting with Dr. Mena subsequent, that this was a preliminary meeting for purposes of negotiating a long-term contract. That was my recollection.
Well, just interrupting you there, of course, sorry, I don't mean to interrupt, following up on you there, it wasn't a preliminary meeting for discussing a long-term license. It's quite clear that from the RDB's point of view, it was a preliminary meeting for discussing a short-term license that you were not in a position to discuss, correct?
I don't ever recall that there was a conversation of us having a discussion about a short-term agreement at all. So that's my recollection.
Then we have your letter to Mr Eminer.
Can I read the rest of this? Can I read the rest of this? It may remind me.
Well, no, because I simply need to move on. I don't have a question on it, and we are not going to finish your cross-examination if you read every letter.
I'm going to give you a more complete answer if you want a more complete
answer. No, I don't want a more complete answer. I want to move on, and we won't finish this cross-examination. Can we go to C059? This is your letter to Mr Eminer, where you say, in our joint discussions of RDB, it would suggest we have a meeting directly with you and RDB about the business legal regulatory situation facing NRD. All the meeting agreed if these issues could be resolved, a negotiation for the long-term concession would be easier and more straightforward. And just pausing there, again, that is you twisting things to try to give the impression that there was some discussion, a negotiation for a long-term concession that everyone thought would be more straightforward if you had a discussion with Mr Eminer, which is not what took place, correct?
I don't believe there was any inconsistency between that and the prior minutes, but you wouldn't let me read the prior minutes, so I'm not sure what you're referring to.
No, you then say—
the language of this agreement, we weren't twisting any language, we weren't misrepresenting anything.
I'd suggest to you this is one of a very large number of examples where you seek to give the impression in your correspondence that there was some agreement or negotiation as to a long-term concession when that wasn't in fact happening. Correct?
We were treated as long-term concession holders from the beginning with a 30-year, with mandatory 30-year period. We expected that that was what was going to be the subject of a commercially reasonable long-term license agreement.
And then you then say we'd originally understood the topics for discussion should be presented to you through RDB. We now understand we are to present a list of topics to you, and then you attach a list. And this is another letter that you copy to the US ambassador, correct?
We were in constant communication with the US Embassy about everything, particularly at this time because we were also working for the Rwanda military.
No. Let's just look at some of the items on your list. If you go on to page 2, second page of this document.
I'm sorry, including the cover email, the second page of the PDF,
yes,
for the second page.
Yeah, that's right. Where you are, that's fine.
Okay, thank you.
So you pick out some issues that you want to discuss with Mr Eminer, starting with little a at the bottom of the page, the continuing harassment of NRD which includes the de facto closure of NRD's Western mining concessions as a result of a lack of security and of the actions taken by the Rwandan National Resources Authority. Now, that itself is a very unfair characterization, isn't it? Because the concessions, Western concessions, were closed down for environmental reasons and only opened up on the basis of your assurance that you could hire demobilized soldiers to curb the problems.
No, the area that was closed, don't forget, was the Sabea River catchment. Not all of the Western concessions were closed. Just so you're aware, as an administrative matter, when we send a letter like this, they have 7 days to respond if there's anything which is incorrect. Their lack of response suggested that they agreed with what is written here.
Is that one of the reasons, Mr. Marshall, why we can see so often you put distorted information in the letter, so you can somehow rely on it and say against the minister that there was something they hadn't responded to within 7 days?
But that's their administrative practice. We write what we believe to be the truth, and they respond as they believe to be the truth.
Now let's look at the next page of the letter. We can see what you're asking for. You say, we would respectfully ask the Ministry of Natural Resources to do the following. First, explain why NRD alone among the mining companies is the target of unofficial and official and unofficial state action. Is it because RNI want to compel NRD investors to give up their investment in the Rwanda mining industry? So this is a letter that emerges from you to the minister in response to the request to negotiate a 5-year concession license for NEMBA. And do you consider that this is an appropriate request to make of the minister?
I think you're mischaracterizing it again. The issue that was decided was that we would be raising issues that were impediments to our ongoing ability to work in Rwanda of any kind. And so these were an opportunity to discuss issues we wanted to discuss with Mr Eminer, who until this point was really unwilling to speak to us.
The reality is there haven't been any...
In fact, I would like to make one last point. There are maximum 10 large concession mining companies in the whole country. The fact that he did not find time to talk to us meant that he was avoiding us, not that he was too busy with other matters.
And far from being the target of any official or unofficial state action, all of NRD's problems are ones that had brought upon itself, for example, by being unable to curb illegal mining on its large concessions, correct?
No.
Let's look at the next item, paragraph 2.
Mining concessions had much more difficulty with illegal mining than we did. Rutongo was among the biggest complainers about that.
Let's look at the next item. Grant to NRD the long-term 30-year mining concessions provided by Rwandan law and promised under the 2006 Exploration and Exploitation Agreement, which grant has been repeatedly delayed and manipulated by RNRA. NRD has fully performed under the 2006 agreement, and in accordance with our agreement, NRD is confirmed is satisfied by its exploration results in some concessions, and in some areas within a concession wishes to continue exploration. Now let's take this in stages. There's no 30-year license promised under the 2006 contract, is there? That was a distortion of the contract.
No,
correct?
No. At all times, we were the statutorily defined long-term, large-scale mining concession holder, which is a defined term under Rwanda statute. And there it specifies as the long-term holder, it is for mandatory 30 years, there's no lesser period. And the Rwanda government always was making the argument, we would like to be sure of what the terms of the so-called commercially reasonable long-term license say, and that was the sole reason for their delaying it.
And there'd been no, as you say, manipulation by the RNRA, had there? The first application by you for a long-term license was not until January 2013, and that was the 9-pager that we looked at earlier. Correct?
No, this is your fanciful narrative, and I understand that you're trying to thread together lines from different sentences, but that is not what was happening on the ground.
And then you say, the that NRD has fully performed under the agreement, but you had already been told repeatedly by the government that NRD had not fully performed under the agreement, hadn't you?
That's not true. We had been given some letters from Dr. Michael, Minister Kamanzi, and later from Minister Evode, but virtually everybody else in the ministry had confirmed that we had fully performed, in fact, performed better than anybody else.
So all your letters...
More than that, if I may finish, please. And more than that, we had a parallel line of negotiation with the government through the Rwanda military. And they were telling us that we had fully performed and there was a corruption problem that their internal security was working on.
So all of the letters from the people with senior responsibility and authority were against that position, but you're relying, are you, on conversations with people like Mr. Bodega, who joined your organization? Yes?
It's an ongoing negotiation. We knew what people thought. We knew that they were investigating corruption. We believed Dr. Michael and Minister Evode were going to be removed almost immediately. In fact, Evode was removed, but 6 months after we left the country.
And this was a wholly distorted position that you were presenting to the minister and copying to the US ambassador so that he himself would, just let me finish, he himself would have a false impression of what was going on. It's fair, isn't it?
He has his own sources of information. He's fully part of the community. Everybody in the US Embassy is fully part of the community. We played with all the cards facing up. They knew what was good, what was bad, what was happening day by day. And they always provided a representative from the US Embassy to go with us to these meetings. That's very unusual. Very rarely does a US Embassy official go with a private citizen to a business meeting. But they came with us dozens and dozens of times because they could see how unfair this was.
Well, they were being told by you inaccurately. They were being told by you inaccurately how unfair things were. Correct?
I think you're over judging my capabilities. They were very adept people. They understand the Rwanda community. They knew what they were doing. They knew who they were talking to. And that, yes, we were being treated much less fairly than anybody else.
Now, we've arrived in the story at the second half of 2013. Mr. Kagubari joined NRD in the second half of 2013, didn't he? Yes, remember him?
Yeah, he started, I want to say November, but he was a consultant, not an employee, and his real job was for the Directorate of Military Intelligence. And he was sort of our go-between with General Jack and Ziza to prepare memoranda for him on topics that were interesting.
Let's look at what he says following his arrival, paragraph 9 of his witness statement. So he explains his witness statement. He's a mechanical and civil engineer by profession. And he says at paragraph 9, I started work in the second half of 2013, very quickly discovered that the company was not being run in a professional manner, but rather that Mr. Marshall and Ms. Moskrovikova were effectively running NRD as a briefcase company. For example, although the company had an office in Kigali, its only staff were 2 women whose job was to prepare accounts that could be presented to the RRA. In the event that the RRA asked for the company's records, the business itself was mostly run out of Mr. Marshall's and Ms. Moskrovikova's apartment, and Mr. Marshall and Ms. Moskrovikova rarely visited the Kigali office. And that's fair, isn't it?
No, it's completely outrageous. We were running the business from the office. We were at the office every day. Our staff were there every day. I don't know about John's professional background, if I may go back to that. I know that he was a construction worker in the UK for a number of years and ran a taxi until he came back for better opportunities in Rwanda. He was working for the Directorate of Military Intelligence. He was our liaison with General Jack and Ziza, who wanted very concrete information about the mining industry and how it should be run and what kinds of recommendations we would propose or we thought would be appropriate. And then he had a shift into military procurement. John Kagubari came with us as his representative to meet with the armaments companies in Czech and Slovakia.
That was all a very long answer to a question of about what he found in relation to the way you ran the company. Can you please try to keep yourself to the answers to my questions, or we will not finish this cross-examination? Next question, please go to paragraph 15 of Mr. Kakabari's witness statement. He says what he found is that although, as he arrived at the end of 2013, although the company was entirely dependent on artisanal mining, it did not manage its staff and contractors in an effective way. Ms. Moskovikova had a habit of firing people at will. It was not uncommon for her to walk up to an employee or miner and fire them for allegedly stealing or because she thought they were lazy. Ms. Moskovikova also seemed to regard payments due to the artisanal miners as discretionary rather than obligatory, and would sometimes decide they should not be paid as agreed after every sale, claiming there were more urgent issues to sort out. An excuse I disapproved and got to learn was the cause of the company's many legal problems with its employees and contractors, and it was involved in a large number of court cases concerning claims for unpaid salary, wrongful dismissal, or failing to pay the artisanal miners for their minerals. I remember at least one court case was brought by a group of miners who had not been paid, although a settlement was eventually agreed and a payment program implemented. NRD did not comply with the payment program and the miners went unpaid. As far as I can tell, NRD lost almost all the cases brought against it, but still refused to pay their former employees and the miners the amount that was due to them. And that fairly sums up the position. NRD did not manage its staff and miners in a professional way, did it?
It's a wholly fabricated statement, completely untrue. All companies are dependent on giving support to our groups of artisanal miners. That's the fact in Rwanda. We manage them in an effective way. I would say we were better at managing them than most companies. I don't have a clear parameter for that, but I know our staff were always paid and always paid in full. To the extent that there may have been any legal problems with any miners, the only ones that I know about were from the start period. And I don't even know that they know that these people had sued the company. We could never find out any information about who they were or what they sued for. As far as I know, we never had a lawsuit from unlawful dismissal, except in those cases where there was a perfunctory lawsuit where we had fired somebody for theft or embezzlement, like Amy, for example. He may have brought a claim. As far as I know, those would have been dismissed, although the courts are, very reluctant not to give some kind of damages, even if nominal damages.
Mr. Marshall, we know there are lots of court cases. Mr. Marshall, we know there are lots of court cases and judgments, including judgments for unfair dismissal.
It's a gross misrepresentation. No, it's not true. The bailiff came to us with a list of so-called employees from maybe the West. We don't know where. We would never get. Wait a second. He would never give us a judgment. He would never give us a court document. We don't know who they were.
A more accurate position is that the bailiff came and he had judgments that he was enforcing.
If he did, he wasn't showing them. That's my point.
Well, we'll come back to that. Can we go to paragraph 16?
All of this is fraudulent, and I would ask you to address these issues to Mrs. Marushkevich.
Back to paragraph 16. Although I'd been hired on the understanding that I would assist NRD in its production strategies and security, which I believed involved industrializing its operations, none of this sort happened, as Mr. Marshall and Ms. Moskovikova were not willing to invest any money in the company. It quickly became apparent to me that NRD was happy to continue buying minerals from artisanal miners and reselling those minerals for a profit, rather than investing in and developing the company's operations. During the time that I worked for the company, it made very little capital investment. It did not make any investment into industrializing its operations. And that's accurate, isn't it?
No, it is not. He was a full-time employee of the Director of Military Intelligence. He was giving us assistance on security matters. It was represented to me by a mutual friend that he could help because he carried the weight of the Director of Military Intelligence to be able to stop some of the harassment we were getting by small communities and small mafia groups. All of this is creative writing at best.
And we know it's accurate, Mr. Marshall, because it coincides with the documents you have produced, which show the company's documents, which show an absence of investment in the period of NRD.
That's not true.
And we've been through that material.
That's not true. You bifurcated the proceedings. You didn't want that information until the second part. With regard to this specifically, I believe he was involved in industrializing mining. He knows well that industrializing mining in Rwanda is interpreted to mean giving more and more assistance and support to artisan miners in their mining activities. It's not to create massive open pit mining operations. And it's a misrepresentation to say that we are happy to continue buying minerals from artisan miners. That's what every mining company does. Everybody, no, there are no full-time miners. There are full-time support staff, but there are no full-time miners. Everybody buys from the miners and sells that production to the comptoirs or traders.
Now let's look at paragraph 18 of his statement.
And
Dealing with root zero.
you go through a sentence, excuse me, just to make an observation.
No, I'm not allowing you to make an observation, Mr. Marshall. You will answer my question. You please go to paragraph 18.
Can I interject a comment, please? You read a paragraph and you say, that's all true, isn't it? And then you don't let me respond to item by item, and that's not very fair.
I'm giving you long opportunities, very many opportunities for long answers, Mr. Marshall. And I need to
you're reading 6 or 8 sentences and you don't give me an opportunity to answer each of those allegations.
Now let's look at paragraph 18, Mr. Marshall. He deals there with the root zero plant. And what he says in the middle of the paragraph is that plant at root zero was not operational. And I was told by employees that had worked for NRD when it was owned by HC Stark that the plant had never worked and could not process any minerals because it had several missing parts. And he's dealing here with 2013 now, and it's right to say, isn't it, that that plant was not operational.
The plant was absolutely operational. It's a farcical statement. It's so bluntly untrue. Not only were we operating it we're certainly operating once a month, but sometimes more often, if we had a major load of material to put through it, it was always available for artisan miners to use some part of it, like the washing tables. You're misrepresenting what a processing plant is. It's a group of processing equipment organized so that it can be most efficient and minimizing labor. That's not the biggest problem in Rwanda. It is the only plant in Rwanda at this time.
And let's go back to the license story now. Mr. Eminer, now as State Minister of Mining, invited you to a meeting in October 2013. Do you recall that?
Yes.
Can we go to the invitation, which is at C060? It says, I'm pleased to invite you to a discussion meeting between your company and the Ministry of Natural Resources to be held in the Ministry's meeting room on Tuesday, October 29th, 2013 at 9 a.m. During this meeting, we will discuss several issues relating to mining activities of your company, including mining licenses, environment, safety and security concerns in NRD's western mining perimeters, and complaints against NRD raised by district authorities. So he wasn't avoiding you, was he? He was inviting you to a meeting, correct?
I don't remember receiving this message. He was avoiding us. The sole purpose of the meeting was the OECD delegation that was coming to Kigali, I would say within a matter of 4 or 5 days. He was very worried about, and this was to deal with the tagging process and whether there was causing undue harm in the DRC and whether there was a knock-on effect in Rwanda. The OECD meeting had never been held in Rwanda before. They were very worried about what was going to be said and whether we, as the mining association, were going to be able to sufficiently articulate that there were challenges to the tagging process which were not being addressed. That was the sole topic of the meeting. If he sent this, I don't remember, but 100% we didn't discuss any of these issues because he had a much more important thing to worry about.
Well, none of this is true, and we're about to go and look at what was discussed at the meeting. But let's start, before we get there, let's start by seeing what you say in your witness statement about this letter. You say you've just given evidence that you don't remember receiving this message, but you in fact deal with it in your witness statement.
Okay.
Paragraph 38. So why did you tell the tribunal you don't remember receiving this message when it's one you actually deal with? So it's the first sentence.
Yeah, okay, I misremembered.
So first sentence.
We received a letter inviting us. Yeah, fair enough.
Well, it says what you say, in fact, is inviting us to discuss the terms of the long-term concession agreement.
Yeah.
But of course, if FTI can pull the letter back up. This is your witness statement. You can explain to the tribunal where in this letter there's an invitation to discuss a long-term concession agreement.
Well, it says during this meeting, we will discuss several issues related to mining activities of your company, including mining licenses.
Well, that's not an invitation to discuss a long-term concession agreement, is it?
That's your distinction.
Especially as you know that RD.
They're one in the
You
same.
finish. Especially as you know that RDB had only invited you to discuss at this point a 5-year concession agreement for Nemba. It's a misreading of a letter, isn't it?
No, I was leading the Mining Association discussions with the OECD. He had one concern. We believed we were going to be included as all the other long-term mining concession holders were in negotiations. We expected that we were going to be brought into that same kind of process. As far as I know, I'm 100% sure that the majority of the discussion was about what was going to be said, what our presentation was. We went through the presentation with him to the OECD meeting. It was very controversial at the time. He wished us luck. He needed us very badly. We were arguing that the tagging system created a de facto embargo, and he needed an explanation of what a de facto embargo was. And so that was the subject of this meeting. Whether you can parse his sentence to say mining licenses means it's not a long-term concession agreement, I disagree with that.
Now, you just gave another answer about the subject of the OECD meeting and tagging, and that's something you also said a little earlier in your evidence, a few answers ago, where you said they were very worried about what was going to be said, whether we as a mining association were going to be able to sufficiently articulate that there were challenges to the tagging process which were not being addressed. That was the sole topic of the meeting. That's what you just told the tribunal. But even on the basis of your witness statement, if we look at paragraph 38, you're dealing with a different topic of the meeting because it's about licenses on this version of events and negotiations for a long-term license.
Mr. Hill, if I might be permitted, I hate to interrupt you, but yesterday you were reminded about talking quickly. You talked so quickly that time, I didn't catch much of what you said. That's not as important as me just reminding you again. When you talk so quickly, it's very hard to follow a whole question like that.
Thank you, Mr. Kennedy.
So,
Mr. Marshall, to ask this question again, the answer you gave to the tribunal a moment ago about this meeting and its topic, you said they were very worried about what was going to be said and whether we as the mining association were going to be able to sufficiently articulate that there were challenges to the tagging process which were not being addressed. That was the sole topic of the meeting. But when we go to paragraph 38 of your witness statement, you describe a completely different topic of the meeting.
Well, with regard to the topic of the licenses, this was said. The meeting was almost entirely about the OECD delegation.
Can we go to?
It was enough for us because it was very reassuring. He needed our help. He reassured us that the language of the agreement would be continuing shortly. At the discussion of the language of the agreement would be continuing shortly.
What he in fact was said at this meeting was a number of things. First, he told you you'd been operating without a license since October 2012, correct?
No, never said that.
Secondly, he told you that could not continue and you needed to make a compliant application for a license.
Not at this meeting, he never said anything like that.
Thirdly, he told you that he considered that NRD did not have the capacity for 5 sites and should focus on 2, Nemba and Rutsiro, with redrawn mapping to exclude protected areas. Yes?
No, never happened. That was never discussed in this meeting. This meeting was almost exclusively about the OECD meeting coming up within a few days. It may have been a week, I don't recall. He did give us assurances as a way that to assure us, look, please, we know that you're helping us out here. Be patient, everything's working out.
Can you go to bundle R112?
Part of the reason for that, by the way, is they had nobody else to articulate a position for the Rwanda government on the tagging process.
This is R112. This is a minute of the meeting. And if you look at the second page, you can see it was prepared by Mr. Yes, we have both pages open. We can see this minute was prepared by the third gentleman on the list, Mr. Peter Martin Nyagina, who's the advisor to the minister. So it's his minute. And of the 3 points that I just suggested to you, if we can see them in the minute, we stay at the bottom of the page, having first recited the same points as was in the invitation letter. It says, Honourable Eminer continued his remarks by acknowledging the efforts done by NRD Limited, e.g. construction of the plant. However, he added on that NRD license was expired and not yet renewed. It is now time to get a new one. So you were told, weren't you, you needed to apply for a new license? Yes?
I believe that this is a fraudulent document. Some of the information in this document, I believe, is true, but not at this meeting.
He also said,
Minister Evode never told us it's now time to get a new one, except in the context of we can tell you that the negotiations will shortly begin with the RDB. It was not his staff, it was the RDB that was negotiating these things.
Next paragraph of the minute, there's a point about production. NRD's production considerably decreased all along this year. For this reason, NRD effort should focus to only 2 mine sites, Rutsiro, where the plant has been installed, and Nemba. However, the first mine site will be remapped to exclude the protected areas such as rivers and forests. So it's right, isn't it, as I said, that you were told to focus on 2 areas because of your capacity, yes?
It certainly didn't come up in this meeting, and I don't know that this came up in any meeting as articulated by Minister Evode. There are some elements in here, but they're from a later meeting after the OECD meeting. I can only think that maybe Mr. Peter Martin got his dates confused and what was discussed confused. Before these proceedings, I had never seen this, these minutes.
We can see
Ordinarily, you circulate them to both sides, and he did not circulate this to us.
Well, we can see that what was discussed is precisely the agenda in the invitation letter that he had sent you shortly before the meeting, correct?
I don't know if it's precisely, but it covers some of the topics that are in the agenda, but they were not discussed at that OECD meeting, at that precursor to the OECD meeting, sorry.
And then if we look at the paragraphs that follow, we can see that you and Ms. Moroskovica explain the steps that are being taken to try and gain control of your concessions with guards, yes?
Yeah, as I say, there are elements of truth to this, but they're not, this is not how it was discussed, and it was certainly not at this meeting.
And it was envisaged at this meeting that there'd be a series of follow-up meetings, although in fact only one follow-up meeting took place. Do you recall that?
I recall a meeting where it was discussed there would be follow-up meetings, and in fact, it is true only one follow-up meeting occurred.
And nowhere in this meeting is there a discussion of the OECD and tags and so on, which you suggested to the tribunal a moment ago was the sole topic of this meeting.
I'm talking about the meeting on October 30th. It seems to be a hodgepodge of a number of meetings. The October 30th meeting, we were completely consumed with the OECD delegation coming to Kigali and what the message was on the Rwanda side, and us as the Mining Association, how we would be representing those issues.
Well, you
All of
say
this
that, but
is
that's not
separate,
even,
and they're not. I'm sorry.
you say that, Mr. Marshall, but that's not even consistent with your witness statement. Let's go back to paragraph 38. Nothing to do with OECD and tags and so on. You're not even mentioned in paragraph 38. All you do is make a suggestion, an inaccurate one.
We're addressing here the long-term license issues. We had other meetings, we've had other discussions with him, which are not referred to in the witness statement.
You say on October 30th, that's the same date, we met Minister Evode and asked when we'd be issued the long-term license. He assured us the negotiations of a language agreements will be continuing shortly at the RDB office. Now, just pausing there, that evidence is inaccurate, isn't it? Because we can see from the minute that he in fact told you it was time to get a new license and that you should focus on 2 concessions. Yes?
You're sticking to a false narrative. The language in this paragraph talks about what was going to happen with the long-term license. The purpose of the October 30th meeting was only OECD. He may have made comment, Rod, please be patient. You know, this is going to all work out. The minutes that you have from the October 30th meeting never happened, not on October 30th. And I think mischaracterizations of a later meeting.
Now, we agree, I think, that there was only one follow-up meeting. And the reason that there was only one follow-up meeting was that at that meeting, you were insistent that NRD should try and hold out for all 5 concessions.
It never came up in any meeting I've ever had. Nobody ever said, Rod, we want you to take 2 instead of 5, or 4 instead of 5, or 1 instead of 5. Nobody ever did that.
Well,
Dr. Michael's letter from 2012 says that he had that conversation with me in his report to the minister. That conversation never happened.
Well, it was confirmed. That conversation was confirmed.
It was not confirmed.
Time going backwards, Mr. Marshall, but that conversation.
He said, I prefer, as you read in my letter. It's not the same thing.
That conversation was confirmed, and that position on the part of the government was confirmed by Minister Kamanzi's letter in January 2013 that we looked at, and it's being confirmed again at this meeting by Mr Eminer, correct?
No, as you'll recall, that Minister Kamanzi's letter says, I understand from Dr. Michael, you were offered 2 of the 5, or you would take nothing as a threat. And therefore, since you're not willing to take 2 of the 5, then you take nothing. And that never happened. That conversation with Dr. Michael, the precursor conversation, never happened. I was never offered 2. I was never offered 5. I was never offered any of them. I was offered a long-term concession license. You can include lots of things in a commercially reasonable long-term concession license, but that's not what this process was.
Now, despite Mr. Eminer telling you again in October 2013 that your license had expired and you needed to be applying for a new licenses.
No,
you didn't in fact
did not say that in that meeting.
You didn't in fact do so for nearly a year. That's correct, isn't it?
No, that never happened, and that conversation never happened in that meeting.
Now, I'm going to move to 2014, and you're aware, aren't you, that between February and May 2014, the previous 2008 mining law was repealed and a new 2014 mining law came into effect, correct?
I'll take your word.
Don't worry, this isn't a memory test in that respect. By 2014, you accept, don't you, that you didn't have any existing license because your last extension had expired in October 2012?
No, we were treated for all purposes of law as a long-term concession holder, as all other long-term concession holders were being treated. We were de facto long-term concession holders. We had fully performed. We were waiting for performance by the Rwanda government. At this time, I should add, Minister Evode decided that Ben Benzingi was the owner, so he stopped our tagging. We couldn't understand it. We were shut down, and we were the only people that process applied to. Nobody else was ever.
Now, again, Mr. Marshall, I'm going to stop you because that is not remotely connected to an answer to my question. We are going to come on to the tagging questions. You'll get your opportunity. Please focus on my questions. Now let's go to C063. This is a letter from Mr Eminer written to you in April 2014, inviting you to negotiate new mining agreements under the new law. You see, he says in the second paragraph, in this regard, the Ministry of Natural Resources would like to call your company, NRD Limited, as a former holder of mining licenses over the above mentioned concessions to renegotiate new mining agreements under the terms of the new regulations. And so we're now in April 2014, and by that stage you hadn't applied for any new licenses, had you?
We fully applied for long-term mining licenses under the old law. I see that he's making a representation that under the New York law, that those contracts are deemed void. That was not our interpretation. As far as we were concerned, our contract was fully executory. We had performed. We were waiting for Rwanda to perform.
Now, can we go to paragraph 39 of your witness statement? And keeping that, if FTI, if you keep that the previous letter on the page on the screen as well, so we can see both at the same time. You say in paragraph 39, on April 2nd, 2014, Minister Evode invited NRD to negotiate the terms of the long-term contract. Where do you say in this letter, Minister Evode is inviting you to negotiate the terms of a long-term contract?
In this regard, Minister of Natural Resources would like to call your company to renegotiate new mining agreements.
He's not saying anything about a long-term contract, is he?
Well, you mean, does it say the words long-term contract? No, it does not say the words long-term contract.
And you didn't apply.
Performed under our existing contract, we were still treated as, for all legal purposes, as the long-term, large-scale mining concession holder as defined by law.
And you did not apply for new licenses in response to that letter, did you? And had to be chased in August before making a new application in September of that year, correct?
We certainly were never asked for a new application. I don't think this letter is a request for a new application.
Now I'm going to come back to that point. I first want to go deal again with Mr. Benzingi, because by this stage we're in the middle of
negotiations will be chaired by the Rwanda Development Board for renegotiations of mining licenses, mining agreements.
I'm going to come back to that point in a moment. First, I want to go to Mr. Benzingi, because we're now in mid-August, the middle of 2014. Now, you'll recall we were looking at documents relating to Mr. Benzingi's attempts to have the RDB change the registered information in August 2012. And as we agreed, he subsequently commenced an arbitration. That arbitration came up for hearing in April 2013, correct?
Yes.
And if you go to C144, there's a letter here from you to the Arbitration Centre in Kigali, addressed to the chairman of the Arbitration Centre, in which you sought to object to the arbitration hearing by this letter, which you sent only the day before the hearing, correct?
That was the process.
You had been on notice of the hearing for some time before.
Our lawyer, Mr. Alois Mutawingwa, was giving us instruction on what this letter should say. As far as I can recall, he actually drafted this letter and it was submitted timely.
You had been on notice of the hearing for some time before that, hadn't you?
Yes.
And having sent this letter to the chairman of the Arbitration Centre, you didn't then attend the arbitration hearing, did you?
That was the process. You submitted an objection the day before the hearing under their law, and you do not appear.
You also, NRD had been aware of the arbitration itself from an early stage, hadn't you? And you'd participated in court proceedings relating to the constitution of the panel. Right?
I'm sorry, where are you reading from?
I'm not reading from anything. I'm asking you if you remember.
I'm sorry, you have to ask me again.
I'll put it again. NRD had been aware of the arbitration from the outset, correct? And it had participated in court proceedings relating to the constitution of a tribunal.
Yes, both. We had objected on numerous grounds because it was without merit, and we went to court to be able to argue that it was without merit and no basis for an arbitration.
Just to be clear, you didn't object to the idea of there being an arbitration. The dispute, we can see from the description of it, was as to the constitution of the panel.
No, we lost
NRD's. Sorry, let me finish the question. You can tell me if you think I'm wrong. NRD's position was that there should be 3 arbitrators. Mr. Benzingi's position was that there should be 1.
2 separate issues. First, we objected that there should be any arbitration. Secondly, the court, as I had been told, the court said, no, there will be an arbitration. Fine. Then we went back and objected as to what constituted who the arbitrators should be.
Now, if we go to the award itself, we'll have that in R013.
So just to be clear, we objected to Nellie. We were informed that we should not attend, and then Nellie issued this order after listening to Mr. Benzingi alone.
Let's go to the award, R013. Now, starting on the second page of the award, you see there that the, just give me 1 moment.
Ordinarily, the arbitration authority would suspend the arbitration until a determination could be made about whether our objection to the suitability of Nellie was appropriate or not. They did not do that, and that's the reason that the arbitration went ahead without us.
You can see what the arbitrator found, which is that the arbitrator, just pausing there, this suggestion that you went through the right procedure to notify the arbitrator, the chairman, of your objection and then didn't appear on, and that's your justification. That wasn't something you pursued on appeal before as part of your grounds of appeal to either of the appellate courts, is it?
I think we did, but I don't remember concretely. It was not
we have the judgments on both appellate courts in the bundle, and that point was never suggested as being a point.
I would be very surprised.
So if you had made the correct ground of objection to the arbitrator and it had not been considered, then that's obviously a point that would have been an available point of appeal, but it's one you didn't take, correct?
No, that's hypothetical. I don't know about it.
Let's look at what actually happened. We can see from the arbitration award. The arbitrator summoned both parties. Defendant neither appeared before the court nor notified the court of the legal, by which that's meant the arbitrator, the court of a legal reason for his absence before the arbitration tribunal. So you didn't notify the arbitrator herself, did you, of your objection?
That would have been our lawyer. I don't know who was notified and what the appropriate process is.
And then what happens in this award, and we don't need to go to detail of it, is that in substance, first the award found in favor of NRD and against Mr. Benzingi in an application for summary judgment, effectively, summary relief. But then it went on to consider the substantive claims, and it found in favor of Mr. Benzingi and against NRD. Fair summary, or do you just not know?
The determinations in favor of Ben Benzingi were very limited and did not affect the ownership of the company, which was the most significant issue.
Now, the upshot was that NRD had an award against them in an arbitration which you had been notified of, but chose not to participate in. Correct?
No, which we timely gave notice of objection to. As you can tell, I'm not a litigator, but our lawyers provided the necessary objection in accordance with Rwanda law. We believe that they had performed their services properly. We had no reason to know otherwise.
And it's right, isn't it, that the effect of the award was that the transfers of a shareholding to NRD, GmbH, and HS Stark were ruled null and void, correct? Those transfers.
The wording is something to that effect, although it is not clear what is meant by it.
Well, sorry, you finish.
Yes, we took this judgment to Mr. Sagano at the RDB, who's their in-house legal counsel specifically for the commercial registry. He prepared an analysis for us about what the effect of the decision was. And those determinations did not change the shareholding of the company. They did, for reasons which are not clear, appoint Ben Benzingi as managing director. Ben Benzingi had a fundamental problem with understanding that there's a difference between being managing director and being owner. So what the registry instructed us to do, and I think that's one of the exhibits to this process, was to have a shareholder meeting before the judgment was to become in effect, and that was to remove Ben Benzingi as managing director even before he came managing director under the order.
Now,
so therefore, it was all, it had actually no effect on the company.
The effect of the judgment, the arbitration award, was that the shareholding reverted back to the Zarnax and Benzingi, and the position of managing director reverted back to Mr. Benzingi. That was the consequence of the arbitration award, wasn't it?
That's not the way the commercial registry interpreted it.
And can you go to bundle R014?
She makes very odd, sort of undiplomatic comments like, I don't know what these people are doing here. So this is illegal. So for me, that was the reason we took it to the registry to say, how do we interpret this? What does it mean? We also took it to the Ministry of Justice and got the same instruction.
Now, we're going to come back to that evidence you've given. But first, let's look at the decision of the Commercial High Court, R014. This is dismissing NRD's appeal against the arbitration award. And I'm going to pick it up at paragraph 16 on the 6th page of the document. And what the court find is that later on, the arbitrator once again, through the court bailiff, notified the parties of the hearing date. NRD did not appear before the court. This is proved by the hearing setting orders. Declarations made by the representative of NRD, according to which the company was not notified of the hearing date, shall not be considered as true. So just pausing there, one of the grounds of appeal that you in fact advanced was that you hadn't been notified of the hearing date, even though you accepted today that you were, and the court rightly found that you were.
Yeah, I wasn't involved in this preparation or in his presentation of the court, so I was not aware of this.
And then at paragraph 17, referring to the aforementioned explanations, the court find it cannot, based on Article 47 on arbitration and conciliation in commercial matters, to annul the decision taken by the arbitrator, because NRD was notified of her appointment in accordance with law in force. The company did not start any procedures opposing her appointment as provided for in the aforementioned law. Now, it's also right to say, isn't it, that the allegation of bias against the arbitrator that you've made in these proceedings is not one of the grounds on which you appealed this arbitration award.
I was not handling this. I don't know what was said in those pleadings. I can read them and respond if you want to take the time, but I don't recall any of this. So
yeah. And in May 2014, the Rwandan Supreme Court also upheld the arbitration award. And it's right to say if you just don't recall, but I'm going to suggest it's right to say that no allegation of bias against the arbitrator was advanced in front of that court either.
That may well be. You know, the court decided that procedurally it had been handled properly, and so we had to live with the judgment.
Now,
it was on a procedural grounds that apparently appeal had been made, and the court affirmed that judgment.
Now,
that ruling by the arbitration court.
Can you go to bundle R032? This is a letter from you to the Minister at the RDB. Can you
Yes.
go to page 4 of the letter? You see, again, this is another letter copied very widely, including to the ambassador. And if you go to page 3 of the letter now, I'm just going to look at items C and D on this page. You say there, NRD company statutes require there be 3 arbitrators of international reputation, according to appointed to arbitrate between the parties. Ben Benzingi has both a personal relationship with Ms. Nelly Rwanda, and she has no international experience. This makes her unfit to arbitrate in this matter. And then you say, NRD notified Ms. Nelly, the Kigali Arbitration Centre, and the Ombudsman's Office and the US Embassy of our objections, and yet Ms. Nelly claims to have had an arbitration meeting without our presence and issued her decision. Obviously incomprehensible how there can have been an arbitration when only Benzingi was meeting with the arbitrator. Now, what you're not making clear here is that you did not challenge the appointment of the arbitrator through proper channels, and you did not make on appeal this allegation of bias that you're putting in this letter.
Yeah, I was not sufficiently familiar with what was being pled by our lawyers to know whether we had alleged bias in the case or not. I was not
And you
aware.
don't make, I'm sorry, I interrupted. You also don't make clear in your letter to all these people that you in fact appealed this decision twice and you didn't raise the allegation of bias. Correct?
I can't comment on it. I didn't know that we didn't raise the issue of bias. This is the first I've heard of it.
And you don't make clear that you were in fact notified of this arbitration hearing, chose not to attend it, and the Rwandan court was satisfied that you were notified. Yes?
Yes, well, no, you saw the letter where we were objecting to Nelly and we wanted a different arbitrator. We were instructed by our then counsel that we should not attend that meeting, which we did not attend. And then she went ahead and listened to Ben Benzingi and issued her decision.
And I suggest to you this is a misleading and tendentious letter sent to the RDB minister and copied to all these other individuals.
No, that's the best I understood at the moment. If I was misinformed by my staff about what had happened, then I was.
Now, you also met with Mr Eminer in a meeting at which you discussed the Benzingi issue, correct?
Yes.
And contrary to what you've alleged, he did not say that he had decided that Mr Benzingi owned 100% of NRD, did he?
I disagree with you. He absolutely insisted Ben was the owner of our company.
And you wrote a follow-up letter to him, which is very similar to the letter we've just looked at, in which, again, you did not make clear that Benzingi had an award from an arbitration which you had been notified of, but which you had chosen not to defend.
The arbitration award does not say that Ben Benzingi is the owner of our company.
No, I'm not on that point. My point, all I'm saying is you wrote a follow-up letter to Mr Eminer, similar to the one we've just looked at, in which you again did not make clear that Mr Benzingi had an award from an arbitration which you'd been notified of, but chosen not to defend. Correct?
Everybody was aware of the arbitration award. I'm not hiding anything. If you will show me the letter, I can respond specifically to your question.
Well, it's very similar to the one we just looked at, and you similarly repeated allegations of bias, which were ones you had not
Please show it
pursued
to me
before the
then.
Rwandan
Let me
court.
respond in a meaningful way.
Well, I'm trying to save time. You essentially cut and pasted the same
Well,
points.
then don't make the point if you're not going to back it up with something I can respond to.
Well, okay, let's look at C090. This is the letter.
Yes.
We go to it's a long letter, so I'm not going to take time on it. We start with the 5th page.
Well, it's an important letter. In fact, this is one of the most important letters of all, I think, don't you? This is
No,
where
because it's the same letter as we've seen, and it's one in which you make a number of points, but what you do not do is make clear that this was the position you are in resulted from an award in an arbitration which you had been notified of, but had chosen not to defend. First, just let me finish. 2 points you don't make clear at any point in this letter. First, that you had an award from an arbitration you had been notified of but chosen not to defend. Secondly, that the allegations of bias made in your letters are not ones you had pursued before the courts.
Mr. President, I would ask if we could get a clarification or correction. A number of these questions started with chose not to attend. This line of questioning put in front of the witness, objections that were raised, talked about hearings, talked about appeals. Obviously, there was a defense. At some point, the questions, and perhaps unintentionally, changed the word attend to defend. And I would ask that Mr. Hill really reconsider whether he intends to use the word defend after establishing it was defended, and instead revert back to attend.
Can I don't normally like Mr. Carey to interrupt, but I had certainly meant to say attend, and I thought I had said attend at each point. I'm not sure I ever said defend, and if I did, and if it's appeared on my transcript, I certainly withdraw that, and I meant attend.
Well, that's absolutely clear. Occasionally one makes a slip of the tongue in a lengthy case like this.
Well, I'm happy that an interruption actually served a good purpose.
Yes, it has on this instance.
I think it's important we not rush through this section, because this is the point when the company gets taken from us, expropriated from us, whether you can say it's by Benzingi or the RDB or the minister. This is where it's taken.
So, okay, so just pausing there, your evidence, your position is that expropriation has happened by this point. Yes?
No, you're missing the point. I'm taking, we are not in possession of our asset. You can use whatever word you want, and I don't want to be, biasing the proceedings by saying it's a different word. We were owners of this company, and it was given to Ben Benzingi, okay? For reasons we don't know. The minister announced in the meeting, which you have skipped over, the minister announced in the meeting, it got very hot and contentious because he was telling us we were dispossessed. The company was now going to be in the ownership of Ben Benzingi. We maintained he didn't have the authority to make that decision. We also maintained that it was a nonsensical discussion because it was not what the arbitration what the arbitration decision said. Even though Ben Benzingi and his lawyer were waving a document saying, no, Ben's the owner, and he got credulous people to believe it. So we were closed from our offices. We were shut out on June 11th. This is a letter of June 13th. And we were shut out from our concessions.
Mr. Marshall, the consequence of the award was that the shareholding reverted to Zarnax, to the original shareholdings. So what you did, the representation you just made about shareholdings was inaccurate, correct?
No, I think you are putting your judgment over that of the ministry and the RDB, who caved to us and said, no, we agree. This doesn't change the ownership. We don't know who the Zarnax are. We don't know who HC Stark are. Why would they come back at this point? Nobody said Ben Benzingi had more than a 15% shareholding. They were saying that somebody unknown hadn't bought with a bona fide transaction this company.
No,
someplace,
quite
someplace,
right. You're quite right about that, Mr. Marshall. No one is saying Mr. Benzingi had more than a 15% shareholding. That's common ground in this arbitration. There's no argument about that. Let's move on and go to
I think this is the critical point. I have to be able to say. So
well, that's, I'm afraid, not how the process works, Mr. Marshall. The way the process works is you answer my questions.
I'm answering your question, but you're rushing through the most critical aspect of this.
No doubt more time can be taken in redirect by your attorney. Let's go to R036, which is on a different topic. This relates to a grant, and it's a letter from you to Mr. Eminer. And you say, Dear Honourable Minister, as you're aware, NRD has received preliminary approval for approximately $1 million grant from the Dutch government's PSI programme for the Kikia-Nyota-Bindi area. This is a key element of $2 million USD funding for the project and will bring jobs, economic growth and development from the poorest areas of Rwanda. This, as you know, is in conformity with the EDPRS 2 Millennium Development Goals and African Mining Mission. We were greatly surprised when Dutch Embassy called us and said you had sent a letter to the Dutch Embassy which informed that the NRD concessions are expired. We met at length with the Dutch Embassy and Prime Minister's office. We found your letter was unfortunately misleading because you don't explain that all concession licenses are expired, but that NRD retains its mining rights pending receipt of a long-term license, all being defined terms under Rwanda law. Now, what you described something that Mr Eminer has said as being misleading because it didn't explain that all concession licenses had expired. But the truth is that your licenses had expired, and Mr Eminer by this stage had been repeatedly requesting you to apply for new licenses.
He never asked us once to apply for a new license. That's wholly apocryphal. And particularly at this time, he was, I would say, not responsive at all. We had been working diligently for months with this Dutch grant agency. It's a very lengthy and involved process. We were chosen the 7th most best opportunity for funding in the world. They're very excited about this because they had not invested in mining anywhere. So we were very excited. Minister Evode had said that they were expired. We were in the same position as all other large-scale mining concession holders.
He had made clear, hadn't he, as long ago as October of the previous year, that it was not appropriate for you to remain mining your concessions without applying for a license.
Never
That's
happened.
correct, isn't it?
No, that's a narrative that was developed later.
Well, that's something that's evident from the minute of the meeting that we looked at, isn't it?
I understand, and I'm telling you that those minutes are not an accurate reflection of what was in the meeting. They were never given to me, and under Rwanda practice, both sides have to approve the minutes.
Now let's look at C155. This is from Mr Eminer. He says he understands your concern in relation to the grant, but the ministry couldn't engage in any discussion with NRD until its issues of ownership and management are sorted out. And that's fair, isn't it? Because at this point, they're only in June 2014. There are essentially competing claims, both as to who is the correct management and as to what the right shareholdings are as a result of Mr Benzingi's award.
I'm sorry, but that's nonsensical. There was never any claim by Benzingi that he had a right to be, I mean, he may have thought he had a right to be the managing director, but he owned, according to the RDB, 0.2% of all shares.
The effect of the award was that the position of managing director, as a result of the award, reverted to him, correct?
And it's equally correct that the RDB instructed us to file shareholder minutes instructing that Benzingi not take that position as owners of the company. They recognized us as owners. They accepted our shareholders' resolution. And effective as of the moment Benzingi was to be appointed, they instructed us and we provided the corporate minutes saying that he was not going to be the managing director. Now,
you also wrote about the Benzingi situation to the Minister of Justice, Mr Businge, and we have that at R198.
Notwithstanding that he was not the owner and was not the managing director, he had possession of both of our, well, together with the bailiff, our concessions and our corporate offices.
So this is your letter
for reasons we still don't know.
This is your letter to the Minister of Justice, R198, and we can see there's a number of copies. We can see on the second page you also sent the same letter to Mr. Ambassador to the Ambassador. You see that on page 2 of the, if FTI could go to page 2. And you deal, it's a note from you, and you deal with the arbitration proceedings at item 5 of your note, which is the last page of the exhibit.
Sorry, this, just so you're aware, this is an honorary title. I've lost the ambassador letter. If you could go back, that's an honorary title for the head of the cabinet office. That's not an actual ambassador. He was not serving at this time as a Rwanda ambassador in any foreign country. That's an honorary title that he keeps whatever his position. The premature is the cabinet, as I understand it. Or perhaps it's the prime minister's office. I'm not sure which.
Let's look at the last page where you deal with your complaint about the arbitration.
But just so you're aware, at this time, we have nothing. We have lost all of our assets. We are being told by the police and the military and the bailiff, we have no rights to anything anymore.
Now you say there, Benzingi convinced, this is item 5, Benzingi convinced the arbitrator and the Rwanda courts that NRD had harmed him. Benzingi did not claim against the NRD shareholders themselves because then he could not seize NRD as his prize. Benzingi convinced the arbitrator to give him a default arbitral award when NRD refused to participate in a false arbitration proceeding. This was affirmed by the Supreme Court. Now, a number of points there. You don't explain there that what you describe as a false arbitration proceeding is one in which the arbitrator was appointed by the Rwandan court, correct?
It was not appointed by the Rwanda court. It is Ben Benzingi's personal selection. Under our corporate articles, there's supposed to be 3 arbitrators. Ben had chosen Miss Nellie, I think her name was. He would not accept any additional arbitrators to be appointed. That was the basis for our objection and the basis on which we didn't show up at her hearing.
It was a court-appointed arbitrator, wasn't it, Mr. Marshall? But you're right. You're right in saying there was an objection which you lost in court about whether there should be 3 or 1. But other than that, your answer is inaccurate.
I don't know that we lost that point. It was overcome by events. It was not a court appointed. It was a court affirmed. It was Benzingi's choice. He went to the court. He said, "This is my choice," and the court affirmed it. Nothing more. Didn't look at her. I don't know what process they followed. Take it back.
She was on a list of court-appointed arbitrators, wasn't she?
I have no idea.
And you don't explain in this letter, which goes to a lot of people, that what you describe as the false arbitration was the subject of court hearings which approved and determined the constitution of the panel, correct?
I'm sorry, you'll have to ask me again.
Yes, there were court hearings which determined, resolved on what the constitution of the panel would be. Yes?
Yes, yes.
And you also don't explain in this item that this was not a default award. There was, in fact, a reasoned award on the merits. They rejected, the arbitrator actually rejected the application for summary judgment.
Well, okay, I plead ignorance to litigation, but we objected to her as an arbitrator. We understood and were instructed that the process, when you do object, is you do not appear at the hearing, and that the hearing is automatic, by rule, automatically suspended until the head of the mediation panel can make a determination about it. That never happened. Instead, the arbitration, such as it was, went ahead. Nellie, who was a friend of Ben Benzingi's, issued the award she did. We objected to it on fairness grounds.
Well, again, you make this point about Nellie being a friend of Mr. Benzingi, but again, that's not a point that you pursued on appeal, is it?
I don't know that. If I knew, I certainly don't recall it now.
Now, you sent another letter to the minister, which you have at R201. Now, just scroll down the page because I'm going to come to the answer at the top. So you asked the minister, you see in this email, this is from you to the Minister of Justice, you make a number of recommendations about Benzingi's civil claim against NRD, including, if you go on to the next page,
I was going to...
a recommendation at item 5 that the Supreme Court decision should be vacated and cancelled because it's based on a mistake of fact about who is the correct defendant. And so what you're seeking to do is, because there's a result in an arbitration that you didn't participate in, you're now asked, and that, which is upheld on appeal, you're now asking the Minister of Justice to cancel or vacate the Supreme Court judgment. Yes?
I was asking him to examine the issues carefully. He's far more capable arbitrator, litigator than I will ever be. So I was giving him instances of what I consider to be unfair behavior. If you think that he's not capable of assessing those things, I think you're wrong. I think he's very capable of assessing what I say and what it means and whether it's appropriate or not.
Let's go back to the first. Sorry,
it's not false and was not misleading. I was addressing the issues as best I understood them.
Let's look at the first page.
Yep.
Over top, please, FTI. Receive a response on behalf of the Minister. Dear Mr. Marshall, a point I've made through my assistant very many times, the Attorney General cannot choose, decide or file any civil claims on behalf of any private individuals or companies. I'm hoping your company lawyers can translate what is contained in your email as civil claims into one or more civil actions, cite the relevant provisions of a law, build the evidence to prove your claims and file them in the appropriate courts. Secondly, what you think are criminal activities can only remain potential criminal cases until again your company files criminal complaints with the relevant agencies as by law required. And that's a fair and reasonable response from the Minister of Justice, isn't it, to your requests?
Well, obviously, I thought it was unfair.
Now, I'm going to change topic and pick up some points about the bailiff, Mr. Bosco.
Mr. Hill,
yes.
Before you leave this topic, can you help me with it?
Yes.
As I understand it, or my understanding was that the issue in relation to this part of the story was whether Rwanda, the state, was complicit in the activities of Mr. Benzinga.
Yes.
That issue I fully understand. But the decision of the Supreme Court purports to find that the transfers of shares upon which the claimants rely in this case were ineffective, that the Zarnaks remain the ultimate owners of NRD. And if that's right, then Spalena has no locus of any kind.
Yes.
Now, we are going to need some help as to whether we look beyond what I would call the pleaded issue in relation to Mr. Benzinga, because it seems to me that nobody's really focused on the nature of these proceedings beyond the issue being whether the ultimate authority for what Mr. Benzinga was doing was the court or was the state. Now, if no point's being taken beyond that issue, I'm sure we can deal with that issue.
I think probably the answer is, I may come back to you at some point if I need to. I think the answer is we made a number of points by way of preliminary objection, which go to standing. I have to accept we have not run that point. And as a result of which it's not been debated, the memorials haven't covered it as an objection from us. And in those circumstances, unless I come back to you, we're resting our objections on all the other points we have been taking. And we're not saying, we're not going to belatedly say this is the knockout blow and that's it.
And at the end of the story, Rwanda seemed to have been treating Mr. Marshall as being the gentleman with authority to take decisions for NRD, not Mr. Benzinga.
And I'm obviously proceeding in all my questions on the basis that on that assumption. So I'm not advancing that as a belated knockout blow. And no doubt Mr. Cowley would say it's rather unfair for me to bring it up now if I were to try and run it late.
And Mr. Hill, I would be grateful also if you would revisit your submissions under the heading lack of jurisdiction, ratione personae, and really sort out exactly what the case is in relation to Benzingi.
Yes.
Because I do find it difficult to ignore what appears to be in evidence in relation to a very important point.
Understood.
Can I have
It's probably a good time to
clarification?
take a break, isn't it?
Oh, exactly. Let's take a break. Thank you.
30 minutes.
Can I raise
Yes,
one point
thank
of housekeeping?
Yes, of course. Sure.
This is just on the outstanding request from Mr. Cowley in relation to the metadata on his side. The reason it arises is we've got an obligation to put in a witness statement from Mr. Ehlers about the document.
Yes.
Mr. Ehlers' position is that he said in his first witness statement he didn't recall. That's still his
Yes.
position, and it is fair that he gets to see the full document and the native form, if in order that he can grapple with it in his witness statement.
You're asking, I'm sorry, the question to me is, what's the timing of our transmitting that over?
Yes, I think so.
Yes. Then after this hearing, I've scheduled a meeting with online meeting. Mr. Marshall will be logged into our computer system, which he's not now. And our IT staff, which actually sits in Philadelphia, will work with Mr. Marshall on our computers, so they'll make it happen for him. A downloading of the email, his emails with metadata. You made the point yesterday that you thought we already had the email with metadata. We don't. We have an email to us with metadata. And as I understand it at a very high level, the metadata on our system to the email sent to us is not going to, it's going to have some differences between the metadata of the original email. So It's not the same. We need to get that, and it's scheduled to happen after this hearing. And then we'll follow right up.
I wonder if I could just have an extension for the Ehlers witness statement till Friday then. At least that then gives us a chance to get the document and then deal with it.
I think that's all right.
No objection.
Grateful. No, nothing else from me, Mr. President.
No, then let's carry on.
Okay, we're bringing the witness back in.
Mr. Marshall, I was going to pick up some points with you about Mr. Jean Bosco and Sengi Yuma, the bailiff. Now, I'm going to try and take it in stages. You accept, don't you, that he was instructed to enforce the judgment debt for a salary claim on the part of a former employee, Pascal, yes?
That's my understanding.
Yes.
Pascal is it's not clear on what the judgment was based on, but that's not your question, so please go ahead.
Yes. And one of his actions as bailiff was to seize some mineral. This is in connection with that judgment, was to seize some minerals which were stored in the warehouse of Mineral Supply Africa, correct? Do you recall that?
He had several seizures. That was not the first one. His seizure of I'm sorry, but
yeah, just it's quite a convoluted story. I'm not going to try and cover all of it with you. I'm just going to capture some elements of it. One of his actions was to seize some minerals which he considered to be NRD minerals stored in the warehouse of Mineral Supply Africa. Yes.
At what date?
I think it was 2013, but I'm not sure of that. Certainly before 2014, when he came back in connection with Mr. Benzingi's judgment and the judgment of some 25 other employees. That's 2014. So I'm dealing with before that.
I don't think so. But that's the reason I asked, is I think that it was all at the same time. But please, if you would check it.
I will check. I'm going to continue. It's mid-2014. I think you're right, Mr. Marshall. It's also 2014.
But do you know what month?
Which one? No, I'm going to come back on the exact month. I'm just going to ask if you recall the events, and then you may be able to help me on the right month. So the story is that the minerals had been moved there by Mr. Kibelinka of NRD. NRD and certain of the individual miners took court proceedings to challenge the enforcement on the basis that the minerals were not NRD's at all, but were still in the ownership of the individual miners because they hadn't been paid. Do you recall that saga?
Yeah, but that's not the way it works. Kibelinka was gone at this point, so it must have been somebody else. I do recall a saga where Bailiff Bosco attempted to seize minerals that belonged to the miners at MSA. And where the ambiguity comes in is all mining, as I say, is artisan support mining. As a matter of law, I understand the minerals belong to them until they're sold to the trader. They don't belong to.
Exactly. We're talking about the same thing. So the dispute, which the court eventually ruled on, related to whether the minerals that had been moved to the warehouse belonged to NRD, who had tagged them, or still belonged to the miners up until the point they were paid. And
up until the point of the sale.
Up until the point of sale, sorry. And in the end, the court ruled against the bailiff. Yes, sorry, it was 2013, and just feel we can go to document in a minute. The court ruled against the bailiff and decided that the minerals were ultimately still under the ownership of the miners. Yes, so it's in a sense NRD and the miners won that court battle.
Okay, I'd have to see the documents, but I get the gist of what you're saying. So
you can see, just so you can see the judgment, it's at R055. This is where NRD and the miners succeeded in their claim that the so this is suspension of seizure and auctioning of minerals currently hands of MSA. And then if you go to the end of the judgment, it's on the last page, what happens is the court this is an April 2013 judgment. The court ultimately confirms the validity of the miners' assertions of title to the minerals. It orders a suspension of the execution on those minerals, and that's the order of the court.
Yes.
And the reason I'm taking you to it is that there was no impropriety at any stage or anything corrupt or improper or wrong in anything Mr. Bosco was doing. His position was clear, in that he was only purporting to execute on the minerals on the basis that they were NRD's property. And all that happened was that someone was able, NRD and the miners acting together with the same lawyer, were able to establish that the miners had personal title. Yes?
No, but not with regard to this case. Bailiff Bosco was exceeding his authority for several months already at this point. Pascal had been a contract employee of H.C. Stark before we got there. So this was a Stark liability that was now our responsibility. He is the nephew of the Minister of Defense, and he brought a claim for wrongful dismissal and was awarded the unprecedented sum of $120,000 when an average judgment for such claims is $2,000. He was by far the largest recipient of a wrongful death claim. So John Bosco, Bailiff Bosco, began seizing different assets from NRD claiming that they all had to be to satisfy this debt, which was largely, as we saw it, a political calculation by James Kabarebe, and therefore we objected and were not cooperating with the bailiff at that point.
Now, just looking at what you said there, from the
He had already seized more than $120,000 at this point.
From the position of the bailiff, he was at all points acting lawfully and on the basis of court judgments that he had, wasn't he?
No, he was not.
And afterwards, leaving aside that claim, he was also appointed in 2014 as bailiff to execute on Mr. Benzingi's judgment and the judgment of some 25 former employees, correct?
Yeah. Well, but your characterization is a little misleading. He is hired as a debt collector by these individuals. He has a contract with them. It's not a court appointed. While his function is court appointed, his job on behalf of any debt holder is by matter of contract. So he went around and was able to gather up these individuals. As I say, he would never provide us with any court documents or any judgment information. We never knew what it was about.
He was enforcing on judgments that he had, wasn't he?
He had been contracted by some debt holders to enforce on judgments and went way beyond his authority. It didn't follow any of the due process rules.
And I'm going to suggest that at every stage, Mr. Bosco was following the due process rules and he was acting entirely within his authority as bailiff executing judgments. And that's right, isn't it?
I'm sorry, you said you're going to make that argument. It's not possible, but you can try.
Well, let's look at paragraph, well, first I'll say the creditors who instructed Mr. Bosco were not the only creditors. NRD also owed money to Mineral Supply Africa, correct? We've looked at that yesterday.
No, we had a line of credit with Mineral Supply Africa. We did not owe them money. There was nothing due under that letter of credit.
If you go to R115, this is a legal letter, essentially a letter before action from Mineral Supply Africa. If you could scroll down, please. We act for and on behalf of our client, Mineral Supply Africa. And with reference to with reliable documentation, it appears to us you failed to reimburse to our client the outstanding balance of 601,000. So by this point, you've run up a debt to Mineral Supply Africa of 601,000 US dollars, correct?
That's what it says, but that's not correct.
Coming back to Mr. Bosco, can you go to R074?
Can I explain what this is about, or do you want to move on?
I would like to move on. Can you go to Mr. Bosco, R074? This is a notice from Mr. Bosco to all of you, Mr. Moroskova, Ms. Morosova, and also Mr. Benzingi, and as representatives of the company, requesting that you present a letter of attorney which would permit you to speak on behalf of the company. And what he's doing in this letter, can you just scroll down, please, FDI? He's informing you about an auction that he intends to hold, and he identifies indebtedness he is seeking to satisfy, and it includes 28 million individual claims, sorry, 28 people with individual claims, and a claim from the Rwandan Revenue Authority representing over 1 million francs. Yes? Do you recall that?
Absolutely not.
But it's a notice that he
prepared in preparation for this hearing.
So you're suggesting this is another fabricated document, are you?
Yes, I do. And it certainly was never delivered to us. If he prepared it and put it into his file cabinet, I wouldn't know. I was never until this very moment aware that he claimed to represent the Rwanda Revenue Authority. This is one of many examples, and he explains them in his witness statement, where he's acting in a regular manner and observing his duties as bailiff. Yes? All bailiffs are contract bailiffs. Did he receive a contract from the Rwanda Revenue Authority? I never heard of it. I don't know, and I'm sure that the 28 people, we don't know any of these. He never delivered any document to us which would give us evidence of any indebtedness. The Pascal decision we knew from the court, but all the rest we did not.
Can we go to C71? This is a letter from you to Mr. Buzingi.
No, this is to Johnston. This is the Minister of Justice.
Sorry, Mr. Marshall. So looking at the first 3 paragraphs of this letter, you're updating Mr. Buzingi on what you describe as the criminal acts of Ben Benzingi and others, and you refer to taking possession of the property, and then you refer to complaints to the Ombudsman office. And then you say, we had discussions there today, and as a result of these discussions, we were advised to send you this request. Bailiff Untitled Chapter tried to have an auction of the entire property of Natural Resources Development Rwanda Limited last Friday. That auction was cancelled because nobody came to the announced place. Just pausing there, you were aware of this auction that I've just taken you to in the letter because you deal with it in this letter from you.
You're being very
Mr. Hill, before he answers, I think you're going to like this interruption again. I think you want to correct. You started that question by saying the letter was to Mr. Benzingi. I don't think you meant that. You might just want to look at the transcript.
I hope I said Mr. Buzingi.
Oh, I'm sorry. I apologize. I misheard you.
Yes.
It's easier to call him Johnston. That's what it's colloquially called.
And then you say, Ombudsman Office told us to write a formal request to suspend the auction until this case is solved. If the auction goes ahead and all the assets sold, damage will be irreparable. This is a formal request to suspend the auction of the property of Natural Resources. And what you neglect to mention in this letter was that Mr. Bosco was simply acting as a bailiff enforcing court judgments that he had. Yes?
No, sorry, 2 corrections. One, his job is to act as a debt collector. His title is bailiff. He collects on behalf of any, in his function, he could be collecting on behalf of any legal debt. In this case, he claimed that they were court orders. There's a highly regimented process in Rwanda where you're given notice, you're given information about what the claim is, you're given the opportunity to discuss with whoever the claimant may be. That has its own internal formal process. He then has to give additional notice. He has to be able to say whether agreement was reached or not. He then has to give notice of an auction. There are commercial terms for that auction. And there has to be so many participants. It has to be at such and such a percentage of the value. Following up that, if there is a sale pursuant to such an auction, he has to provide details and evidence of what happened to the proceeds. Never did he do even the first of those steps. He comes around and is acts like mafia and waves a document, said, I have a list of people who you or start before you owe, and that's as far as he ever went. There was never a legitimate process with Bailiff Bosco.
Can you go over the page here? You say this letter is also to respectfully request your office suspend the mandate of Bailiff Jungsengiyuba John Bosco with regard to NRD and its assets until the matter of the bailiff's fraudulent sale of NRD minerals as reflected in the attached court decision is fully investigated and resolved. And that's a reference, isn't it, what you call the fraudulent sale of minerals? Isn't that a reference to the MSA story that we've already looked at, where Bosco was in fact, no?
No, that's a different transaction.
But at all times.
In that case, he was able to seize the minerals, bring them outside the compound, the MSA compound, and he claims to have had an auction, and we were never given notice or information about it. And he went off with the money. We don't know what happened to the proceeds.
Well, that's not right. We know that the MSA Minerals is just one story. We know how it ends in the end, but we also know that at all stages in that story, Bosco was acting in accordance with his duties and his perception that these were NRD minerals because they had been tagged by NRD. Correct?
No, you're confusing two incidents. He tried, is my recollection, it may have been more than twice, but he tried to seize minerals at the MSA compound on more than one occasion. This one, I think, is referring to that instance where he was able to get the minerals outside of the MSA compound, and he had an auction on the street. We were never informed. We were never consulted on any of it. We have no idea what happened to the proceeds.
Now, after receiving this letter from you and with your description of what Mr. Bosco was up to, Mr. Bisingi, the Justice Minister, did in fact suspend Mr. Bosco's powers to carry on with his execution, didn't he? We can see that at bundle C072. You remember that?
He did temporarily.
And if we look at this document, C072, that's in Kenya, Rwandan. I'm not sure if the English is in the same tab or not. It is. I think it might be in the same tab.
Don't forget, I want to alert you that this date, so this is July, they're still in possession of our entire company. So just
focus on my questions, if you would.
I have to interject because I'm not even sure that they consider us to be owners of the company at this point. So you can say that, well, fine, you made these complaints, but I'm not sure we were recognized as the owner at this time.
So just looking here, what the Justice Minister in fact says is he addresses Bosco and he says, based on the letter of 14th of July 2014, so that's the letter we just looked at, addressed to me by NRD Rwanda, asking me to stop the auction of our assets you were anticipated to carry on and to stop your projects. And then he says, after examining all issues that are based by way of execution of judgments lost by NRD is being carried out, after hearing what different bodies who observed by closely the activities you carried out related to the execution of judgment between NRD and Ben Benzig and others that they mention, I find it concerning these ways in the way these judgments are being executed. For that reason, based on the responsibility of the Ministry of Justice Services or the Attorney General to establish and inspect the execution of laws and justice to all, and in order to respect justice for all beneficiaries of the execution of judgments against NRD, namely NRD themselves, Ben Benzingi, employees who brought and won legal cases against the company, you are currently suspended from all activities to do with execution of judgments against NRD Rwanda, so that the status of issues in question may be examined to know if they are disputes to be brought to the courts or functionality and management or mindsets among all who have interest in the case, so that you'll be able to continue in peace the activities you are carrying out. So it's a temporary investigation, suspension, based on, in part, on your letter and while further investigation is carried out, correct?
That's right. We're very grateful that he was willing, for this purpose, to consider us at that time the owner of NRD.
And then we go to C073. This is a letter this is after further investigation from the Minister of Justice. He says,
what's the date of it? Can you tell me?
This is 26th of August. So it's about just over a month later.
26th of August.
He says, Dear Madam Sir, reference is made to my letter dated 23rd of July, which suspended temporarily the execution of judgments and arbitration awards rendered against NRD Limited. Reference is also made to a number of judgments, around 15, and an arbitration award pronounced against NRD Rwanda Limited annexed to the present letter. Further, reference is made to lots of correspondence you have addressed or copied to me recently. In light of the above, we have studied the problem and come to the conclusion that NRD Rwanda has A, corporate governance issues, which is their duty to settle or seek resolution of the pending ones through legal channels. Over this, the Attorney General has no power. B, legitimate judgment creditors who won cases against the company and must be paid. In respect of A above, I find the Attorney General has no power to enforce solutions. Legal channels exist. And Mr. Bosco's powers, sorry, I should just say, in respect of B, you are kindly advised to voluntarily execute the judgments and awards, because short of that, the company's seized assets will be liquidated to settle these judgment debts. So he was explaining that on investigation, the Ministry of Justice was satisfied that these were legitimate judgment creditors and therefore that Bosco was entitled to execute, correct?
No, because you've lost the timeline here. What has happened, our company was seized about June 11th, 2014 by Bosco and Ben Benzingi. During the next 3 months, they looted our concessions, they stole our assets, and whether he called it execution or not, he sold our assets. By the middle of August, at the same time as this is going on, we're giving assistance to the military because they were interested in procurement of military assets from the West, and that will become important in a second. The military was with Bosco and the bailiff. We were dispossessed of our entire company. We were not recognized as owners for any purposes. So the fact that at least nominally the minister was willing to recognize this for purposes of these communications, we were appreciative. During that 90 days or 60 days, they looted the concessions, they looted our office, they had riots. One man was
Mr. Marshall, I'm going to stop you because this is not an answer to my question.
I have to insist. You won't understand this letter unless I explain this. Please bear with me for 2 more minutes.
Well, no, it's not a question.
I'm sorry. You have to understand what happened. This letter is after we got our concession back and after the killing stopped. 40 people were murdered. 40. We were out of the concession area. We were left alone. Do we suspect that maybe the military took us out of there and gave it to Benzingi while the killing was going on? We don't know. It was absolutely the most terrifying time in my life.
Mr. Marshall, what the Minister of Justice is explaining is that his department have examined the issues and they are satisfied that these were legitimate judgment creditors and therefore that Bosco was entitled to execute. Correct?
No. Their execution was on our concessions. They took over $800,000 worth of equipment, fencing, other supplies. That was an execution.
And all of Mr. Bosco's actions at each stage were the lawful actions of a bailiff, weren't they?
No, we never got one notice. We still don't know what those claims were. We know the Pascal claim.
And they arose because of a series of judgments against NRD, as a result of which NRD was a judgment.
Series of so-called judgments which were not made available to us. We have no idea who they were or what those claims were. And the seizure of our NRD concessions was a taking in the sense of that was how he was going to auction assets to pay the creditors. And it was far less. It was maybe $30,000 in total. And instead they took the whole concession and sold some by auction, some by theft, some by whatever means. And only in August 22nd did we get it back. The delegation arrives with the military on the 24th, and the military calls us up and say, please come and take responsibility for your concessions. And at that point, the killing stopped.
With that answer, I don't accept any of that at all, but it has nothing to do with the question that I asked. I'm going to move on. I'm now going to go back to the topic of the licenses.
Seizure, isn't that responsive?
I'm going to go back to the topic of the licenses. You'll recall that you had been invited in April 2014 to apply for licenses under the new rules. We looked at that earlier, yes? You recall that letter? By August 2014,
nothing came up, I'm sorry.
By August 2014, you had not made any application for new licenses, had you?
We had been making it, our application goes all the way back to 2010. No document came up. I don't know what you're referring to.
Please go to C064. This is a letter from Mr. Eminer to NRD, in August 2014. And you can see that it's addressed to the company and not to any individual at the company in particular. Do you see that?
Yes.
He refers in the second paragraph to the fact that the license has expired. Further reference is made to the letter of Honourable Minister of Natural Resources dated September 13th, 2012.
I'm sorry,
extending
what's the date of this letter? I don't mean
This is August 2014.
I understand what day in August.
I will come back to you and tell you the answer to that. I don't think it matters for my questions, but tell me if you think it does when I ask them. By 18th of August. Now, so he says further reference is made to the letter of Honourable Minister of Natural Resources dated September 13th, 2012, extending NRD's licence for 3 months, expiring in October 2012. So he's referring there to the fact that the licence has expired, yes, in October 2012.
He says that extension expired in October 2012.
Yes, and then a little lower down the page.
I don't know that he's saying that all of the licenses have expired. We interpret it as executory, as I think I told you.
A little lower down the page, he then says, considering the fact that the negotiating process for the possible renewal of mining license for the above mentioned concessions has stalled, did not yield any positive results since its initiation in 2012. And then he refers to the new mining law. And then he says at the bottom, I am requesting NRD Limited to reapply for the licenses of some or all of the former mining areas. The list of what is required in this application is attached to this letter. Each concession is a separate entity and should be applied for individually. This application should be done within 30 days. Each application will be assessed on its own merit. It is key to note while applying that the government is looking for optimal investment in each of the mining areas mentioned above. So he's requested you again to apply for licenses, correct?
It reads that way under the new law.
He makes clear that the application should be made within 30 days, will be assessed on its merits, and should be done separately for each of the concessions, correct?
That's what I read.
And he also provided an annex, didn't he, which gave you a detailed list of what was required to support the application, correct?
I don't see it, but he may have.
We can go through it. If the FDI keeps going down, you'll see the annex, which might prompt your memory. You see there?
Mm-hmm. Okay.
So that was the list of targets you had to hit for the application.
May well be.
Yes.
But you'll understand, of course, that there were two issues that we were facing at this time. One, we did not have any access to any of our documentation. We were strictly custodians of the mining concession at the instruction of the Rwanda military. We had no other documentary evidence of anything. This letter was sent to many companies, but not to the concession holders, except for us. Rutongo was in exactly the same position and did not have to reapply.
Rutongo, by this point, had a well-advanced license application, which had been on the cusp of receiving, for some time, had been on the cusp of receiving long-term licenses. They're in a completely different position from you.
That's absolutely untrue. They didn't receive their license until the beginning of 2015, and you can question Kevin on it.
And you've alleged that Minister Baruta told you that the reapplication was a formality, but that's not true, is it?
We had the conversation with him. He absolutely reassured us that we'd been mistreated, and he was going to, in fact, his words were, as I recall, as long as I am minister, you're not going to lose your long-term concessions.
What he in fact would have said is that as long as you comply with the law, you would be treated fairly.
No, he did not. And it was a very different conversation. I beg to differ with you. You were not there.
And Mr Eminer's letter made it clear that each application would be assessed on its own merits. So you had to make an application that hit the targets that he had identified and would be considered on its own merits, correct?
I don't see that, but
that's what he said in the letter. Each application will be assessed on its own merit.
Yeah, for me, we were being treated differently. We were being asked to reapply for something that we had already fully satisfied our obligations under.
And you had no doubt at all, did you, what was required because you were told specifically what was required?
No, that's simply not true, and you weren't there. We had a terrible time with Minister Evode because he was off on his own frolic. We had started with an indulgence. Yes, we'll bring money, we'll bring investment, and now they're again looking for an opportunity, an excuse to be able to say, "Oh, you failed, and now we're going to keep everything without compensation."
Oh,
for legal
just
purposes.
To be clear, Mr. Marshall, my question is: you had no doubt about what was required because he told you in his letter what you had to do and gave you a list of targets to hit, didn't he?
I understand, and I'm telling you that we had communications with his office that this is not, it must be intended for other people, but not for us, because you know us, you know what we've invested, you know what research we've done, and what is this formality?
No, you've just invented that.
That's why we went to Minister Baruta and asked him the question. And he gave us absolute unconditional assurance we were not going to lose our licenses.
You just invented this story about other people in Minister Eminer's office telling you it was a formality or whatever you just said, because the only evidence you've given before is that Minister Baruta said something, and now you've invented something about other people in Minister Eminer's office.
What was my quote? I don't know.
Let's look at your quote. You said, "I understand, and I'm telling you that we had communications with his office, that this must be intended for other people, but not for us." And you've just invented that, haven't you?
So we believe that to be true. We believe that to be this is a generic letter written for people who have just arrived in the country, not for somebody who's already been here for, at this point, it was 7 years. This is it's written as if they don't even know who we are or what our name is.
No, again,
I would like to point out to you that for example, Musha, another concession holder, arrived and 3 months later was awarded the 30-year concession without any investment or any research. So there's very desperate treatment between people who are applying for licenses. At this point, we had a problem with Dr. Michael, and they were trying to create a false test process, which they would then declare we failed.
You say a false test process, but you've just said, even on your own evidence, that this is something that other people were required to comply with. It's not bespoke to you.
As if you've never known them before. They've known us. They've seen our work. They've seen our investment.
But your work's been considered inadequate before, and you've been repeatedly told to apply for licensing that you haven't done.
If your point were true, then you would think that they would have a narrowly tailored conversation about what needed to be done differently. Not, please tell us your name and do you have any bank accounts?
Now, I'm going to come back to the application you made. Let's go on to the story of tagging, because we're now in the summer of 2014. And one of your complaints is that in this arbitration is that from the summer of 2014, Mr. Eminer was unwilling to provide tags to NRD for the mineral tagging system. Yes, that's one of your complaints.
Yes, I think it began in March. Well, the way the tagging process worked is that some tags were a quantity of tags, if there was a secure place at a mine, would be kept at that mine site. So even though Minister Eminer instructed that no tagging be done on any of our concessions anymore, it took some weeks before it fully kicked in and we were completely out of tags.
Now, the tagging system was intended for licensed operators, wasn't it?
All operating mines had tags.
No, just answer my question. The tagging system was intended for licensed operators, wasn't it?
All companies in our position had tags.
If you go to Mr. Nayan Sarbert's supplemental witness statement, at paragraph 16,
Forgive me, that name one more time?
Nayan Sarbert, N-I, neon on neon.
Thank you.
N-I-Y, yes.
Thank you.
Paragraph 16, he's the man who's the packed itchery man. He explains in paragraph 16 that myself.
Supplemental?
Sorry, supplemental. I'm so sorry.
This is the supplemental.
Exactly.
witness
Tags
statement.
are only issued to licensed mining operations. So the way the scheme works is you need to be a licensed operator in order to have tags, yes?
We were the only mining operation in ITRI history that had our tags withheld from us for no reason.
Well, your license had expired and you had been asked to apply for new licenses and you hadn't done so.
All licenses had expired. We were in exactly the same position as every other company.
You'd been asked to apply for new licenses and you had not done so.
Rwanda was in the same position. They had no license.
Rotungo had applied for new licenses, hadn't they?
With the same application we had given. Not
remotely the same application you had given, because your application had not been accepted and you had made no renewed application as you'd been asked to do by this stage repeatedly, correct?
No, it's completely misrepresentation of the fact pattern. And more than that, as Dr. Michael kept saying, look, these are half of all the mining areas in Rwanda are being held by NRD. And by withholding tagging from us, that meant effectively the tagging system had no effect in Rwanda.
And by the summer of 2014, you should have been applying for a license, shouldn't you? And you'd been asked to.
It was you're misrepresenting. He didn't ask us for anything. He said, Ben Benzingi owns your mines, and therefore we're not going to give you tags. He later came up with the argument that the tagging license hadn't been applied for, and he wanted to, as he put it, regularize our licensing position.
One of the points about making an application for a license is that that's the process by which the government gets to determine whether you're entitled to a license, whether you're a worthy license holder, correct?
You'll have to rephrase the question, I'm sorry.
One of the points of having a license is it's a process by which the government can make an assessment about whether you deserve a license and you're a worthy license holder, correct?
Yes. Within the indulgence that we started off with from the beginning, please come and invest, and the license will follow.
And Mr. Eminer, I'm sorry, I cut across you. Had you finished?
Please.
Mr. Eminer explained to you in September 2014 that there were two impediments to him providing with tags. The first one was that you did not have a license, and providing you with tags would just be encouraging you to carry on as an unlicensed operator, making money out of non-industrialized artisanal mining and not bothering to apply for a license. And that fairly summarizes what you're up to, doesn't it?
Absolutely not.
And that would be contrary to the scheme of the ITSC system, wouldn't it?
No, the ITSC system is, and I'm sorry, I don't want to lecture you, but the ITSC system is tags are withdrawn from those companies who violate ITSC rules. No other reason. We are the only company who, Mr. Evode say-so, had the tags withdrawn. No other company in the history of the ITSC program did that happen to.
Now, the second point that Mr. Eminer made is that Mr. Benzingi had the benefit of this arbitral award supported by court decisions, and the effect of that was that you were neither the lawful management nor the correct shareholders of NRD, and that was a fair summary of the consequence of the arbitral award, wasn't it?
No, obviously not, because the registrar didn't change the registration.
And Mr. Benzingi was...
Mr. Benzingi at the end, before and after the arbitration, still held 0.2% of all shares.
And at that point, Mr. Benzingi was himself threatening proceedings if GMD issued tags to you or to you as purported controllers of the company, such that Mr. Eminer was at that stage faced with competing claims, wasn't he?
No, I never heard that he was going to bring a claim, but I wonder if I had threatened to bring a claim, whether he would have reversed himself. So as I take it from your comment, if you threaten suit, then they buckle and say the owner is not the owner and we're not going to give tags to anybody?
It's not just a question of threatening suit, is it, Mr. Marshall? Mr. Benzingi at that point had a Supreme Court judgment which validated his position, didn't he?
No, you just said that Minister Evode was faced with the threat of a suit from Benzingi.
Yes. He was faced with competing claims, and one of the claims on the other side to you was a claim from someone who said he shouldn't be issuing tags to you because you weren't the lawful controller of the company, and he had a Supreme Court judgment to back him up.
Under Rwanda
That's
law,
fair.
no, under Rwanda law, the registrar of company registry is the one who records who owns what. It's not a matter of ongoing debate to be determined by a minister of mining.
Now that's your legal.
We were the owners of the company. Ben Benzingi was not the owner of the company.
Mr. Marshall, that's your legal proposition about the effect of Rwandan law. But that's actually not the effect of Rwandan law, is it? The judgment of the RDB is not determinative, is it?
First I've heard of it.
Now let's go to bundle R0.
On what basis do you say that?
R203. This is the note of a meeting with Mr. Eminer in September. And can we look at what...
Can we say that the reverse is true by your supposition?
I'm not answering your questions, and that issue on Rwandan law is actually one of the legal matters for the tribunal.
No,
So
but
I'm
I just don't understand the point. What you're saying is that...
No, I'm going to ask you, I'm not going to engage in debate on this, Mr. Marshall. I'm going to ask you a question about the next document, which is R-203.
Well, no,
This is the note of the meeting
I need
that
to
you
understand.
held.
You're going to ask questions that's based on that question. What's the point?
No, I'm not. I'm just asking you about what happened at a meeting, and I'm going to ask you to now go to the minutes of the meeting. R203 is the note of the meeting with Mr. Eminer in September. And I'm going to look at what you said at this meeting. You can see that the first discussion is about NRD and Benzingi. I'm going to ask, can we go to page 2 of this minute? We have here, next discussed point was tags. NRD, in its letter attached, asked the minister to provide tags for the NRD concessions. Minister said he will not approve to provide the tags if NRD doesn't have a license. NRD pointed out that from 2011 there is no license, and NRD was allowed to mine and tag. Invitations for the negotiation for long-term license were sent out from minister in April 2014, and that's right. Then the minister said he received letter last week from Benzingi that Benzingi doesn't want the minister to give NRD tags. Benzingi signed as the managing director of NRD. NRD says it makes no sense if individuals sending letter. Minister ignores the letter sent by the Minister of Justice in which the bailiff awards and judgments were suspended. Now, just looking at that, this idea NRD says it makes no sense. You're referring there to the letter that we looked at earlier, where the Justice Minister suspended execution. Yes, we saw that earlier.
I wasn't at this meeting, and I don't know. I would prefer if you asked Ms. LaRouche.
Do you want me to? Because that's fair enough. You weren't at the meeting. Enables me to save some time. I'll move on and I'll ask Mr. Skoda. Now, let's stay in this meeting. You'll see that what was requested was an extension of time for making a license application, and the minister refused the extension, saying that your problems were your own, not his, and you should provide what you're able to in accordance with a deadline and supplement it as necessary.
Well, I would suppose, not being there, I can't be sure, but I would suppose that was a reference to the fact that the government still had our offices and we had no access to the documents that were being sought in the application.
Just so you can see, it's on the first page. This particular part of the meeting is dealt with, and that's it's just dealt with something at the second half of that second paragraph. Now, it's right, isn't it, that you didn't request this extension until this meeting, which was on the 16th of September, only 2 days before the deadline? Yes?
My recollection is they couldn't get a meeting until 2 days before it was due.
and you didn't request an extension until then, either by correspondence or in a meeting, correct?
You'll have to ask Ms. Marushkovich if I don't know that.
And the problems, as the minister said, the problems of getting into your Kigali office were indeed your own problems, weren't they? Because they resulted from lawful court rulings that NRD was subject to, correct?
No, we were the only company in Rwandan history, as far as we know, that was seized in its entirety for a debt which was a tiny fraction of some of the value of its assets.
And the reality was that you and Ms. Marushkovich ran much of this operation anyway as a briefcase operation, largely out of your accommodation in Kigali. So you had a great deal of access to material in any event, correct?
Nope.
And much of the material that was required, and we'll go to some of it in a moment, but it didn't even need access to company files because it involved acquiring it from third parties, correct?
No.
For example, you were required to obtain tax clearances, and that was just a question of seeking confirmation from the Rwandan Revenue Authority. Yes?
No. We were not recognized at that time as the owner of the company, you'll recall. RRA would not speak to us.
And the reason that you did not obtain tax clearances is not for that reason, nor because you didn't have access to your office, but because NRD hadn't been paying its taxes and owed unpaid debts to the revenue, and you could never have got a clearance from the revenue, could you?
No, that's a gross misrepresentation and slander.
You knew very well that the revenue regarded you as having outstanding debts to it, didn't they?
No, as we talked about yesterday or the day before, there was a allegation from the Rwanda Revenue Authority that H.C. Stark had not accounted for some of the money that it had paid to casual laborers, and pursuant to which some amount of Social Security tax would be due. That was the beginning and the end of the dispute. There was no, I'm sure that H.C. Stark was, accountants and auditors were not wrong in their judgment. The agreement we had reached with Rwanda Revenue Authority is that they would come in and do a proper audit, which they had still not yet done. And the matter was being left to that. There was no other outstanding debt as far as I know.
They regarded you as having outstanding unpaid debts and would never have given you a revenue clearance, would they?
That's untrue and slanderous.
Let's look at the application you did put in on the 18th of September 2014. We have it at C84, C084. Now, although it's dated 18th of August, on its face, it's common ground and there's no dispute that that's supposed to be read 18th of September 2014. So that's a September application. If we look at the first paragraph, you say, this letter and the attached information are submitted to you based upon the discussion you had in your office on Tuesday, 16th of September with our finance director and our director of operations. By way of short explanation, the instruction in your letter dated 18th of August 2014 that the investors in NRD should submit requirements to you was puzzling. We were glad to receive a letter by email to our personal accounts, but had been informed this was a mass mailing to all license holders, and the information requested from us as investors would wait for resolution of the claims by Mr. Benzingi. Now, you knew very well, didn't you, that the request for the application had been directed at NRD as a company, and Mr. Eminer was not concerning himself with any particular investors, correct?
No, our understanding that was a letter which was being sent to everybody, that this was how they were going to proceed with new license applications. And it was a new process and for new arrivals to Rwanda.
You knew very well, didn't you, that, well, let's look at the second page. So this is the information that you give. You say, article third, starting with the third paragraph, well, you start with the second paragraph. The contract provides for the purpose of the agreement of the rights and obligations of the parties to the agreement and authorizes NRD to proceed with its obligated activities. And then you say Article 2 sets out certain of the obligations of the parties, and Article 3 to 4 provides for NRD's rights to obtain an automatic and exclusive right to mine for cassiterite, wolframite, and tantalum anywhere within the mining concession areas for a minimum period defined by statute for mining concessions of a minimum of 35 years renewable. The definition of mining concessions is specifically noted in Article 10 as being defined under existing Rwandan legislation. NRD has completed its obligations under Article 2 and 3 to 4, and the agreement has endured to date and has not been terminated. It's therefore respectfully incumbent now on the part of the government of the Republic of Rwanda to grant the necessary mining rights for a period of 35 years, renewable to NRD, hereinafter referred to as the long-term license. Now, you didn't think at all that it was the case that the contract provided for automatic rights to mine for 35 years, did you?
I think it's an error. It should say 30 years.
You didn't think that either, did you?
Yes, they shall have the right is the language of the original contract.
And you knew that you had not satisfied the requirements of Article 2 of the contract in respect of the reserves and feasibility report, didn't you?
The representations from the beginning were the same. We were always treated as the long-term license holder as defined by law. We, as an indulgence, started the investment before we were granted the long-term concession agreement, which we expected them to be commercially reasonable.
Nor had you submitted at any point.
Everybody else got a long-term concession license except us.
Nor had you submitted at any point a feasibility report that was at all likely to be seen positively by the government, correct?
No, we had submitted the feasibility report. The feasibility report was for us to be able to determine, as in any long-term license application in the mining industry, as a basis on which we determine whether we would want to go ahead with our investment.
You also knew, didn't you, it was wrong to say the agreement had endured to date, correct?
No, we believed it had been endured to date. We had fully performed on our side of the agreement, and we were just waiting for performance on their side.
Now, coming on to the next paragraph, you refer to the injection of funds. You say, in a period starting before signing the above named contract to this date, NRD has to date invested funds in excess of $20 million into the project, and that we've been through the amounts invested, and that statement was untrue, correct?
No, it is correct.
You then attach some limited documents, and we'll go through those in a minute, but it's right, isn't it, that you didn't even purport to put in an application on a concession by concession basis as you'd been requested to, correct?
We had fulfilled the terms of the original arrangement. We had submitted an application in 2010. The application was deemed sufficient. If they were asking for additional breakdown of information, it had never been clearly articulated to us in a way that said it's an amendment to the original agreement where we had fully executed.
You were told what to do, which is to apply on a concession by concession basis, providing the information requested, and you didn't even attempt to do so, did you?
I'm sorry, where are you reading from, or what period?
I'm reminding you of a letter we looked at only a few moments ago, which was Mr Eminer's letter in August, telling you specifically you had 30 days to apply on a concession by concession basis and to provide the information requested.
The agreement we had with the government was that we submit an application, then we start negotiating the terms of a long-term concession. If there was some business reason for changing that procedure, we'd be happy to do it.
So you just chose to ignore Mr Eminer's letter?
We were not subject to this. Everybody else was treated as a long-term concession holder and invited to negotiate an agreement. If they wanted to, at some point, be able to say in that negotiation, no, this concession is too large, or we need to allow you to focus on these areas, that would be part of the long-term concession agreement.
He was telling you you were subject to it. And he sent you a letter telling you what to do, and you chose to ignore it. That's fair, isn't it?
No, it's not fair. We disputed that we were subject to it. We wanted to be treated the same as all other holders. We had all of our documentation and research and expertise in our office, and he was not giving it to us, so we assumed that this was a setup. He just wanted to be able to say, you failed. Now, otherwise, he would have given us our office back.
You provided what Mr Eminer had no ability to give you your office back, did he?
He absolutely did. He was in charge of the mining industry. He alone had the ability.
Now, you provided what purported to be a feasibility report, which we have at C085. And can we go to that document? And can we go to page 40?
This, by the way, is the environmental problem I was telling you about where they did the ground sluicing. The picture
Page
on the front.
40. This is a page summarizing NRD's investments in respect of infrastructure, where you identified two particular pieces of infrastructure. And could FTI, can you make it slightly smaller so I can just see the page? Thank you. Yes, I'm looking at the bottom paragraph. FTI, you're happy for you to blur it up again. So it's the bottom paragraph we're looking at. So this is under NRD's investments leading to enhanced exploration and mining capacity. And you say NRD's investments in respect to the plants themselves are summarized in the NRD application 2010. And if we just scroll a little further up, we can see that that's dealing with two plants, the Rutsiro plant, and then further up, a Nemba plant. See that paragraph, including constructing the Rutsiro plant and the Nemba plant. So what you're saying in this application is that the investment that's been done was done before November 2010, because the details about it are to be found in the November 2010 application, correct?
No, the investments were ongoing.
You don't identify in this application, in this feasibility study, any material new investment in infrastructure, do you?
No, all investments were ongoing. The Nemba plant didn't exist in 2010. So, with regard to that item alone, but all upgrades have to, it's a work in progress. You can't stop investing in the mining.
Well, let's go back to that bottom paragraph and look at it again.
Okay.
NRD's investments in respect to the plants themselves are summarized in the NRD application 2010, making it quite clear that the investment had taken place before November 2010 and is summarized in that document. Yes?
In Nemba? No.
That's what your document says that you submitted. Correct?
Maybe inartfully worded, but the Nemba plant wasn't built until after 2010.
Can we go to page 71? This is a section dealing with exploration works. And it actually starts, if you go back one page, if FTI can put the previous page up as well at the same time. We've got a section dealing with satellite image tools. And then on page 71, it says 3 paragraphs down, in addition to the research reflected in supplemental fields to this feasibility study, several field campaigns of exploration work were performed. And then you say in the text below, we roughly summarize performed work. You see where I'm reading from? It's immediately above the 4.9. Okay. For detail, we refer on report NRD 2010 and 2008 to 2010 annual status reports and supporting material. So it's clear, isn't it, that as regards this work also, surveying work, this feasibility study identified no material new work that had not been identified in the November 2010 application.
No, well, I'm not saying that it's correctly stated, but certainly we had teams of geologists permanently in Rwanda from the Czech and Slovak republics.
If you had done any material new surveying work, you would have identified it in this application, wouldn't you? And not just directed the reader to the November 2010 application, correct?
No.
Let's go to page 88.
It may be less promotional than it should be. It may be less of a statement to show how great we are, but That's what we wrote.
But the reality is also, Mr. Marshall, it's not just this document, although we'll keep going to it. You had other opportunities to supplement your material, and you were given a number of opportunities by the government, and you never produced any updated investment or surveying data, did you?
I agree to differ. I think we did provide, every time the geologists did work, they spoke with their counterparts at the ministry. They would have provided them with those studies.
You never
The fact that you're
improved.
not providing them to us today doesn't mean that the work wasn't done.
You never improved this part of your application, even though you were given repeated attempts to improve on your application, did you?
No, we did improve on this part of the application.
Now let's look at paragraph, page 88. This is dealing with mineral reserve modeling, and we start with starting with exploration and sampling. And at the beginning of the first paragraph, it says, wolframite sampling, initial reserve estimates were carried out pre-2010 for the primary wolframite deposits at Rutsiro and their associated secondary tailings deposits. So again there, the work done for reserve estimates was pre-2010, yes?
No, that says initial reserve estimates were carried out then.
And no other work is identified, correct? This is what...
Well, you'll have to let me read it. If you want me to read it, I'll double check. But
it's just describing the work that we see in the November 2010 application.
yeah, but all of the sampling was ongoing. As we're mining, we're sampling. We were unique among all mining companies in the ability to do that because we were the only mining company with a lab. I beg to differ with you about what this means. If you're saying that we failed because we didn't specify much of the exploratory work after 2010, it's not to say it didn't happen. I think your staff, your client's staff, would be able to verify it. We took thousands of samples.
Let's go to, if you had done that, you would have identified them. Let's go to Mr. Eminer's witness statement at paragraph 33.
But these seem to be questions of fact to me, and I would urge you to go back and do a more detailed investigation since you're accusing me of not doing something when you have the information to be able to demonstrate whether it's true or not.
Now, Mr. Eminer deals with this application and he summarizes his take on it. He says on 18th September 2014, NRD submitted a partially complete application for the issuance of long-term licenses. It included a feasibility study update, which although some 90 pages in length, contributed almost nothing new. It was largely a reworking of a November 2010 application with some generic geological reports obtained from public records. And that is a fair assessment, isn't it, of the report, the feasibility report that you submitted?
It's entirely unfair because I know that our staff spent hundreds of hours on it. And I wish you would do a close comparison rather than referring to conclusory remarks by somebody who's very biased.
We're very happy to do a close comparison of this document and the November 2010 application. And indeed, one has been done, and you cannot identify any material new investment in your November 2010 report. Sorry, in your 2014 or exploration in your 2014 report.
I beg to differ.
And let's
I
go.
know the work was done. You can make a claim. But by the way, I would also encourage you to compare it to all other applications. Other than Rotungo, ours was far superior.
Let's go on in Mr. Eminer's witness statement. He says the application overall, and despite the terms of my letter 18th of August 2014, one application was made rather than a separate application for each individual concession area with specific plans and studies relating to that concession was evaluated by the license team. Now, just taking that in stages, it's right to say you hadn't addressed the concession singly as you'd been asked to, correct?
I stand by our position that Mr. Evode had possession of our offices and would not give us access to exactly the information he's requested.
You didn't mean to suggest that Mr. Evode had possession of your offices, did you?
I mean, the government had possession of our
You didn't
offices under the auspices of Mr. Evode, yes.
You don't mean to suggest that either, do you?
I do.
Given that the previous feasibility study was considered insufficient for the 5-year license application in 2010 and 2011, this was never going to be considered adequate for a long-term license, was it? You must have known that.
I'm sorry, read the question.
You must have known that this feasibility report was never going to be considered sufficient for a long-term license because the last one hadn't been.
Far superior to all other applications other than Rutongo. We saw Gafurwe, we saw Rintwabu, we saw New Bugarama. Our documents far exceeded those, and I would invite you to provide those other proposals to the panel for a point of comparison for them.
Can you look at your third witness statement, or your second supplemental witness statement, as it's called, paragraph 19. Sorry, paragraph 25, I should say. You say there, NRD was the only company doing sampling on a daily basis using the then new XRF spectrometers, which enabled NRD to sample thousands of minerals on site. Can we just see what Mr. Eminer says that in his supplemental report at paragraph 19?
Did you say Eminer supplemental?
Eminer supplemental, paragraph 19.
Thank you.
He says, in my first statement at paragraphs 12 to 13 and 71, I explained how the sampling done by NRD was superficial. They had only obtained 115 samples for 3 concessions, which equated one sample for every 191 hectares. Paragraph 25 of the second supplemental statement of Mr. Marshall, he claims that NRD was the only company doing sampling on a daily basis using new XRF spectrometers. This cannot be true and is not consistent with my understanding at the time. First, if NRD was taking samples on a daily basis, I believe this would have been recorded in November 2010 application or indeed any later applications, but it was not. The November 2010 application states only that a total of 115 samples were collected. And this is consistent with the explanation I gave in my first statement. Secondly, NRD was not the only company using an XRS spectrometer, and in fact, they were commonly used in Rwanda. And what he says is right, isn't it?
No, it's entirely untrue. A couple of traders, MSA and Phoenix, had an XRF, and I think those were the only 3 in the country. Perhaps Chris Huber, as a trader, also had an XRF, but other than that, there were none. They were expensive, about $50,000 with the related equipment. And so for most companies, they would rather rely on the judgment of the trader for the value of the minerals they were selling. We did not. I would say that he's also made several other conclusions which are, not based in reality, not based in truth. There were detailed samples that H.C. Stark sent back to Europe for additional analysis. And as I recall, and I would have to go back and look at the application, those were the 115 samples. So it's a bag of 20 kilos and 115 sent back for that specific purpose. But they were doing ongoing sampling, and the XRF was a Bayview Group asset, which was being used by NRD, I think, at that point.
Mr. Marshall, if you had been lots and lots of samples, as you suggest, you would have made that clear in your application. But you didn't suggest that in your application, did you?
No, and I think you're making a mistake about what I thought was relevant in the application and what you, with 20/20 hindsight, claim is relevant.
Now, you also supported this application with the document that we have at C92 as an indication of your financial resources. And if we just look at C92.
No, our financial resources was the investment we had already made.
They're interested, the government are interested in what investment you can make going forward in support of your application for a long-term license, aren't they? That's
No.
what they're interested in.
No, they're interested in whether we're going to be able to make any investment. Remember, this is a new application. This is a list of transactions for me as a professional. It's nothing to do with financial capability. The investment they're interested in is, can you make any financial investment in Rwanda? And we'd already made $20 million in investments.
Well, this might be your answer. Let's just look at this document. This is what you put in as being relevant to your application to support the idea that you had financial resources in order to make you a worthy applicant for a long-term license. And let's look at what this document is. It's headed Gilson and Marshall Associates, Counsellors at Law.
Can you show us the requirement, what provision this is supposed to be responsive to? Because this is not my memory that this would have been submitted as responsive to a question of whether we had financial capability.
Why do you think you submitted it?
I don't know that it was submitted.
It was. This is one of the documents you relied on in support of the application.
What does the language say? Then maybe I can give you an explanation.
We don't have, it's your application, and we don't have a description from you.
No, what is
why
the
you're
requirement?
submitting it.
What does the government say the requirement was? What were they asking for?
Doesn't matter. You tell us
It does
why.
matter, because I need to know what you're claiming I'm responsive to. This is prepared by my staff. I was not in the country, as you saw from the meeting on the 16th.
So you say you didn't read the application and the supporting material?
I was not in the country. They were responding to all of these provisions themselves. Did they make a mistake? Entirely possible. But
Will you tell us what
asking
you
what
think
it
this
says.
document is?
This is a list of our transactions as a law firm.
Yes, that's what I thought. This is a list of the transactions done by that you've advised on as lawyers, correct?
Yes.
Thank you. So it wouldn't
What was the
assist
request?
at all, would it? Do you accept? It wouldn't. It maybe your answer to this is it wasn't intended to, but it wouldn't assist at all, would it, on the question of NRD's financial capacity or those of its backers to execute its proposed activities during the period of a license?
No,
Correct.
we may be unique in that we had already satisfied this question. It's not what are you going to bring? It's we already have satisfied that.
So you considered that your application for a long-term license was sufficiently satisfied in terms of resourcing and investment by the historic investment that had been done. Is that right?
That's what we were told was the deal.
But that is your
That
position.
was
That's
the
your-
representations that we had been made to us and the basis on which we invested.
and you were not then
They're now
attempting to persuade the government that you could bring anything else to the table for your long-term license beyond the historic investment that had already been done.
we had no ability to talk with anybody about what their expectations might be over and above what we had already invested. There was
Let's
no
go to
dialogue. There was
let's go
no, all of these processes are iterative. They're all done on a collegial basis. We had no chance to talk to anybody about what was expected in any item on this list. As I say, I was out of the country at the time, but I don't even understand why we were having that discussion. We had an agreement. We had fulfilled our part of the agreement, and now they're changing the rules.
Let's go to R020. This is an evaluation provided of your application, that was made of your application by a license evaluation team. And you can see that at the top of page 1. So it's to the Honourable Minister from License Evaluation Team. And if you look at just to see who the team are, if you look at the last page of the document, page 8, you can see there are 4 names as being the team. Do you see that?
Yes.
And then were you aware that there had been an evaluation of your application by a team which made a recommendation to the minister?
Of course not.
Can we look at page 7 of the document? This is the recommendation. After all observations seen above, the technical evaluation team recommends that Natural Resources Development Rwanda NRD may not be granted 5 concessions, namely Nemba, Rutsiro, Gikeya, Mara, and Sabea. This is because NRD did not submit all the requirements requested, and even those that were submitted are deemed not satisfactory, according to a request letter for the Ministry of State in charge of mining, which requested NRD to reapply for some or all finding errors by NRD. The evaluation team analysed documents submitted by NRD, and the team found that in the motivation letter for the application of a licence, NRD Rwanda did not indicate which kind of mining concession NRD Rwanda Limited was willing to operate in. The type of licence was not mentioned according to the new law, and also the company did not indicate the licence period it wanted. And their recommendation was not to grant the licenses. Yes, you see that?
I see the language you're pointing to. This is all new to me, and this is the first time I'm aware that they ever held this kind of evaluation without simultaneously conferring with people like us who might have been the recipient of the license.
And between pages 3 and 6 of the document, if the FTI can go to page 3, what you'll see is that between pages 3 and 6, the team listed all the items Mr Eminer had requested to be provided. Perhaps just 3 and 4 could come up, thank you, in the letter of 18th of August, and they commented on whether they were provided, and they made observations on their content. So, for example, if you look at the bottom of page 3, there was tax clearance certificate from the Rwanda Revenue Authority, submitted no, and then their observation is that the company is said to have 294 million Rwandan franc as a tax liability to the government of Rwanda. This is according to the audit from PricewaterhouseCoopers, which could be evidenced in a letter addressed to the Commissioner General on 7th December 2010. See page 3 under summary of tax liabilities. Further consultation can be done with the RA to know the accurate liability. So that's just one example of your failure to provide a tax clearance and the perception by the government that there is in fact a tax liability. Do you see that?
I see the language that's not correct.
And then we look at the bottom of page 5.
This is the first I've seen this document.
Today, that's the first time you've seen it.
No, I never saw it during this period, sorry.
So you have seen it in preparation for this case, presumably?
In preparation for this case, but not at that time. I question whether it was contemporaneous.
Then we have...
Or it's surprising to me, and the reason I say that is it would be very unusual for the government to prepare this kind of document without sharing it with the party who's applying. They ordinarily are very meticulous in going through each item, so they fairly give people a chance to respond.
Looking on to page 5, there's a section requirements on mining and exploration plan. And there's a section which says minimum investment commitment on each mining area. Answer, no. The company did not submit the requested minimum investment on each of the mining area, i.e. Nemba, Gikeya, Rutsiro, Mara, and Sabea. However, in the document submitted, the company shows it will spend €382,000 to exploration over the 5 concessions from 2011 to 2015. The valuation team found out that this information is not an updated information, rather old. Can we carry on? An old one, and there is no expenditure allocated to mining exploitation. And that's a fair analysis of the feasibility study you submitted, isn't it?
No, as a practical matter, the ministry provides the applicant with the amount of the expected investment at each and every location, and the expected amount of production that would come from the mining. And the reason for that, just so you understand, is that that's part of a commercially reasonable long-term concession license, so that there are performance characteristics, goals, requirements in the contract itself, which could lead to termination if you didn't meet it. But for us to, we would never presume, and it's always been a dialogue in the past, what do you think this can provide? What do you think is the amount of investment required? If we hadn't had that conversation, in a recent couple of years, then we would have necessarily gone back to the information that the ministry had provided to us before.
Well, you knew, didn't you, that this was one of the items on Mr Eminer's list, because this report is going through the list. I'm going to pick up another one. Well, you want to answer that?
But my point is that by this process, they've changed their approach. It's no longer a collegial give and take about these issues. From what I'm hearing from you is he sent you these requirements. You didn't answer, or you didn't answer in the way that he expected. Therefore, you failed. That was never the process in Rwanda before this time.
Let's go to page 5. Let's go to page 5. You were asked to provide minimum work commitment on each mining area, to which their response is no. The company did not submit the information requested. However, the company in its document that seems to be not updated shows some proposed activity in research, production, reserve calculation, processing information, environmental mitigation, and work safety for period January 2011 to January 2015. And again, your work proposal hadn't been updated since the November 2010 application, had it?
Yeah, you have the office, you have the documents. I can't be sure, but again, this is the first time that this kind of comment would be made. In fact, I've never heard of it being made without a consultation with the applicant.
And then the next, just a little lower down the same page, penultimate row, the financial capacity to support each commitment with supporting documents to prove such a capacity, for example, a bank guarantee from any financial recognized institution by the Rwandan government. So again, you're being asked to demonstrate financial capacity, and their answer is no, their evaluation is no. The company did not submit any kind of proof for financial capacity to support any of their activities planned. And that again is a fair assessment of the application you put in, isn't it?
No, it's very unfair.
Well, you didn't. Are you suggesting you did submit proof of your financial capacity to support the planned activities?
Correct me if I'm wrong, but this is for all new applicants, for people they don't know anything about, not somebody that has invested significant amounts of money already.
So just an answer to my question.
Where's the category for what has already been done?
In answer to my question, you did not submit any kind of proof for financial capacity to support any of the activities planned, did you?
Well, I'm sorry, I don't mean to be rude, but we've already invested. We've already invested $20 million. Isn't that proof of financial capacity? Why does it start from zero? Why does the application suggest that anything you've done so far is meaningless? Now tell us what you're going to do and what it means in the future without even talking to us.
So the answer to my question is, in terms of the planned activities going forward, which is what this document was supposed to indicate, you did not provide proof of financial capacity, did you?
We were never asked in that context.
You were asked specifically because it was one of the items on the list, correct?
No. We were asked, do we have the ability to build out these concessions? We've invested $20 million, and now we assume that that's to address that question. What is your financial capacity? $20 million is here. What more do you need? Nobody has invested 20 million in the industry, even since then. I don't think there are 3 companies in Rwanda right now with more than $1 million in investment.
No, I don't accept that 20 million figure for a moment, and we've been through that. But now let's look at what Mr Eminer says about your report.
Pick a number then. We've already invested. What you're saying, if you follow the logical conclusion of your question, what you're saying is everything that's done doesn't count anymore. It's only about what you're going to do now. Thank you very much. Yeah. You've given that to us.
Mr Eminer received this recommendation. Can we look at what he says at paragraph 33 of his witness statement? And in the second half of that document, he refers to the evaluation by this team. And he says they found that NRD had failed to provide numerous documents that were required of them, including a tax clearance certificate, a recommendation from the Rwanda Environment Management Authority on the state of the environment at the 5 concession areas, proof of financial capacity to support each commitment, i.e. to invest and develop the mines, and work plans in relation to each mining area, i.e. plans as to what they were planning at each of the 5 concession areas and how they'd go about this. These documents were critical to our evaluation of NRD's application. For example, the tax clearance certificate was necessary to demonstrate that NRD had been paying taxes, and the recommendation from REMA as to the status of the environment was critical because we had concerns about environmental damage occurring at NRD's sites. And that was a fair evaluation of the flaws, or some of the flaws, in your application, isn't it?
No, I think you're fundamentally mistaken. First of all, we could not get anything from Rwanda Revenue Authority. They didn't recognize us, for whatever reasons they had, as the owner. There was no basis on which we could get them to negotiate anything. Would not recognize us. We tried. With regard to the Rwanda Environment Management Authority, we went there to talk about what regions they could either do or support consultants to look at whether there was environmental challenges that had to be met. Their official position is they don't do any work until a license is awarded. None, zero. They're not going to do speculative work. They say, if you own that license for that specific area, then yes, we will come and review it. So we were stymied there. We had nothing more we could ask.
Mr. Marshall, you are again coming up with points which are a fiction, aren't you?
No, I'm afraid your client hasn't informed you of the full nature of what's going on in Rwanda.
Can we look at paragraph 34?
This was not presented to us at that time. So these complaints we had no ability to discuss with them.
So here, Mr. Eminer says, I've seen the document headed selected financial transactions from 1996 submitted by NRD as part of its 18th September 2014 application, allegedly as evidence of NRD's financial resources. That document contains no information regarding NRD's financial resources or its ability to finance the investment and development of the 5 concession areas. On the face of it, the document has no relationship to NRD at all. As evidence of NRD's financial resources, it was completely worthless. The fact that NRD chose to submit this document as evidence of its financial resources was further evidence to me that neither NRD nor Mr. Marshall were taking the application process seriously. I do not believe NRD can have been under any doubt as to what was required. And that is a fair comment on the list of transactions by your law firm that you provided, isn't it?
No, and I think he's entirely misunderstood what we took to be the principle, that we should be like any new investor. If you were considering us as a new investor, that the 20 million that's already invested be credited to us. What additional proof do you need of our financial capability?
Now, just a couple more questions on this area before I move on, or before we have a break, in fact. Mr. Paragraph 35 of this statement, Mr. Eminer summarizes his response that the evaluation team determined that many of the documents were unsatisfactory, including the financial document I've referred to, and that NRD had failed to provide any tangible document that proved its financial capacity to develop mines. Accordingly, by letter dated 28th of October 2014, I advised NRD that a decision had been made not to grant it any mining licenses, but that NRD had 7 days to file an appeal against this decision. I gave NRD this right to appeal despite being under no obligation to do so. And it's right, isn't it, that he gave you a 7-day opportunity to appeal despite not being required to? Yes?
My understanding from the minister at that time was that it was mandatory, that he, as part of due process rights, we had the right of appeal, and we took that opportunity to appeal.
And there's been nothing unfair, has there, in any part of this process? You were told what you needed to do. You didn't do it as you were asked to. There was an evaluation by a team looking at things objectively, and the minister accepted the recommendation of his team. That's fair, isn't it?
It's entirely unfair and entirely unreasonable. We should have been treated exactly the same as all other large-scale concession holders. And we were not. We were singled out for this treatment. And the only one among them singled out for this treatment.
And by the time we get to 28th of October, so sometime after you put in the application, when Mr. Eminer communicates his refusal, you still hadn't attempted to supplement the application in any way, had you?
I'm sorry?
You hadn't attempted to supplement the application in any way.
I think we submitted additional detail. He knew what he was doing. He knew that we were not able to get access to the office. He knew we had no tags. He knew we had no rights to be able to mine. So this was, in our mind, a perfect setup, which is why we continue to rely on the advice of the military people who encourage us to wait for the internal investigations to play out.
You did submit some very limited additional information, but that was only in response to a request to do so from Mr Eminer, which comes later, and I'm going to come to that. So I wonder if now is a convenient moment, Mr President.
Yes, let's break for 15 minutes.
Jerry's good though. Jerry's is on a habit. Right.
Susanna at what? Computers.
Yes.
Right. They're in a different place.
Correct.
Okay. Okay, Mr. President, I'm going to go off camera. I'll wait to hear about bringing the witness in.
Yes, please bring Mr. Marshall.
I have a housekeeping issue, Mr. President.
Oh, yes.
Sorry, and I think Mr. Hill. So do you. You may not be informed of this, but because it doesn't immediately impact your schedule with your witnesses, but it impacts your schedule for questioning our witnesses. We've been informed by FTI that there are two packages trying to make their way through customs in Rwandan customs. One package for of materials that are necessary to participate that holds all of the equipment for claimants' witnesses. One package holds all the equipment for respondents' witnesses. Both packages are still held up in customs. They're not through. The next witness after redirect of Mr. Marshall is completed is Mr. Biscus. And I don't have the schedule committed to memory, but I think it impacts the next witness and then they skip. If there's, I bring it to the tribunal's attention, not because I think the tribunal can solve it, but if there's any ability to suggest that members of the respondent who may not already know, but that assistance may be needed and could probably be helpfully provided by representatives of the respondent to get the packages through.
This is hardware, is it, to do with the actual filming?
It's the computers and cameras. There's the 360 camera is so a computer that's connected to the internet, whether it's theirs, whether it's FTI's or not, has the capability to link in, but they don't necessarily have the same capability to allow FTI to do everything that it may need to do to help people or other things. I'll let FTI explain the difference between just anybody's computer and theirs. The one big difference is most people don't have available to them an equivalent 360-degree camera. That make do or workarounds for that might be far more limited. And those are the two things I know.
Yes. Mr. Hill, do you think your clients could do their best to unblock the customs so that this stuff gets through?
Yes, I hadn't, I'm afraid, heard of this at all. It hadn't got to me. I will take instructions and see what can be done. I'm afraid it's a complete unknown to me, but I will certainly take instructions and see what can be done.
Good, thank you very much.
And just to be clear, I feel defensive here, but I probably shouldn't be, but there's so many allegations being thrown around. I am not suggesting anybody's done something wrong. I'm just pointing out what I've heard. So I'm just asking for help, not blaming anybody for the situation. And we're all in. I think both packages are in the same place.
Yes, understood. And I hadn't inferred any criticism on your part. Right, let us continue, please, with last round of direct for Mr. Marshall.
Okay, we're bringing the witness in right now.
Mr. Marshall, carrying on with the license application, we just dealt with Mr. Eminer's refusal of your application following a recommendation from his team. And I would like to look at your response to Mr. Eminer's refusal, which is at bundle C-165. This is a letter from you to the Rwandan police. Yes, that's CGCID, isn't it?
Yes, that's the police.
And it's headed formal complaint against apparent corruption. And in this letter, you are, on its face, complaining to the police, aren't you, that Mr. Eminer has been corrupt?
Yes. I haven't read this letter, but I do recall sending a letter informing the police about Mr. Eminer's corruption.
And this is
not the only one.
This is not stamped and doesn't have the company's seal, this letter. And I'm just asking you, are you sure you sent this letter? Seems unclear that you did.
I'm sure we sent a letter to the police about his corruption.
And can we look at the last page of the letter? And see that you copied the letter, if you did send it, to the President, the Prime Minister, and other ministers, and the US Ambassador. Yes? You were seeking to do maximum damage, weren't you, to Mr. Eminer?
I don't recall that, but it's possible.
Well, it says CC, and you were seeking to do maximum damage to Mr. Eminer, weren't you?
No, my objective was to get fair treatment for our investors, and I knew Mr. Eminer was corrupt.
Let's look at some of the points you make. Can you go to the first page of your letter? You have this complaint, and under the complaint, you say, A, we have lost our mining business through what appears to be a state taking or nationalization of our company's assets, including mining licenses, which was announced by Minister Evode on 28th of October 2014. So you are describing his notification that your license application has been unsuccessful as a state taking or nationalization of the company's assets, which is a crime on his part. Is that what you're saying?
No, I think you're taking it out of context. I think the seizure of our business, the closure of our office, the shifting of an application from one that had already been in process for a long time to a new one where there was no communication other than a written response of which there was then no follow-up or no discussion. We saw, to use the vernacular, we thought the fix was in.
You are saying, you're referring to this taking of nationalization being announced by Minister Evode on the 28th of October 2014. That's his letter declining your application for licenses. And you are saying to the police that this is a corrupt nationalization of your assets, aren't you?
I was giving the whole context for what had happened and why we believed it to be corrupt, yes.
And then underneath that, you say there's been systematic stripping of our capital investment assets by numerous criminal scams, including bailiff seizure scams, which the authorities refuse or are unable to stop. But again, you had raised that with the Minister of Justice, and he had told you that on investigation, these were lawful judgments that you should be getting on and settling. Correct?
No, that wasn't how we understood it. We did have several meetings with the Minister of Justice. He at first was very sympathetic. We were told that he had gotten some political guidance and he changed his mind. The bailiff was, not behaving like a bailiff should or could. We still had no information about, other than the Pascal seizure, what any of the seizures were. No court orders, and he followed none of the bailiff process. So to me, that was corrupt.
You then, at little e, I'm not going to take every point of this letter, it's a long letter. Taking up little e, you say we've lost millions of US dollars of income beginning more than 5 months ago because Minister Evode illegally shut down our business. He shut us down by refusing us the ITRI control tags which are required by law before any minerals can be sold. This was illegal and without due process. We had no hearing, received no notice of closure, and were repeatedly refused an audience with Minister Evode. But as we've seen, and as you don't explain here, NRD had no license, and Mr Eminer was also facing a competing claim. Yes?
The license issue as an excuse didn't come up till much later.
That's not right. Just stop there, Mr Marshall. That's not right, because we've already been to the meeting with you at which this was discussed. Mr Eminer set out his position in relation to the license, and that is before this October letter. We've been to that meeting.
Well, you're missing the timeline I'm referring to. I'm sorry.
You carry on.
He stopped the tagging in March. The tagging took full bite in beginning of April 2014. And we didn't hear from him what it was about or why, just he refused. And then we had a meeting late May, you can tell me what the date was, where he explained that Ben Benzingi was the owner of our concessions. So there was no, as of that point, there was no discussion about regularizing, as he called it, licenses. Ben was the owner. We were out. We were losing everything and being told in no certain terms to go home. So for us, this was very frustrating process. He did refer to it as a piece of plastic, and you should just continue mining and store it, which was very hard concept for him to suggest we should follow.
And contrary to what you say in this letter to the police, you had meetings with Minister Evode, hadn't you?
Not meaningful ones. We had a meeting with Minister Evode in March with his lawyer, May. This is the exciting one where Isaac, formerly our lawyer, announced that Ben was the owner, and the minister agreed with him.
And then you had a meeting in September, didn't you?
Well, we could have.
We've been to that today.
Which was that? Oh, Susanna had a meeting with him in September. I'm sorry. I see what you're saying.
Evode did meet with you, and what you said in this letter is inaccurate.
Look, this is a very small community. Ordinarily, we would have near daily contact with these people. We had been put out into the cold. No other mining company was treated this way. We simply didn't know things. We had to find things from the other mining concession holders, what was going on. In earlier periods, we had simply stopped by. They would stop by our mine. It was very collegial. It's a small group trying to solve a handful of problems.
Let's look at what's then said in item 2 of your complaint. The letter dated 28th of October 2014 from Minister Evode to NRD is drafted to read as if Minister Evode is merely denying a mining license application. Minister Evode has selectively used the facts to pretend that the relationship between NRD and the government of Rwanda is only in respect of an application for a mining license. This is not true. In fact, it appears that Minister Evode's letter cancels all relationships he is taking or nationalising the NRD business. Minister Evode's letter does not follow the usual and customary Rwandan administrative practices. Minister Evode's letter, and we can go to it if you like, was simply declining your mining license application, wasn't it?
No, I think in the second paragraph, if you go to it, he says this letter constitutes something like that, canceling of all relationships between NRD and the Rwanda government.
Well, you didn't have any relationships beyond your ability to mine on the concession, did you? That was the contractual relationships that you had, correct?
No.
You had an expired contract and you had expired licenses.
We've been referring it to you. We've made endless references to you about that relationship with the Rwanda military. We were spending, with the closing down of our mines, we shifted over to charitable work, and we've shifted over primarily to working for the Rwanda military and the Rwanda intelligence services. That's what we were asked to do, and that's what we were happy to do.
Let's look at R-022.
This is why we knew about all of the smuggling going on of the minerals from Congo. This was part of our work, was understanding how to improve Rwanda's reputation in the international community. They asked for help on acquiring arms. We helped them on acquiring arms. We don't know what arms there were, what they ultimately purchased, but we set up a relationships that they didn't otherwise have.
Can you look at the second page? So this is from the Ministry of Natural Resources. He says, this letter serves also to inform you that the ministry has terminated all prior working relations with your company. Consequently, if no other contrary decision is taken within the notification period mentioned, you are requested to proceed with the closure processes of mining operations. It's quite clear, isn't it, that what he is regarding as at an end is your relationships with regard to the concessions and the mining. Nothing to do with the military or anything else, is it?
But that's not the way we read it.
That's what the letter says.
And that's why we asked our colleagues in the military how we should handle it, and they advised us to raise it as part of this letter that we prepared at that time.
And this is a complete distortion, isn't it, that you're putting forward to the police of what has happened in Minister Evode's letter?
No, it's not. It's the truth.
And then if we, it's a long letter, I can't pick up all of it. Can we go to the fourth page of the letter? And I'm going to go to item G.
I'm sorry, in the same document?
Yes, yes. So it's the same. I'm sorry, we're back in, I apologize. We're back in C165.
Thank you.
Fourth page, item G at the bottom. You say, there are many instances where Minister Evode indirectly threatened NRD and management and owners. Amongst these, on or about August the 14th, he told NRD business partner David Ben-Susan he will nationalize NRD as a help to MSA. And then you go on and say, according to Mr. Ben-Susan, Minister Evode separately told him he will stop NRD from having income, bankrupt them, and take the mining licenses. And Mr. Ben-Susan was shocked. Now, none of that is true, is it?
Absolutely true.
We have Mr. Ben-Susan's evidence on it, and he gives evidence. Can we go to paragraph 8 of Mr. Ben-Susan's witness statement? He says, I've been shown a copy of Mr. Marshall's letter to the CID dated 30th October 2014, and then he quotes the bit I've just read out. And then he says at paragraph 9, these statements are false. Mr. Eminer did not ever make these comments to me, and I certainly never told Mr. Marshall that he did. And then if you go on paragraph 10, further, the suggestion that Mr. Eminer would have made such statements to me is completely implausible. I met Minister Eminer on numerous occasions through my position at MSA and always found him to be highly professional. It's simply not credible that he would have made such statements to me about any mining company, including NRD. And the truth is, you've invented this allegation for the purposes of this letter, haven't you?
Absolutely not. And what you're saying is slanderous. David is not mistaken. He's lying here. David had the biggest concession comptoir in Rwanda. He was partners with General James Kabarebe, who was the then Minister of Defense. I met with him on some occasions. Every weekend they were meeting to talk about bringing minerals in from Congo. They wanted our mining concessions. He made repeated proposals to me of various kinds. None of them were so that we could get out. I was terribly worried if we merged with his company, he would squeeze us out and might not be able to pay any of the investors back. His effort to use Evode, I would be guessing at, but I know that he would tell me things when we were good friends. We found him to be duplicitous after several years. It took a long time before we understood it. We found that his business with General Kabarebe and moving minerals and pretending they're of a Rwandan origin was something we could never be part of anyway. But for us,
so just pausing there, this is yet another person. It is in a very long list, Mr. Marshall, who says something you disagree with, and you immediately launch into accusations of criminality. Yes?
No, we and several other investors in the Rwanda mining community went to his parent company, Cronimet, a German company owned by the Pilarski family. We all shared information on the duplicitousness, and he would do things like he would change the internal computer in the nighttime so that he would get a different reading and therefore didn't have to pay the miners the full amount due to them.
Mr. Marshall,
They
you're
fired
simply digressing into a series of allegations you've never made before, which are not true and are simply illustrating your propensity to slur anyone who you disagree with.
They fired him. They closed the business. They left the country. He
Let's
was
go on in the letter.
exporter, the biggest exporter at over $150 million a year, and they closed the company because of his corruption.
Let's go on in the letter to item 3. Minister Evode has also apparently conspired with others to harass and intimidate NRD management and investors. And you are suggesting in these paragraphs that Minister Evode has conspired, criminally conspired, with Ben Benzingi. And that's the representation you are making to the police, isn't it?
I believe that there was a criminal conspiracy to harm NRD when Ben Benzingi had no valid claim to owning 100% of the company. And yet he was treated like 100% owner of the company.
You had no justification at all, did you, for the allegations of the police that Mr Eminer had criminally conspired with Mr Benzingi?
That was the only explanation I could see for what was happening to us.
Mr Eminer, as he explained to you, was faced with a claim from Mr Benzingi. Yes?
But the claim was that he be recognized as a 0.2% shareholder, not that he be given ownership of 100% of the company.
Mr Eminer was faced with a claim from Mr Benzingi that he was entitled to represent the company and you were not, and that claim accorded with the Supreme Court judgment that Mr Benzingi had, correct?
No, you're misreading it. The arbitrator said that Ben Benzingi shall be appointed the managing director. We went to the commercial registry, and the commercial registrar legal counsel gave us advice. Fine, they can affect that for the 20 seconds of that day, and then the owners of the company will remove him.
No, I'm not accepting the evidence that you just gave, but leaving all that aside, Mr Eminer, from his perspective, was faced with a claim from Mr Benzingi, who was holding a Supreme Court judgment that validated his claim. And you knew that when you wrote this letter.
Nobody interpreted the judgment to read that way. The arbitration judgment in operable language said, I don't understand what Mr. Marshall is doing here. Not, he's not the owner. She said, I don't know what he's doing here. Very different concept. And Mr. Evode, in his wisdom, decided that meant that Ben was the owner of the entire company. That's the basis of their claim.
He did not. He never said to you that he had decided that Ben was the owner of the company. He was facing a claim, and he regarded there as being management issues that need to be resolved before he would issue tags. No. And you had no basis whatsoever, did you, for your allegation of criminal conspiracy?
No, you're being mean-spirited. Other concession holders had internal disputes too. Ours was the only one where the minister took a side in it and dispossessed us from both our offices and our concessions. Those decisions cannot be made without his authority.
Now let's look at little c in this, down at the bottom of the page. Minister Evode has refused to give control tags to NRD because, according to him, the ownership of NRD is in what he says is a dispute. He has not provided any evidence of that so-called dispute other than by repeating Benzingi's unsubstantiated allegations. Now, what you describe as the unsubstantiated allegations are in fact an award from an arbitrator backed by judgment from the Supreme Court, correct?
That's not what the award says, which is where you're misreading this.
And this is a distortion of the position which you are giving to the police, isn't it?
No, the reason they gave it back to us in August 22nd was because they said, yes, you are the owner.
And let's go to item 4.
It was only Minister Evode who was claiming, along with Bailiff Bosco, that Ben was the owner.
Let's go to item 4. in addition to the evident malfeasance by Minister Evode, other state officials have apparently targeted us and are victimizing NRD. It would appear that Minister Evode's harassment of NRD and its management and investors has emboldened others to attack NRD and its assets. Most prominent amongst these is State Court Bailiff John Bosco Nsuguma, who has committed several crimes against NRD, but who is apparently protected by the police and other state authorities. Now, you then go on and say, last Friday, we were informed by the Metropolitan Police Authorities that the court bailiff, Jean Bosco, has announced to them he will begin auctioning more NRD assets to collect approximately 82,000 in alleged court judgments. And yet these are the same court judgments which he has already fully executed upon and satisfied. Now, this was a point. It was not true, was it, to say that Mr. Bosco was enforcing on judgments which were fully satisfied?
Yes, it is.
This was a point which was taken up in a meeting, wasn't it, by the police and Mr. Bosco and Ms. Moskovikova, and she declined to provide any substantiation for this assertion.
No, I'm sorry, you've got it backwards. It's the bailiff that has to be able to substantiate what the claim is.
No.
We never got a document from the bailiff showing what the orders were or on what basis he could make the claim.
Mr. Marshall,
Never.
you have it the wrong way around. The bailiff had valid claims. You'd complained to the Minister of Justice, who told you to pay up on the valid claims. Your next line of defence, which was raised at a meeting with the police attending, was that somehow these claims had already been paid off. And you were asked to provide substantiation for that, and you did not do so. And that's the correct position, isn't
You
it?
can ask Susanna. I think some of the names were recognized. We never got orders from the court to say what those claims were. Never. I'm repeating myself 100 times, and I apologize for it, but you're missing the point. We don't know what those claims were. We
This
recognized
letter-
some of the names, and we sat down with some of the people, not me, but Susanna, and please ask her. We don't know.
This letter of yours contains a series of extreme and unsubstantiated criminal allegations against Mr. Eminer, doesn't it?
No, these are all factual.
And do you consider this the kind of behaviour for a realistic professional applicant for a long-term mining license?
No, we are being dispossessed of everything. They're taking it from us. They've stripped NEMBA for $800,000 worth of property without legal process, with a so-called legal process, but which was not a valid legal process. There was never an accounting. Nobody ever was coming to us to explain where the equipment or minerals went that were stolen, or the damages that were done, or how we were going to be compensated. It was if we stopped existing.
Now, we, on the respondent side, we don't accept for a moment you have any valid claims at all. But if you did consider you had claims to have been expropriated or harshly treated in contradiction to the treaty, it's quite clear from this letter that that was all apparent to you at that point. Yes? You're complaining vociferously about what you describe as your mistreatment. So the claims that you had now pursue in this arbitration were all apparent to you at this point, weren't they?
Are all apparent?
Were apparent to you at this point. You were aware of the points that you now advance as claims in this arbitration. We can see it from a letter because you're...
I'm sorry, please ask the question a different way.
You were aware, yes, you were aware of the matters that you now complain about in this arbitration because you're complaining about them in this letter. So you're already fully aware of this proposition that you've been expropriated by virtue of being declined licenses. You're aware of the suggestion you've been expropriated by or harshly treated by reference to Mr. Benzingi's actions and Mr. Bosco's actions. It's all there in this letter, isn't it?
No, I disagree. You know, we wanted to be able to do the right thing. We had a great relationship with the Rwanda military. They were very enthusiastic and conveyed to us how much they valued our services. They, in the Rwanda cultural hierarchy, are far higher than anything to do with the ministry or whatever petty corruption was going on there. They were instructing me to wait and be patient. I was addressing here concrete examples of crimes which had been committed against us and our disappointment that the police had not taken action in what was clearly theft, no more.
Now let's go to C086.
Under the color of law, but theft.
Let's go to C086. This is your next letter to Mr Eminer, which contains your appeal and reapplication for a license. And just underneath the italicized part, go underneath that, please, FTI. After giving us only 2 days to prepare a so-called application, we expected inquiries from your office as well as additional communications and not a termination letter. We take the opportunity of 7 days to lodge this appeal against your decision. Now, it's not true, is it, to say you were only given 2 days, you were given 30 days to make this application?
Yeah, well, you're sort of right. The letter came, but it was a form letter that we understood was being sent to everybody. We had assumed that it was not applicable to us because our offices were closed and that as was our concession. So we were already out of business. We assumed that this letter was a mass mailing and not specifically addressed to us. But we did take the step of setting up a meeting with Minister Baruta, who just had taken on his functions roughly a week before. And this was the first day that we could speak with him. Evode was not willing to speak to us at this time. We got that meeting 2 days because of his availability, 2 days before it was due. But you're right, the mass mailing came out 30 days before the 18th.
Go to the next page. You've got, you talk about another company being given 2 years, but by this point you hadn't had a license, had you, since October 2012. So you've been out of license for more than 2 years, correct?
They were in exactly the same position. They had been out of license for 2 years as well. This is Rwanda I'm referring to.
You had been out of license for 2 years since your license had expired in October 2012.
And they,
Yes.
they would have been the same.
And you had not made any application at all in that license period until this license application, correct?
This is a new argument that started much later. When we submitted the application, it was by far the best. We saw the other applications. We knew
Well,
it was
that's just not right, is it? We'll come on to Rwanda a little later, but the reality is that Rwanda are in a completely different position in that they had a well-advanced license application which had already been favourably received by the government, entirely different from you, who had no license application on foot until you launched this one in the autumn of 2014.
You're being casual about your terms. Their licenses, if by your standard, expired the same time ours did. I don't agree that they expired at all, but the 4-year period ended about the same time that ours did. They had 2 side-by-side applications, Rwanda and Tinko. ETI, sorry, Tinko's the
Don't worry, Mr. Walsh, we're going to come to it because we have evidence from Mr. Eminer explaining what happened with Rwanda. So I can show you exactly what happened.
Mr. President, I would ask, the question was put to him to challenging him to say to disagree with Rwanda was in a much better situation. Now, when he tried to answer that, cutting him off as if that's not responsive and moving on is not fair. I would suggest the path forward is either to withdraw the question he asked or to let him answer the question he asked, but not to just say he's done answering it and move on.
Well, I don't mind if Mr. Marshall wants to continue the answer now, but we are coming back to this topic later.
Well,
So I hope he doesn't repeat it later.
You made the point that somehow you think Rwanda or ETI, which is Nyakabingo, were somehow in a different position. They were in exactly the same position we were. Both of them were under long-term negotiation at this point. They've been talking about them for 2 years, but the terms of those licenses were essentially identical to ours. There were 4-year agreements. They had that 4-year period. And I'm not agreeing that it's a termination, but that 4-year period had ended 2 years before. They were being treated as a negotiation partner. The negotiations were ongoing, and we had no chance to negotiate our agreement, much less the two agreements that they were negotiating side by side.
Rwanda had 20 times your production levels, didn't they?
I don't know that.
Well, it's a document from you that confirms exactly that. Do you want me to show it to you?
Yes, please.
Go to R-107. R-107.
What am I looking for?
Give me 1 moment. Yeah, I'll come back to that question. So I'd said I'd deal with Rwanda later, and I will.
Yep.
Now let's go back to the letter we were on. So we're in C86, second page. And under prior negotiations, you say, note, NRD submitted the application for a long-term mining license in 2010 and had to wait 4 years for this so-called opportunity to reapply. Now, that is simply not correct, is it? Because you had been invited specifically to reapply, and you could have reapplied at any point prior to now.
No, those forms were not created until that time when they requested the information. There was no process before this. I think you're mistaken. You need to go back and talk to your client. I'm certain about that.
Well, Mr. Marshall, the difficulty of that is you did make an application, a very defective one, in January 2013, didn't you?
Whatever application process we adhered to was at their instruction.
You knew you could reapply.
You started this question by saying we did not do something which we ought to have done. And my point to you is we were following all instructions at all times.
You knew you could reapply because you had an attempt at reapplying in January 2013, which was the 9-page that we looked at, correct?
No, we follow the instructions of the ministry. If the ministry calls up and says, we need an application which says XYZ, that's what we put together. It's not a question of our taking the initiative or not. That's not the way the system works. They come to us and say, this is what we need to do now.
And you had been specifically asked to reapply by Mr Eminer at the end of in late 2013, and you hadn't done so, correct?
I don't know what you're talking about.
Well, we looked at the meeting minute of the meeting in which he asked you to reapply.
But I think I specifically told you that that meeting did not cover that topic.
So
100%, I'm quite certain he did not ask us to reapply at that meeting.
it is entirely wrong to say you have had to wait 4 years.
You're creating an assumption based on something that I disagreed with before.
It's entirely wrong, isn't it, to say you've had to wait 4 years for an opportunity to reapply for licenses?
We had applied in 2010. We were waiting for the negotiation, which was ongoing for Rotungo. Why was Rotungo given the opportunity to negotiate the long-term agreement? And instead, we have to so-called reapply. Why did Rotungo have to reapply, or Nyakabingo, or any of the others?
Let's go to the next page.
We were treated like we just arrived and they didn't know anything about it, and it was very unfair.
Let's go to the next page,
It
first
was unfair
bullet.
because it was an excuse to be able to set us up for taking our assets. That's the bottom line here. It's not like neutral, okay, you can't invest here, fine, you can go home. No, we've already invested and they're trying to take it. And it was very upsetting.
Well, that's the point we're about to come to. Top of this page, this bullet, our investors invested over 20 million of new invested money, not reinvested from operational cash flows. Now, that is a representation, but there's been 20 million of new invested money. And that is simply incorrect, isn't it?
Well, you know, I think you need to, as you said, you are going to bifurcate this process, and then you'll know that.
We already have looked at that 20
You keep
million.
announcing that it's untrue. I haven't conceded that point.
That 20 million figure is the figure in dollar conversion that we've already looked at.
No, it is not.
The lion's share of that.
Already agreed. We contributed from NRD. I mean, Bayview Group to NRD. We already had the investment, which is made by HC Stark, and we intend to be able to show you that that is the money. But
No,
you
the lion's share, just to my question.
Process and bifurcated from this.
If you listen to my question, the lion's share of that money, as we saw earlier in this cross-examination, came in from HC Stark. And even that money, there's no basis for saying it's new invested money as opposed to reinvestment from operational cash flows. Correct? We talked about that earlier.
No, I without going through that research, I can't tell you that.
And then the other smaller portion of the 20 million is the estimated 6 million euros that you put in square brackets as foreign consultants and engineering fees. And you got and 2 points about that. First, that money was not invested at all. Secondly, it certainly wasn't invested as net new money, was it?
Well, I appreciate that you are raising issues for the government of Rwanda. The government of Rwanda came, they saw our books, they saw our investments, and they never objected. And I wish you would give us the chance to be able to go through those amounts and be able to demonstrate what that number was. But I understand it's a bifurcated process, so we can do it then or whatever you suggest. But for me, this is a question of being able to show that information, not reach it on a conclusory basis.
You've made in your correspondence along the way a number of allegations about 20 million of investment. Not until this point did you ever suggest that this was 20 million of new invested money, not reinvested from operational cash flows. Correct?
No, I can't tell you the answer to that information without going through that exercise.
That is an invention, isn't it, on your part?
No, it's not an invention. Is there a mistake? I doubt it, but you have to be able to let us go through that process.
Now let's look at, can someone pull up your skeleton argument?
Reaching conclusions and then accuse me of being a liar, and that's just slanderous.
Well, let's have a look at your own side's pre-hearing brief for this arbitration at paragraph 9. What's said in this paragraph in the second half, after explaining about investments, most of this investment came from retained earnings. So your own position is that such investment as you did provide mostly came from retained earnings, yeah. Correct?
I can't comment on it without going through the exercise. I don't know.
And what was put in this letter in response to Mr Eminer was simply untrue, wasn't it?
No, and it's slanderous for you to say it's untrue. There was significant investment. What that number was, I can't precise, and we won't be able to precise until we go through that exercise.
And just staying with this letter, can we look at the next paragraph? So we're back in the letter.
If I may draw an example for you, I don't know of one other company other than Rotungo who invested $1, any money. Maybe Musha Piran maybe has invested $1 million or $2 million. I don't know it, but I don't know any other mining company who's invested at all at this point. All those that have invested for their own reasons have left.
So FTI, we're on C086. And I'm going to the next paragraph. So I was just looking at, yeah, sorry, we're on the next, no, sorry, that's right. Underneath that, Sorry, excuse me 1 moment. Yes, can you go to the next page, please? This was the paragraph we were on. Thank you. You then say, and last but not least, we have existing agreements beginning in 2006, later amended and added to, which created the base for our large investment and for the future long-term mining license. We fully performed under these contracts, have a right to a long-term mining license. You make no mention of these agreements except to announce they are terminated. Your termination is, of course, a breach of those agreements in violation of the bilateral investment treaty. And you regarded at that stage Rwanda's actions as being a breach of the bilateral agreement treaty, did you?
I'm making an argument, for me, for them to say that you now have to go home and you have to leave your assets behind, that has a practical monetary result for us. So, if that's what they were going to do, and that's what I was afraid they were going to do, I wanted to alert them that there would be other people looking at this, and hopefully somebody would review it and at least encourage them to behave properly.
That was on 1st of November. You wrote another letter on the 5th of November, which we have at C171 to Minister Baruta. Let's look at that. And you say in the first paragraph, you've been victimized by the acts of Minister of State Mr Eminer, and we ask you to intervene.
Yep.
And then 2 paragraphs down, you say you've been Minister of State for Mining Evode has maliciously targeted NRD.
Yes.
And in the next line, you refer to abuse of powers.
Yes.
And then you have in this letter a list of accusations against Mr Eminer.
Yes.
And if we look at item 2, for instance, you say we have repeated. Sorry, I've lost it. Item 2, NRB has been out of business since that time. We have repeatedly asked Minister Evode to allow NRD to resume business, but Minister Evode has refused, arguing there is a dispute about the ownership of NRD. Please note that the so-called dispute is only recognised by Minister Evode himself, and again, as in other letters, ignoring the fact that Mr Benzingi was confronting Mr Eminer with an arbitration award and a Supreme Court judgment, correct?
Yes, but you're again assuming what that judgment says. You're not going into the detail of whether that judgment means anything. For the arbitrator to say, I don't know what Rod Marshall is doing here, and to be interpreted by Benzingi and only Minister Evode as meaning Rod Marshall is no longer a shareholder, but Benzingi is the sole remaining shareholder, is not a fair reading of that judgment. And for me, I fully agree that these are very emotional terms, but we were facing losing everything. And I was very emotional, but my point being that there's no way you could read that arbitration decision and say Rod Marshall and his investors are not the owners, is Ben Benzingi.
Let's look at item 8.
But sorry, it also begs the question of why he stopped us from tagging if there was an investment dispute. The tagging goes to the business, not to the individuals. Why would he stop the company being tagged if it was a person-to-person or group-to-group dispute? It made no sense to us. That's why
it does make sense, because you have different people claiming to be in control of the company. Now let's go to item 8. Minister Evode.
You're misunderstanding the ITRI rules. The ITRI rules are that tags are issued to companies. Companies function. If there's an internal dispute within the company, that's not an ITRI issue.
Let's go to item 8.
No ITRI participant was ever canceled for that reason, other than us.
Let's go to item 8. Minister Evode demanded a reapplication from us for all of the NRD mining areas and maliciously violated normal Rwandan administrative procedures. Minister Evode refuses to acknowledge that agreements exist between the government of Rwanda and NRD dating back to 2006. Do you see that?
Yes.
Now, that agreement was no longer extant and you had not met your obligations under it.
It was
correct?
fully executory, correct?
No,
We had
that
fully
agreement was
performed.
defunct because
We
you had failed to meet your obligations under it.
We had fully performed and we were waiting for the negotiation for the language of the commercially reasonable long-term license.
Item B in your complaint to the Minister Baruta, Minister Evode insisted that we reapply for the mining licenses on 2 days' notice. That's simply incorrect, isn't it? He gave you 30 days' notice to apply.
We assumed that it did not apply to us for all the reasons I've already given you. We had 2 days in which to reply when we were told that, yes, you have to reply, despite the fact that you don't have access to your files or your business.
This is what you are putting forward to another minister incorrectly as evidence of corruption on the part of Minister Evode, correct?
No, I think it's absolutely correct. Minister Evode would not meet with us, period.
Could you look at now C098?
Until that 2 days before it.
Let's look at C098. This is the response from Minister Baruta. Reference is made to your letter of 5th November 2014 requesting for urgent help in connection with your company being victimized and seeking for my intervention. Recalling different open dialogues the ministry had with you where you raised issues concerning your company of reapplication process for the expired mining license, the ministry advised that you don't personalize issues, but rather comply with the mining law requirements. Therefore, the ministry takes this opportunity to clarify that one, Minister of State Evode Eminer made decisions on behalf of the ministry and in his capacity as state representative in charge of mining industry developments in Rwanda. 2, the services you requested cannot be accessed without a valid mining license. 3, you have gone beyond your boundaries to raise serious baseless allegations against the Minister of State, and this is unacceptable. In this case, you are hereby requested to respect the government of Rwandan institutions and comply with the mining laws as other operators in the mining sector do. Once again, your company is requested to comply with the mining laws and regulations and go ahead to submit the documents required for mining license reapplication process, being mindful of a specified timeframe. And that is an entirely fair response, isn't it?
No, it's entirely unfair and ignoring all the issues that we were presenting to him.
Now can you go to bundle C087? This is a letter to you on 12th of November 2014 from the ministry in response to your letter to them that we've looked at. And I'm going to read the second paragraph. As stated in your letters, I'd like to clarify that the terms of the above mentioned contract did not give NRD the right to obtain an automatic and exclusive right for long-term mining licenses. However, as specified in Article 4 and 5 of the contract, granting of mining licenses subject to a positive evaluation of a submitted feasibility study and fulfillment of obligations under the Article 2 of the contract. So they were reminding you correctly that there was no automatic right to long-term licenses. Yes?
What's the date of this? You were too quick for me. When you scrolled up?
I just read the second paragraph.
I understand. November 12, 14. And who's it from?
This is from the Ministry of Natural Resources to you.
I understand, but who particularly? Is this from Minister Eminer?
This is from Eminer, yes. So the first point he's making is that contrary to the suggestion in your letter,
we disagreed. It's clear.
Now, next point is that if we go over the page, and in fact, if FTI could get up that second page and also the third page of the document, the next page of the document, you can see that the ministry gave you a list of the missing documents and gave you an express opportunity to improve your application. Yes?
Yes.
So
but
again,
we didn't see it as a question of improving an application when we were being treated differently from everybody else.
Again, fair.
Why the process continued.
Fair and transparent and more than they were required to do.
Not fair, not transparent. We were being treated distinctly differently from all other concession holders.
Now,
We
let's
were
go.
the only ones being asked to provide this additional detail as if they had never met us before.
Let's look at the letter you wrote 2 days later in response to this. This is R214. This is a letter you're now writing to the president of Rwanda.
Yeah, I
And in
don't
this-
think this letter was sent. This was contemporaneous, but I don't think this letter was sent.
Well, it may not be, it's not signed. This, you're suggesting this one was not sent.
It's the kind of thing that I would have written. It was contemporaneous, I'm sure. I do remember writing it, but we were very reluctant on what to write to the minister, so I don't know that I sent this letter. We don't have any document particularly with the president's office. We certainly would have gotten a stamp, and that makes me think I was just blowing off steam on this one.
Right. Well, in that case, I won't take time on it. Let's go to C88. This is your letter providing further information to Mr Eminer.
Yep.
And we've been told at paragraph 88 what the totality of the package of information you provided to Mr Eminer was. So we've already looked at C85, which was the 2014 feasibility study update. We've looked at C92, which was your Gilson and Marshall transaction document. And in addition to that, there was a company corporate social responsibility plan, a CSI plan, and there was an environmental impact study. Now, that was the material that you provided by way of totality by this stage, and that's clear from your own side's memorial. Now, I'm now going to ask you to go to C95, C095, which is the letter from Mr Eminer in December 2014, following a further review of the material. And he tells you that the material is still insufficient. And if we look at the second paragraph, he says, based on the documents you submitted and on explanations you gave, and considering the requirements of the law, we would like to inform you of important information and documents which are either lacking or for which you did not submit complete information, and yet they are the minimum requirement for any further step. And then he says the missing documents are into two categories: proof of your company's capacity to develop the concessions, to detailed plans for the period of a license being applied for. And then he goes on and asks you to provide, in the nature and form mentioned, the following, and he gives a list of what is missing. And if we look, if it can scroll down, clear evidence of NRD Rwanda's financial viability from supporting banks or any other reputable financial institutions, financial statements of NRD Rwanda Limited and financial statements of NRD's parent companies or financial statements of the companies owning NRD's parent company, any tangible documented proof showing the current financial viability of either NRD's parent company or the parent of its parent company, a tax clearance certificate issued by Rwanda Revenue Authority. You're also requested to provide separately for each concession the following detailed proposals with clear time frame for work plans and business plans for the period of a license being applied for. The planned and activities and investments needed shall be detailed enough. Can we scroll down, please, FDI? It's also important to note that not only will be considered valid the proof of financial statements of viability of NRD lands, its parents, and the parent companies from companies duly recognised as certificate of the company registered by RDB. All the companies mentioned above should be submitted not later than January the 16th. Please be also informed it is of concern, and it doesn't help at all, to say that Rutsiro plant is operational when it's the most successful design of its kind in Rwanda, and when it's designed to serve all NRD's Western concessions, when it's known and obvious that the plant barely worked in the several years it has been in place. So all of this is a fair and transparent approach, isn't it?
No, I would say it's slanderous, manipulative. If they had given us our office back, they knew we couldn't respond to many of these questions, and we didn't even understand the point of it.
He's identified.
Why were we singled out for this kind of treatment, and why were we double? Why did they double down? Why not just give us our office back? and then see what we can
He's
produce.
identified genuine gaps in the material you've provided and given you
He's
an
not answering
opportunity
the
to remedy
point,
it,
though.
hasn't he?
No. Nothing. You take away our office, you say, look, if you happen to have it at your home and can use the material that you have at your home, then you can apply. Otherwise, I'm sorry, too bad. You don't deserve to have your office back and be able to supply a meaningful application, much less the fact that nobody else among the concession holders had to provide these kinds of materials. Nobody.
You
not
didn't
one.
need your office to be able to give financial information of
Surely.
the backers of and the parents and the pet of NRD, did you?
Yes, we do.
No, you don't, Mr. Marshall.
How can
Because it's
how can
you and your
possibly presume to know what's in our office or not?
Because it's you and your investors that you're being asked to provide financial information in respect of. That's the request. And you didn't need your office to do that.
I'm sorry, but we understood the fix to be in, and we understood that it was sort of pro forma. Yes, we'll provide you the documentations that we have access to. Tax office, as you say, the environmental office, they're not going to provide us with anything. We knew that you were setting us up for failure.
This
We
is
knew.
not. This is an opportunity Mr. Eminer didn't even need to give, and he's giving you a third chance at this
Yes,
point
yes,
and
yes.
identifying the missing material, isn't he?
You tell me. I don't know what Mr. Eminer by rule or practice or law had to do or not do. All I know is we were unfairly prevented from getting access to any of our documentation for reasons I still don't know to this day. And then yet unceremoniously, 4 months after you say we lose everything, you give us our office back. What was the point of that?
Let's see the response, your response at C096 on 16th of January, 2015.
I can well imagine they become increasingly intemperate.
So you say item 1, company's financial viability. As per our previous correspondence, we mentioned to you in a recent past, although out of mine lines, we were able to raise $2 million US with participation from the Dutch government. We've also firm funding commitments from other internationally recognized entities. And all this is as a result of our impeccable investment reputation and track record. Now, if you had genuinely had firm funding commitments from internationally recognized entities, you could have actually provided evidence of that, and rather than just asserted it in your letter, couldn't you? Yes?
No, I mean, there's no reason for us to do this. For us, did we believe that we could raise funds to increasingly build it out? Yes, but we had to have the long-term concession.
You didn't have firm funding commitments from other internationally recognized entities, did you?
Yeah, I'm sure we did. I wouldn't have written it if we hadn't.
Well, you wrote, it was untrue when you wrote it, wasn't it?
No, and it's slanderous for you to say so.
And if you had had firm funding commitments, you would have been able to identify them and produce them in support of this application, wouldn't you?
I'm sorry, but you're suggesting that we would share everything we knew with the minister. At this point, we could see what was happening.
And this has nothing to do with what is or is not in your Kigali office. Because if you'd had firm funding commitments from internationally recognized entities, there'd have been no impediment from the Kigali
What
office.
makes you think that would have made the slightest bit of difference at this point? We've been set up. We understand that. We just don't know what the next step is going to be.
You then said in the next paragraph, in addition, we submitted to you our list of successful investment transactions of over 40 billion US dollars. These investors would gladly bear testimony of our trustworthiness. Now that is a reference to the list of transactions to which your legal firm gave transactional legal advice, yes?
Yes.
So that you were, as I put to you earlier, relying on that as evidence of the company's financial viability.
This goes to trustworthiness, not to whether they were going to provide cash for it. I don't know on what basis or what the thinking was at the time. Is it responsive? No, it goes to our trustworthiness. Certainly more trustworthy than many of the people who are in the mining industry in Rwanda. And we thought that that would be helpful for the minister to understand who he was dealing with. Maybe I was mistaken. And if so, so be it.
Then if we go down, you
We're
have
trying to mislead anybody. This is a very difficult business.
We then go down and you have current financial viability. So you say be barred from the offices, but in fact, you were able to retrieve copies of NRD's financial statements. So there's in fact no difficulty in relation to NRD's financial statements. And then there's a reference to.
We had some, as I think I mentioned to you, we have the office computers and we have our home computers. And if by chance we happened to have documents on our home computers, yeah, we had access. That's the material we submitted.
But what this is all showing is that the important deficiencies in your application, which have been identified to you, none of the problems arose from documents being in the Kigali office. We've dealt with parent company, and now looking at current financial viability.
Couldn't disagree more. From our point of view, the financial viability question nobody has invested. Nobody. From our point of view, we were the sole standing investors who remained in the country, and that was proof. You didn't need additional proof. Did they come back to us and say, well, what we want to know is, okay, you've invested whatever disputed amount you want to say, you've invested this much, but now we need to know that you're going to be able to invest X more. Those conversations never happened. Couldn't get anybody to talk to at this point.
And the other point,
I believe a political decision had been made.
The other point that you make in the next paragraph is about Spalena. You say NRD's investors created the Spalena company. An LLC is a legal entity widely used in the United States where each investor is responsible for their own taxes worldwide. And beyond saying that, you're not providing any further information, are you?
Because we didn't need to. We fully satisfied it by the 20 million we'd already put in.
Let's look at the third item, which deals with tax clearance. As to the tax clearance from the Rwandan Revenue Authority, much as with other state institutions, Rwanda Revenue Authority no longer considers us to be in business. It's only once we are granted a mining license we will be able to apply for the tax clearance. That was simply untrue, wasn't it? The reason you didn't apply for a tax clearance is because you would have been unable to get one because you owed tax.
Now you're accusing us of lying. No, my assistant, Zuzana Marushkevicheva, our CFO, went to the tax office, and as I understand it, that's the explanation for why they would not give her a tax clearance. You can ask her directly, but I'm sure she's not lying. Yeah, I wish you could find a different phrase of "you were lying" because it's really distracting.
Could you go to bundle C179? This is an email from you we looked at earlier. It's the email we looked at some time ago to Mr. Ehlers dealing with the financial position. Can you just scroll down a bit, FTI? Stop that. And amongst the other points you make, you say, and this does not, you see in the bottom of the big paragraph, this does not contemplate the tax obligations identified by PwC for withholding on expats. And that was part of a tax issue, which had never been resolved by this point, correct?
No, it was partly resolved. The withholding on expats had been resolved. The only outstanding issue, as I understood it, was the company had incurred expenses for casuals. And by that, I mean, somebody would do a job at a mine site and they would give them 5,000 francs or something. So it was very much what they call casual labor, and Stark had not been properly documenting it. And I don't know if the problem was in the field or it was at the headquarters, but the complaint from the tax office was that we had not set aside Social Security contributions in respect of that one-time payment. And it was a large amount of one-time payments, but it was all accumulative of what they just called casual payments for casuals.
As a result of that, you would not have been able to get a tax clearance at that point in time, would you?
You know what? Susanna's answer is the correct one. We went there and they were told we're not a company and they don't recognize us, so we were not able to get one.
Well, I don't accept that, but leaving that aside, you would not be able to get a clean bill of health, would you? Because they regarded you as owing tax, correct?
No, it was under the agreement we had reached with them, and this was 2011, that they would come in and perform a true audit. They had done some kind of superficial audit with Anthony Ellers and not properly looked at the books. They agreed, and we were waiting for them.
Well,
So this is 4 years later, and we're still waiting for them.
Even on your version of events, they regarded you as owing tax, but they might have been prepared to recalculate the amount. Yes?
I don't know whether we owed anything. It could have been zero. In fact, our point was that they owed us because they held a $100,000 deposit from us.
Now let's go to R023.
Susanna had the direct, participated in the conversation with the tax office. So please ask her that question.
R023, this is the Mini Rayner team assessment of your further round of information. And we could just look at item 1 on assessment and comments. Item 1, clear evidence of NRD's financial viability. The company has provided no evidence at all as regards its financial viability supported by any bank or financial institution for its present and future mining operations. Indeed, among documents submitted, none had any information with supporting elements as regards the company's viability, financial viability. Rather, the company just submitted its previous financial investments and investment transactions which have no supporting evidence. And that's a fair summary, isn't it?
No, we had already satisfied the requirement by investing $20 million, and this was a exercise to be able to try to say, oh, it's not enough, or whatever the standard would be.
And then at item 2, they deal with MRD's financial statements of NRD's parent company or financial statements of companies owning NRD's parent company. And then they identify that partial financial statements have been provided for the company, but then they identify no material for anything above the company. And that's accurate as well, isn't it?
I'm sorry, tell me again.
Well, I'm going to move on because I've actually shown you the documents and I put it to you by reference to your application. Let's go to item 3.
I didn't understand the question.
Well, don't worry, I'm going to move on. Tangible documented proof showing the item 3, tangible documented proof showing the current financial viability of either the company's parent company or the parent of the parent company. No documents have been submitted in this respect. And it's fair to say, isn't it, that despite being given opportunity after opportunity, you had not met the requirements given to you by the ministry.
Please, I'm sorry. Again, I'm going to repeat myself. This is a question for a new investor who's just appeared. They don't know anything about him. Please give us some proof of something so that we know or have some idea. Not somebody who's been in the country for 8 years, invested $20 million or whatever you claim the disputed amount is. This is for a new person that they don't know anything about. So for them to say, oh, well, your 20 million doesn't count, so we need to see something else. We interpreted this to mean, no, we've proven our financial viability. If they're asking for additional financial viability, that would make us different from these guys, but that's not what's happening here.
Well, you knew what you were being asked because it was being specifically identified to you in the letters.
And this is a question for a first-time applicant that they don't know.
So you chose to ignore it because you regarded it as not being...
We believed it was fully satisfied. Somebody's invested 20 million bucks. You don't say that, oh, you have nothing, goodbye.
Let's look at item 5. Detailed work and business plans for each mining perimeters and clear time frame. There were no separate applications for each concession as per the requirement in the minister's letter, which would indicate the merits to consider when assessing the application for each concession. The technical report submitted was of a very general nature and did not present details on the work done in every concession. It is, however, necessary to note here that there was some useful information presented in the section called Nemba Project, which provided a general assessment of the resource, Cassiterite and coltan in the Nemba concession, and the possibility of putting up a processing plant. However, the information is insufficient as regards proper mine development for the Nemba mining perimeter, The company did not submit a detailed work and business plan for each of the mining concessions as requested in the minister's letter, and there is no mentioning of a time frame for operations for each mining concession. And that is a fair summary, isn't it, of the material you submitted?
I repeat my former points. We didn't have our office. We didn't have access to any of that information. This is for a new mining concession applicant, and this is a more detailed kind of assessment that you would have expected from him. They knew what we did. We met with them frequently prior to this so-called dispute period. And this was not really applicable, but if it was applicable, then they needed to give us our office so that we could respond.
Let's go to R024. This is Dr. Biryar Barema's review from February 2015. And if you go to page 2, you can see that he deals also with Rwanda Limited financial statements, and essentially he makes the same points as the previous reviewing team, but adds his own in relation to the financial statements. You can see at 221. So you can see he conducts an analysis of what you have provided. Yes.
I see his words, and he's certainly misgiven.
Can you go to section 2.5 in his report?
You know, again, you can see by the tone, by the veiled accusations that it appears they don't want us there. Not how do we help this company to follow the usual administrative process of let's sit down and figure out what we need and what they need and come up with a solution.
That's not fair at all, is it, Mr. Marshall? We just looked at the evaluating team's assessment of your work and business plan, and they made a fair point, but in relation to the Nemba concession, there was some useful material. So where there is useful material, they're free, they do say so.
No, I disagree with you, because they're giving credence to one small application in one small respect. They knew about our company. Some of them had spent many hours with us, and that's the usual, as I say, collegial process that everybody goes through until now. It's not only a new process which gets applied to us as a holder and not to anybody else, but it's a whole different process where a list is given. Oh, you didn't answer it the way we wanted or what we were expected. So sorry, you're insufficient and therefore not worthy of a license here. Goodbye.
Then you have paragraph 2.
About extracting our mining assets from us and not compensating for it.
Then you have paragraph 2.5 from Mr. Biryar Barema's review. And he starts off by essentially saying the same thing as his previous reviewing team, but he adds to it. You can see in the middle of the paragraph, however, the information is insufficient as regards the development of proper mine for that concession. There are no substantive technical reports either submitted in the past or in the recent submitted documents that show advanced exploration work done in any of the 5 concessions. The reports on exploration works in Rutsiro and Nemba submitted in the past, and the Nemba project provided in the current documents are all of a reconnaissance nature. There's never been any exploration report, past and recent, on Mara, Gikia, or Sabea concessions. And that's all a fair summary, isn't it?
No, of course not. Slanderous. And it begs the question, if they're so confident about our lack of having performed in any respect, why didn't they give us the office back?
And if you go to his recommendations,
or perhaps they knew that there was nothing left in the office.
Due to his recommendations, he says there is no basis for Minirena to grant a mining license to NRD Rwanda for the 5 concessions. Technically, NRD Limited did not apply for any concession. It was clearly stated in the minister's letter that each concession should be applied for as an entity. Secondly, the documents submitted were insufficient and not specific to any concession. The company has not shown any financial or technical viability, and is therefore not qualified to such a large and potential area. If it had been cooperative, negotiations for one concession, say Nemba, would be viable and reasonable. The company has publicly on several occasions stated it has so far invested $20 million in the concessions. A look at the list of expenditures include huge payables without documentation, like a foreign consultation fee of about 5 billion Rwandan francs. There might be a need to request the Auditor General's office to audit the finances of the company to stop it from making unsubstantiated claims. And that is all a fair summary of the position, isn't it?
No, I would suggest that they had retained British counsel to come up with these arguments and this language, because this is not the way they write, and until this time, not the way they've ever communicated with us, and certainly not the words they ever would have used with us. This is very confrontational, very litigation focused, and very distilled, entirely unlike their usual writing style. Perhaps you gave him some help in preparing this, but this is not what we've ever seen, and not what that I believe is their own work.
You know fully well, Mr. Marshall, that this is an entirely fair and objective review of the deficiencies of your application, which we've seen by looking at the application ourselves. Correct?
No, absolutely not. I would say that this is a well-prepared and well-documented effort to be able to substantiate a decision they've already made.
And you're aware, aren't you, that Mr. Iminer's further refusal of your application in May came after further consideration of the material, both by the reviewing team and by Dr. Birabarema, and a negative recommendation. Yes?
If you tell me that's the case, these documents I've not seen until this litigation. Everything.
Can you go to...
All of this is new, and that's highly unusual in a country like Rwanda, where everything is done on a consultative basis.
Can you go to R-079? This is a statement of seizure of a car done by Mr. Bosco. And you can see it's done at the request of the Rwanda Revenue Authority. Do you see that? Second line.
I had understood that the process from the Rwanda Revenue Authority is if they have some claim against you, they give you notice. So, until this process, I was never aware that that was even possible. You
knew, didn't you, that you had unpaid debts to the revenue, and indeed they were seizing your assets? Yes?
Definitely not. 100%, not 99%, 100%. We had been told that all our accounts had been frozen until such time as a determination was made about who was the owner. That's why we also couldn't get a tax certificate.
And as I said earlier, the reason you couldn't get the tax certificate is because you had unpaid debts. And this is just another example of how that's so.
I put it to you that in fact, what you've been doing all day long is trying to say what I say is the truth and you say is a lie. And it's simply unreasonable. It's in fact slanderous.
Let's go to another document. We're going to go to the RDB minute at C101.
Well, certainly there was never any notice to us. If there was ever a notice from the RRA to anybody, it didn't come to us.
Mr.
Hill.
Yes.
It's 7:30.
Exactly, Mr. President. I haven't finished, as you can see. I know this is obviously eating into my time with other witnesses. I think I will be less than an hour. I hope considerably less than an hour, but less than an hour with Mr. Marshall tomorrow morning. And I know it's on my head and that we've got a chess clock and it takes away my time with other witnesses. I'm close, but not. I had hoped to finish today, but I haven't managed to.
Very well, we'll adjourn until midday tomorrow.
Thank you.
Thank you.
All right. All right, everyone, we're going to go ahead and shut down. Everyone have a good night.